ಏನ್ರಿ ಇದು ಲೈವ್ ಇದೆ ಸರ್, ಏನ್ ಮಾಡ್ತಾ ಇದೀರಿ ಅವಾಗಿಂದ? ಈಗ ಆಯ್ತಾ ಹೋಗ್ಲಿ, ಅದೆಲ್ಲ ಬೆಳಗ್ಗೆ ಕೋರ್ಟ್ ಕಮೆಂಟ್ಸ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ ಬಂದ್ ಮಾಡ್ಬೇಕು. ನಿಮ್ಗಳಿಗೆ ಯಾವಾಗ ಬೆಳಕರಿಯೋದಿಲ್ಲ, 10:30 ಬರೋದು ಆಫೀಸ್ಗೆ. ಈಗ ಬಂದ್ ಕೋರ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆದ್ಮೇಲೆ ಮಾಡ್ತಾ ಕೂತ್ಕೊಳ್ಳೋದು. ಇದು ಕೋರ್ಟ್ ಅಲ್ಲಿ 9 ಪ್ರಾಬ್ಲಮ್. You should attend before 10:30. It should be ready by 10:30, not by after 10:30. Memo by the appellant ಏನ್ರಿ ಇದು? ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ? ನೋಡಿ, the appellant counsel has filed memo stating that suit has been settled between the parties and this appeal doesn't survive for consideration and hence permitted to withdraw in terms of the memo. Maintain laboratory appeal as per value stated in appeal memo in so and so so and so. Yes, madam. ಏನ್ ಹೇಳಿ, ನಿಮ್ ಸಬ್ಮಿಷನ್ ಏನ್ ಹೇಳಿ ಫಸ್ಟ್, ವೆದರ್ ಅಪೀಲ್ ಇಸ್ ಮೇಂಟೈನಬಲ್ ಆರ್ ನಾಟ್? ನಾಟ್ ಮೇಂಟೈನಬಲ್. ಆರ್ ಯು ಗೋಯಿಂಗ್ ಟು ವಿಡ್ರಾ ದಿಸ್ ಟು ಫೈಲ್ ಬಿಫೋರ್ ದಿ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಫೋರಮ್ ಆರ್ ಏನು? ನಾವೇ ಕೇಳ್ಬೇಕಲ್ರಿ, ನೀವು ಏನು ಅಂತ ರಿಲೀಫು ಹೇಳ್ಬೇಡಿ, ನೀವ್ ಹೇಳಿ ಏನು? Appellant counsel seeks permission of this court to withdraw the appeal with liberty to approach the appropriate forum. Correct? And permitted to withdraw. Memo along with list of documents filed by advocate for appellant. SOB filed by. ಪಾಠ ಅಂತ ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ? ಏನಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಮೇಡಮ್ ಇವತ್ತು? ನೀವು ಹಾಕಿದ್ರಾ? ಆಯ್ತು, ಇವತ್ತು ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಯಾಕೆ ಬಂದಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ವೈ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟೆಡ್ ಇನ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಏನ್ ತಗೊಳ್ಳೋದು ಏನು ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ? ಈಗೇನ್ ರೆಡಿ ಇದೀರಿ ಇಬ್ರು? ಪಾಸ್ ಓವರ್ ಆಯ್ತು, ನೋಡೋಣ ಪಾಸ್ ಓವರ್. 2:30 ಅಂತ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡೋದಿಲ್ಲ, ಯಾವಾಗ ರೀಚ್ ಆಗುತ್ತೋ ಅವಾಗ. ಸಚಿನ್ BS issue notice to R8 to R12. ಏನಾಗಿದೆ? ರಿಟರ್ನ್ ಪೋಸ್ಟಲ್ ಸರ absent. Totally. Petitioner counsel 6 weeks time to furnish the fresh PF and correct address to issue notice against R8 to 12 and hence 1 week time granted, and if PF paid, issue notice against R8 to 12. Correct? Next, dismissal, non-payment of cost. Idu aste pass over. Report filed by the court commissioner. Commissioner report ಹಾಕಿದ್ದಾರೆ. The appellant counsel seeks time and has list this matter in the first week of March. Manjunath H awaiting service of notice in respect of R9 to 14. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದೆ? ಏನಾಯ್ತು ನೋಡ್ರಿ ಅದು? 9 ಹೋಗಿದೆ. ಏನ್ ಆರ್ಡರ್ ಏನ್ ಮಾಡಿದ್ಲು? ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪ್ಲೆಂಟ್ ಇಸ್ ಪರ್ಮಿಟೆಡ್ ಟು ಟೇಕ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 to 14. AK Kadri undertakes to file ವಕಾಲತ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 26. ಕಾದ್ರಿ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ರ ವಕಾಲತ್ತು? If wakalat is filed, registry is directed to show his name for respond number 26. The counsel for the appellant is directed to furnish a copy of the appeal memo to the said counsel. List the matter for admission on 15 to 24 ಅಂತ ಇದೆಯಲ್ಲ ಮೇಡಮ್? And I am reporting the same by the presence cannot be required because the teleport also they were not present. ಯಾರು? 9 to 14. All these submissions and before that
Before giving the notice, the trial court has passed it on some merits of the IAS. And the trial court has done the mistake.
ಸರಿ ರೀ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಲೀಫ್ ಯಾರ ಮೇಲೆ ಕೊಟ್ಟಿರೋದು? ಎಗನೆಸ್ಟ್ ಆಲ್. ಹಾ ಆನ್ ಮೆರಿಟ್ಸ್. ಆಯ್ತು, ನೀವೆಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಿರಿ. ರಿಲೀಫ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಎಗನೆಸ್ಟ್ ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ರಿಲೀಫ್ ಕೊಟ್ರೆ ಇನ್ ದ ಆಬ್ಸೆನ್ಸ್ ಆಫ್ ಯಾರಿಗೆ 9 to 14 ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ? 9 to 14 ಹೈಯರ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
Should not have good influence of the opinion that their presence was required.
He
argued the matter. And all of us argued the matter and they dismissed their applications, all three applications.
ಅಲ್ಲ ರೀ, ನೀವು ಸರ್ವಿಸ್ ಆಗದಲ್ಲ ಹೆಂಗ್ರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ? ಆಯ್ತು, ಕೇವೇಟ್ ಹಾಕಿದ್ ಆಯ್ತ್ರಿ, ಎಕ್ಸ್ಪರ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿತ್ತಾ? ಸರಿ ರೀ, ನೀವು ಸರ್ವಿಸ್ ಮಾಡ್ದಲ್ಲ ಹೆಂಗ? ಹೌ ಯು ಕ್ಯಾನ್ ಪ್ರೆಸ್ ದಿ ಪಿಟಿಷನ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್? ನೋಡ್ರಿ, ನನ್ನ ಪ್ರಶ್ನೆ ಇಷ್ಟೇ. ಹ್ಯಾವ್ ಯು ಸಾಟ್ ರಿಲೀಫ್ ಅಗೇನ್ಸ್ಟ್ ಆಲ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬಟ್ ನೋ ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್? How a court can consider the application in the absence of the respondent?
I am pressing the application
Expert only in the
they themselves appeared without service of notice. All other defendants, this is the better.
all respondents appear agillalla trial court alli. Matte alla, how you can press the order against in the absence of respondent? ಯಾಕ್ರಿ ಇದನ್ನ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಷನ್ ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಡರ್ ಇದ್ಮೇಲೆ ಯಾಕೆ ಹಾಕಿಲ್ಲ? ಏನ್ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಅಂತ ಇದೆ? ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಆನ್ 15 to 24 ಅಂತ ಇದೆ ಅಲ್ವಾ? ಇಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಅಂತ ಇದೆಯಾ ಇಲ್ಲಿ? ಮತ್ತೆ 9-2 ನಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ? ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿರೋದು ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪಲೆಂಟ್ ಇಸ್ ಪರ್ಮಿಟೆಡ್ ಟು ಟೇಕ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 to 14 ಅಂತ ಮಾಡಿದೀವಿ. ಹಂಗಿದ್ದಾಗ ಹಿಂಗ್ 9 to ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು 7-2 ರೀ. 9-2 ನಲ್ಲಿ ಹೆಂಗ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ. ಆರ್ಡರ್ ಆಗಿರೋದು 7-2 ನಲ್ಲಿ. ನಾವು ಹೌ ದೇ ಹ್ಯಾವ್ ಶೋನ್ ಆಸ್ ಅವೈಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ 9 to 14. ಅದ ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು? ಅವ್ರು ನೋಡ್ಬೇಕಾರ್ದು ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಅಲ್ವಾ? ಯಾವತ್ತು? ಆಯ್ತ್ರಿ, ನಾವು ಆರ್ಡರ್ ಮಾಡಿರೋದು ಹಂಗಲ್ಲ. ನಿಮಗೆ ಓನ್ಲಿ ಪರ್ಮಿಟೆಡ್ ಯು ಟು ಟೇಕ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 to 14. ದಟ್ಸ್ ಆಲ್. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಪಾಸ್ಡ್ ಎನಿ ಆರ್ಡರ್ ಟು ಇಶ್ಯೂ ನೋಟಿಸ್. Call them and also the person who posted the matter in the orders in spite of specific order to post the matter in admission. Pass over. 2/3 don't fix the time to the court. ಮಾಡ್ಕೊ ಮುಗಿಸ್ಕೊ ಬನ್ನಿ, ಕರ್ದಾಗ ಇರಿ ಅಷ್ಟೇ. 60 ಮ್ಯಾಟರ್ ಇರುತ್ತೆ ಎಲ್ಲಾರ್ಗು. ನಾನು 2:30 ಕೊಟ್ರೆ ಎಲ್ಲ 2:30 ತೊಳಕಾಗುತ್ತಾ? Manjunathji, counsel submission with regard to office objection, that is father name of appellant to be correctly stated. Non compliance ilwa ತೊಗೊಳ್ಳಿ. ಎಷ್ಟನೇ ಸರಿ ಬಂದಿರೋದು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್? ಫಸ್ಟ್ ಟೈಮ್ ಅಥವಾ ಎಷ್ಟನೇ ಸರಿ? ಇದೇನು ಹಾಕೋದೇ ಇಲ್ವಲ್ಲ ಮೇಡಮ್ ಇವರು? ಎಷ್ಟನೇ ಸರಿ, ಏನು ಕಂಪ್ಲೇಂಟ್ಸ್, ಯಾವಾಗಿಂದ ಬರ್ತಾ ಇದೆ? ಯಾಕೆ ಕರೀರಿ ಅವ್ರು ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ನವ್ರನ್ನ? ಎಲ್ಲ ನಾವು ಹುಡ್ಕೊಂಡು ಆರ್ಡರ್ ಬರಿಬೇಕ ಇಲ್ಲಿ? 4 ಸಲ ಬಂದಾಗ ಯಾಕೆ ತೋರಿಸಿಲ್ಲ ಇಲ್ಲಿ? ಪಾಸ್ ಓವರ್. ಜುಡಿಷಿಯಲ್ ಸೈಡ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇನೆ. ಇಫ್ ದಟ್ ಇಸ್ ದಿ ಲಾಸ್ಟ್. ಎಷ್ಟು ಸರಿ ಹೇಳ, ದಿನ ಅದೇ ಕೆಲಸನ. ಬೆಳಗ್ಗೆ ನಾವು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಕೊಂಡು ಆರ್ಡರ್ ಬರಿಬೇಕ ಇಲ್ಲಿ? ವೈ ದೇ ಆರ್ ಡೆಪ್ಯೂಟೆಡ್ ದೇರ್ 12 ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂತ. ಅಲ್ಲಿ 4 ಟೈಮ್ ತೋರಿಸಿದ್ರೆ ಏನು ವೆದರ್ ದೇ ಆರ್ ಸಿಟಿಂಗ್ ದೇರ್ ಟು ಹೆಲ್ಪ್ ದಿ ಅಡ್ವೊಕೇಟ್ಸ್. ಇಲ್ಲಿದೆ ಮತ್ತೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂತ ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ. ಸೆಕೆಂಡ್ ಟೈಮ್ ಇದೆ, ಮಾಡಿದಿರಾ ಇಲ್ಲ ಮಾಡ್ತೀರಾ? ಎಷ್ಟು ದಿವಸ ಟೈಮ್ ಬೇಕು ಹೇಳಿ? ಹಾ 3 ಇದೆಯಾ ಅಂತ ನೋಡಿ, 5ರಲ್ಲಿ ಇನ್ನೂ 3 ಇದೆ ಅಂತ. ಎಷ್ಟು ದಿವಸ, 1 ವಾರ ಬೇಕಾ? The applicant counsel seeks 1 week time to comply with remaining office objections. List the matter after the compliance. Non-compliance of office objections. ನೀವು ಕಂಪ್ಲೈನ್ಸ್ ಇಲ್ದವ್ರು ಮೆಮೊ ಹಾಕಿ ಮೂವ್ ಮಾಡ್ತೀರಾ ಕೌನ್ಸಿಲ್? If you have not complied the office objections, why you have moved the matter before the court? ಏನ್ ಮೆಮೊ ಮಾಡಿ ಮೂವ್ ಮಾಡಿದಿರಿ? ಅಲ್ಲಿ 3 ಇದೆ ಇನ್ನೂನು. ತೊಗೊಳ್ಳಿ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಸದಾಶಿವ ಹೇಳ್ರಿ. ಹಾ ಮತ್ತೇನಿದೆ, ಏನಿದೆ ಮೇಡಮ್? ಹಾ ಕೋರ್ಟ್ ಫೀ ಎಲ್ಲ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ? ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇವಾಗ ಬೆಳಗ್ಗೆ ಮಾಡಿದ್ದಾರೆ.
ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ಬೆಳಿಗ್ಗೆ ಬಂದು ಈ ಫೈಲ್ ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟು
ಸರಿ, ಅದ್ ಯಾವಾಗ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕೇಳಿದೆ. ಅದ್ ನೆನ್ನೆ ಬರುವಾಗ್ಲೇ ನೋಡ್ಬೇಕಿತ್ತಲ್ಲ ಅದನ್ನ. The counsel submits that he has already completed the office objections and hence post the matter for admission on ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಅಥವಾ ಏನು? ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ
ಹಾ
ಇಮೇಲ್ ಹಾಕ್ತಿದ್ದಾರೆ, ಪರವಾಗಿಲ್ಲ.
ಮೇಲ್ ಅಲ್ಲಿ ಕಳ್ಸಿದಿರಾ ಕಾಪಿನ? ಮತ್ತೆ ಮೇಲ್ ಕಾಪಿ ಹೆಂಗ್ ಸರ್ವ್ ಮಾಡಕ್ಕೆ? ಅದು ಅಲೋಡ ನಿಮಗೆ? ಕೆವೇಟ್ ಕೂಡ ರಿಟರ್ನ್ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಮೇಡಮ್. ಕೆವೇಟರ್ ನೀವು ಕಾಪಿ ಕಳ್ಸಿರೋದು, ಕೆವೇಟರ್ ರಿಟರ್ನ್ ಆಗಿದೆಯಲ್ಲ. ತೊಗೊಳ್ಳಿ, ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಇನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಕುಮಾರ್ ಟಿಕೆ, ನಾಗಮುನಿ ಪಿ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಹೇಳ್ರಿ ಎಷ್ಟನೇ ಸರಿ ನೋಡ್ರಿ ಮೇಡಮ್ ಅದು. ತೊಗೊಳ್ಳಿ, ಎಷ್ಟು ದಿವಸ ಬೇಕು? Appellant counsel seeks 2 days time to comply with office objections. If office objection complied within 2 days, list this matter in the next week. Vivek S. First time, ಎಷ್ಟು ದಿವಸ ಬೇಕು? Counsel seeks 2 weeks time to comply with office objection and hence 2 weeks time granted. Next, Sudhindra S.A. Non-compliance of office objection, that is acknowledgement for having served copy on the K-waiter. ಅಲ್ಲ ರೀ, ಮತ್ತೆ ಕೋರ್ಟ್ ನಿಮಗೆ ಕೆವೇಟರ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಬಟ್ ವೈ ಯು ಮೂವ್ ದಿ ಮ್ಯಾಟರ್ ಮೆಮೋ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್? ಕೊಡ್ರಿ, ಎಷ್ಟನೇ ಸರಿ ಬಂದಿರೋದು? ಫಸ್ಟ್ ಟೈಮ್. ಮತ್ತೆ ಯಾಕೆ ಇವ್ರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ? The council has not served the copy on the Kevator council and hence 1 week time granted to comply with office objections. Council submission with regard to office objection, that is typed copy to be furnished for manual script document. ಕೊಡ್ರಿ. ಪೇಜ್ 51 ಮಾತ್ರನಾ? ಟೈಪ್ಡ್ ಕಾಪಿ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಇದೆ ಮ್ಯಾನ್ ಸ್ಕ್ರಿಪ್ಟ್ ಎಲ್ಲಿ ಇದೆ? ಇಲ್ಲಿ ನಾಟ್ 51 ರೀ, ಬೇರೆದಿರ್ಬೇಕು ಮ್ಯಾನ್ ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಇರೋದು. 51 is the relevant document. ತೊಗೊಳ್ಳಿ. 6 and 7 5 ಇದೆ ಇಲ್ಲಿ. 6 ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 6 ಪ್ರಮಾಣ ಪತ್ರಿಕೆ ಇದೆಯಲ್ಲ. ಆಯ್ತು, ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 6 ಇಸ್ ರೀಡಬಲ್. ಆಮೇಲೆ 7 ಏನು? 7 ಆಲ್ಸೋ ರೀಡಬಲ್ ಅಂಡ್ ಹೆನ್ಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ನೆಕ್ಸ್ಟ್ ಏನು ಬೇರೆದೇನು? ಟೈಟಲ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟ್ ಏನೋ EFI. ಓನ್ಲಿ ಎಸ್. The council submission is accepted with regard to the typographical error in not mentioning the name as S. List the matter for admission. ನಾಳೆ ಆಗೋದಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್, ನೆಕ್ಸ್ಟ್ 21st ಮಂಡೇ ಅಲ್ಲ, RSA ಡೇ. 22nd. 18, non-compliance of office objections. Council seeks 2 days time to comply with office objection. 2 weeks, 2 weeks. And hence 2 weeks time granted as sought. Next. Kirti Kumar D. Naik. Clarification filed by the advocate for petitioner along with statement of objections filed by advocate for respond number 1A. ಏನ್ರಿ ಇದು? ಪಾಸ್ ಓವರ್ ಏನು ನೋಡ್ ಯಾವ್ದಿದು ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಬೇಕಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ ಪಾರ್ಟ್ ಹರ್ಷ ಡಿ ಜೋಶಿ impleading R3 filed by advocate for impleading R3 non-filing of SOB on IA number 1 of 23 by advocate for appellant 1/2/24. Who filed this impleading application? ನೀವು ಹಾಕಿರೋದ ಅವ್ರು ಈಗ ಇಬ್ರು ಇಲ್ಲ ಅವರು ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೋರು ಇಲ್ಲ ತೋಳಿ you are appearing for whom? Respond number 1 and 2 na 1 and 2. The counsel for 1 and 2 is present and impleading applicant counsel is absent and also the appellant counsel is absent. List this matter after 2 weeks. Gangadhara A. Nagareddy awaiting service of notice in respect of R4 to 14. ಬರ್ತಾ ಇದ್ದಾರೆ ಪಾಸ್ ಓವರ್ Sachin BS 51 days delay. Other side appear ಆಗಿದಾರಾ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಾರು ಹಾಕಿದಾರ? ಕಾಪಿ ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದಿರಿ? ಅಯ್ಯೇ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರ ಅದರ್ ಸೈಡ್ಗೆ ಅಲಾಂಗ್ ವಿತ್ ಮೇನ್ ಅಪೀಲ್ ನೋಟಿಸ್ ಆನ್ ಅಯ್ಯೇ ಅಂತ ಆಗಿದೆಯಾ ನೋಡಿ. ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ. ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದಾ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ತಗೊಳ್ಳಿ. Heard on IA 1 of 23 and there is a delay of 51 days in filing the appeal. And though counsel represented behalf of the respondent has not filed any objections to IA 1 of 23 and for the reasons stated in the accompanying application and affidavit and the delay is only 51 days and hence delay of 51 days is condoned. List the matter for admission along with IA number 2. The 4th week of February. Kavita Damodaran GR Mohan. ಯಾವ್ದೋ ಲೇಔಟ್ ಪ್ಲಾನ್ ಅದ? ಇದು ಮ್ಯಾಟರ್ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಲ್ವಾ? ಏನಾಯ್ತು ಮೇಡಮ್? ತೋಳಿ ಮೇಡಮ್. ಈಗೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವಾಗ ಹಾಕ್ತೀರಾ? ಅವ್ರಿಗೆ ಕಾಪೀಸ್ ಕೊಟ್ರ ಅದರ್ ಸೈಡ್ಗೆ ಕೊಡ್ತೀರಿ? ತೋಳಿ. ದ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವು? Respondent submits that he is going to file the documents and also going to serve the copy of the documents today itself in the office. And hence list this matter. ಯಾವ್ದು MF ಏನ ಮೇಡಮ್? 22nd ಕೊಡಿ. 22nd ಇದು ಪಾರ್ಟೆಡ್ ಅಂತ ತೋರಿಸಿ. ಇದು ಮೋಸ್ಟ್ಲಿ ಎಲ್ಲ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಇದು. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ತೋರಿಸಿ. ಕೊನೆಗೆ ಏನೋ ಎಲ್ಲ ಕೇಳಾದ್ಮೇಲೆ ಲೇಔಟ್ ಪ್ಲಾನ್ ಇದೆಯೋ ನೋಡೋಣ ಅಂತ ಮಾಡಿದ್ವಿ. ಅದು ಆಕ್ಚುಲಿ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮೊದಲು ಮಾಡಿಲ್ವಾ? ಹೌದಾ? ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ವೆಕೇಟಿಂಗ್ ಏನಿದು? ಪಾಸ್ ಓವರ್. ಆಯ್ತು. ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ರೀಚ್ ಆಗೋದು ಡೌಟ್ ನೋಡಿ. ನಾಗೇಂದ್ರ ನಾಯ್ಕ್ ಆರ್ A 2/23 for condonation of delay of 206 days in filing. A 1 of 23 for stay. A 1 of 2 additional documents. Other side are notice ಇನ್ನೂ ಆಗಿಲ್ವಾ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ. ಡಿಲೇ ಇದೆ. ಡಿಲೇ 206 ಡೇಸ್ ಇದೆ. ಏನ್ ಮಾಡೋದು? ನೀವು ಡಿಲೇ ಇದ್ದಾಗ 1-2 ದಿವಸ ಅಲ್ಲ 206 ದಿವಸ ಇದೆ. ನೀವು ಅದರ್ ಸೈಡ್ ಬೇಕಾದ್ರೆ ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ. ಐ ವಿಲ್ ಪರ್ಮಿಟ್ ಯು. ಆಯ್ತು. The appellant counsel is permitted to serve the copy of the appeal memo and also the IAS on the counsel who appears for respondent before the trial court. ಯಾವತ್ ಬೇಕು? ಒಬ್ರಿಗೆ ಮಾತ್ರನಾ? ನೀವು ರಿಲೀವ್ ಕೇಳ್ತಾ ಇರೋದು ಯಾರಿಗೆ? ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ. ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ. ಆಮೇಲೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡೋಣ ಬೇರೆಯವ್ರಿಗೆ. ಬೇರೆಯವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ರೆ ಮತ್ತೆ ಟೈಮ್ ಆಗ್ತದೆ. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಮಾಡ್ಲಾ ಬೇರೆಯವ್ರಿಗೆ? ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. ಸರಿ, ಯಾವತ್ ನೀವು ಮಾಡ್ಕೊ ಬರ್ತೀರಿ? 13th ಯಾವ್ದು ನೆಕ್ಸ್ಟ್ ಮಂತ್ 13th ಟೈಮ್ ಇದೆಯಲ್ಲ, ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಬಿರ್ಲಿ. ಅಷ್ಟು ಒಳಗಡೆ ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀನಿ ರೀ, ಬೇರೆಯವ್ರಿಗೂ ಜಾರಿ ಆಗ್ಲಿ. ಅಂಡ್ ಆಲ್ಸೋ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್, ಇಶ್ಯೂ ನೋಟಿಸ್, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಫಸ್ಟ್ ವೀಕಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್, ಮಾರ್ಚ್ ಅಲ್ಲಿ ಕೊಡಿ, 7th 6th ಕೊಡಿ, 6/3 ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 6/3. R1ಗೂ ಸರ್ವ್ ಮಾಡಿ ಆಫೀಸ್ ಕೋರ್ಟಲ್ಲೂ ನಿಮಗೆ ಕೋರ್ಟ್ ಕೂಡ. ಅಂಡ್ ಆಲ್ಸೋ ಪರ್ಮಿಟೆಡ್ ಟು ಸರ್ವ್ ಅಂತಾನು ಆಯ್ತು, ಜೊತೆಗೆ ಅವ್ರಿಗೆ R1 ಮಾತ್ರ. 26 ಪರ್ಮಿಷನ್ ಟು ಫೈಲ್ ಅಪೀಲ್. ನೀವು ಕೇಳಿದ್ರಿ, ಹೇಳಿ. ಹಾ
ಅಲ್ಲಿಲ್ಲ.
ನೀವು ಕೇಳಿದ್ರ ನೀವು ತೊಗೊಳ್ಳಿ. ಹರ್ಡ್ ದಿ ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ on IA number 1 of 24, wherein prayed this court to grant leave to file this appeal on the ground that ಯಾವಾಗ ತೀರ್ಕೊಂಡಿದ್ದು? ಹಾ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದೆ ಅವಾಗ. Two 11/23 ಅಂದ್ರೆ ರಿಸರ್ವ್ ಆದ್ಮೇಲೆ, on the ground that the miscellaneous petition number 1543 of 22 was heard and reserved on 7/6/23, and her husband Sri B. Manjunath passed away on 26/9/23, leaving behind the appellants, and impugned order was passed on 2/11/23, and hence sought permission leave of this court. For the reasons stated in the accompanying application affidavit, leave is granted to file the appeal. Next, ಏನಾಗಬೇಕು? ನೋಟಿಸಾ? ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. ಅಡ್ಮಿಷನ್ ಕುಮಾರ್ ಅಂಡ್ ಭಟ್, ಗಣಪತಿ ಭಟ್, ನಾಗೇಂದ್ರ ಕುಮಾರ್. 2 weeks ಏಕೆ ರೀ? ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಡ್ಮಿಷನ್, ನೋಡಿದೀರಾ? ನಮ್ ಮುಂದೆನೆ ಸುಮಾರು 3-4 ಸರಿ ಬಂದಿದೆ. ವೈ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಟೈಮ್? Order 1 Rule 10, 8 application read with section 92 of ನಾವೇನೋ ಮಾಡಿದೀವಿ ಇಲ್ಲಿ. ಆರ್ಡರ್ IA 1 of 20 wherein praying to amend the cost title so and so. ಅದು ಓನ್ಲಿ ಪ್ರಾವಿಷನ್ ಅಮೆಂಡ್ ಮಾಡಕ್ಕೆ. Last time permitted to amend the provision, council appellant seeks time to argue the matter on merit. Third, the appellant council seeks 2 weeks time, and hence list this matter after 2 weeks. 2012 ಇರ್ಬೇಕಿದು, 12 ವರ್ಷ ಆಯ್ತು ಇನ್ನು ಅಡ್ಮಿಷನ್. HR ಅನಂತ ಕೃಷ್ಣ ಮೂರ್ತಿ, ಸುಜಾತ ಅಹಮದ್. ಹೇಳ್ರಿ. Memo along with certified copy of the order passed in AS number 25002 are filed by the advocate for appellant. Non-filing of memo along with acknowledgement for having served documents to the advocate for R2. ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗೋದು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರಿಗೆ? ಒನ್ಗ R2ಗೆ ಏನೋ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಅಂತ ಏನೋ ಇದೆಯಲ್ರಿ ಇದ್ರಲ್ಲಿ? ಸಿಕ್ಕಿಲ್ಲ ಕೊಡ್ತೀರಾ? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. 2015 matter ರೀ. Learned counsel for the appellant seeks time. Learned counsel for the respondents are present. Learned counsel for respondent number 2 submits that except appeal memo, none of the documents are produced. Hence, the counsel for the appellant is directed to produce the same forthwith ಅಂತಂದ್ರೆ ಅರ್ಥ ಏನು? To the counsel for respondent number 2. ಕೂಡ ಕೋರ್ಸ್ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ? ಇಲ್ವಲ್ಲ ಈಗ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ. ಪಾಸ್ ಓವರ್. No counsel, 2015 matter. ಅಲ್ಲ ರೀ, ಡಾಕ್ಯುಮೆಂಟ್ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ನೋ ಐ ಆಮ್ ಆಲ್ಸೋ ರೆಡಿ ಅಂತಂದ್ರೆ ಹೆಂಗ್ರಿ? When the direction was given to you to serve the documents forthwith ಅಂತ ಮಾಡಿದಾಗ ಮತ್ತೆ ನಿಮಗೆ ಸಿಗೋದಿಲ್ಲ, ನೀವು ಸರ್ವ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಡ್ಬೇಕು, ಇಲ್ಲ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಜಾರಿ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗ್ತದೆ? ಹಾ, ತೊಗೊಳ್ಳಿ. ದ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಗೇನ್ seeks time to serve the documents on counsel for R2 and hence list this matter in the 4th week of March. ಅವ್ರಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ಮೇಲೆ ನಮ್ಗೆ ಏನು ಕೋರ್ಟ್ನವ್ರಿಗೆ ಕೊಡಿ. 4th week of March ಕೊಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಯ್ತು ಹಿಯರ್ ಮಾಡಿದ್ವಿ, ಕ್ಲಾರಿಫೈ ಮಾಡಿ ಅಂತಾನೆ ಹೇಳಿದ್ವಿ. ಅದ ದಟ್ ಈಸ್ ಡಿಫರೆಂಟ್ ಮ್ಯಾಟರ್. ಹೇಳಿ. ಅಲ್ರಿ, ಸತ್ತವ್ರ ಪರವಾಗಿ ಬಂದಿರ್ತೀರಿ 2016 ಅಪೀಲ್, ಆದ್ರೂ ಈಗ ಬಂದ್ ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ತೀರಿ ಅಂತಂದ್ರೆ ಏನ್ರಿ ಇದು? ನಿಮ್ ಪಿಟಿಷನ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಹಾ, ಏನ್ ಲಾಸ್ಟ್ ವೀಕ್ ಅಪೀಲ್ ಆಫ್ ದಿ ಇಯರ್ 2016. I think it appears that you are thinking that the court is not having any. Huh? I read the papers. Now you seek time. This appeal is filed in 2016 and matter is listed for admission. Even now, even after lapse of 8 years, the council seeks time and hence an urgent and cost of rupees 5,000. List this matter. ಯಾವಾಗ ಬೇಕು? No council. ಆಯ್ತು, ಆನ್ ಕಾಸ್ಟ್ 23 2 ಕಾಸ್ಟ್ ಕಟ್ 30 kg ಶಾಂತರಾಜ ಅನುಪಮ ಹೆಗಡೆ. ಹೇಳಿ, ಯು ಆರ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ತೊಗೊಳ್ಳಿ, ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಆರ್ಡರ್ ಶೀಟ್ ತೊಗೊಳ್ಳಿ. Yes, filed wakalat last time, hence registered to put up the same and show the name of the council so and so. ಡಿಸ್ಮಿಸ್ ನಾನು ನೋಡಿದ್ದೀನಿ, ನೋಡ್ತಾ ಇದ್ದೀನಿ ಯಾಕೆ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಪರ್ಸೂ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ. 2016 ಆದ್ರೂ the appellant counsel is absent and counsel for respondent is present. Though this appeal is filed in 2016, even after lapse of 8 years, the appellant counsel is not pursuing the matter diligently. However, in the ends of justice, instead of dismissing the same and cost of rupees 5,000, an opportunity is given. List this matter on 23 2. If appellant counsel doesn't appear and pay the cost, appeal will be dismissed in the next date of hearing. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಸ್ಟೇಟಸ್ ವೆರಿಫೈ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ವಿ. ಆರ್ಬಿಟ್ರೇಷನ್ ಸೆಕ್ಷನ್ 9 ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿರೋದು ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಬರ್ಲಿಲ್ವಾ? ಪಾಸ್ ಓವರ್. ವೆಂಕಟೇಶ್ ಪಿ ದಲ್ವಾಯ್ ಆರ್ ಪುಷ್ಪ ಹಾಷಾ ಫಾರ್ R2. ಆರ್ಡರ್ 9 ರೂಲ್ 9 ಡಿಸ್ಮಿಸ್ಡ್. ಹೇಳಿ. 2 years ಕೊಡಿ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡಿ. Two years back also.
So meaning once there was direction to dispose of particular thing, they did not comply, they did not cooperate. Should have dismissed for non-prosecution. They made a misdirection of this also, stating that there was no grounds to revive the original. In the meanwhile, even given the tendency of the misdirection, the applicants have register agreement of sale, they have sold the property to some person. That's more interest in the property. Their interest is only for.
ಆಲ್ರೆಡಿ ಸೇಲ್ ಮಾಡಿದಾರಲ್ಲ ಮತ್ತೆ.
Yes, I agree. Then when we went to the well, what we learned that there is a cell. Then I fed an application. No, this can't be. Humanitarian loans, liberal loan, because the applicants are knowing the sources of interest in property. I find this, the other one is very good. I have put in the register document of sale also. Therefore, the applicant, even if they come, they can't handle.
Oh, shit.
Work in the office, they never say about how the business is.
ಯಾವಾಗ್ರಿ ನೀವು ಕೊಟ್ಟಿರೋದು NOC ಅಪ್ಲೆಂಟ್ ಇಲ್ಲೇ ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿದೀವಲ್ಲ ಲಾ 1-2 ನಲ್ಲಿ appellant is absent and the learned counsel for the respondent is present if the counsel for the appellant doesn't appear on the next date of hearing appeal will be dismissed ಅಂತಿದೆ. ಆಯ್ತು, ಇವತ್ತು ಬಂದಿದ್ದೀರಿ, ಹೇಳಿ ಕೇಳೋಣ. ಹಾ ರೇ ಕೊಡ್ರಿ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಲ್ರಿ. ಹಾ, ಏನ್ ವಿತಿನ್ ವೀಕ್ ಕೊಡೋದು? ಅಂಡರ್ಟೇಕ್ ಏನ್ ಮಾಡೋದು ನೀವು ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಾಗ? ನೀವು ಆಲ್ರೆಡಿ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ಹ್ಯಾವ್ ಗಿವನ್ NOC. ಕೊಡು ಇದು ಡಾಕ್ಯುಮೆಂಟ್, ದಟ್ಸ್ ಆಲ್. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಇದೆ ಇವತ್ತು. ಯು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಅಕ್ನಾಲಜ್ಮೆಂಟ್. ಅದೇನು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದಿರಿ, ಕೊಡಿ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಕೊಡಿ. ರೆಕಾರ್ಡ್ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಹ್ಯಾವ್ ನೋ ಲೋಕಸ್ ಟು ಮೇಕ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಕೌನ್ಸಿಲ್. ಯಾವಾಗ? 2 ವರ್ಷದಿಂದನೇ ಕೊಟ್ಟಿರೋದು ನೀವು NOC. ಮತ್ತೆ ಅಪಲೆಂಟ್ ಇಸ್ ನಾಟ್ ಪರ್ಸೂಯಿಂಗ್ ದಿ ಮ್ಯಾಟರ್, ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಬಿಡಿ ಇವತ್ತು. ಮತ್ತೆ ಯಾಕೆ? ಮತ್ತೇನು ಕೊಡೋ ಆಪರ್ಚುನಿಟಿ ಏನಿಲ್ಲ ನಿಮ್ದು, ತಗೊಳ್ಳಿ. The counsel for the appellant would submit that he has given NOC 2 years back. And this court also having taken note of the appellant counsel is not pursuing the matter. And in the previous date of hearing 1/2/24. When the appellant counsel did not appear before the court, made it clear that if the appellant counsel doesn't appear on the next date of hearing, the appeal will be dismissed. Now counsel says that he has not maintained any records for having given NOC. And when the counsel submits that he has given NOC 2 years back, and when the appellant is not pursuing the matter by engaging any other counsel, it appears that appellant is not interested in pursuing the appeal and hence appeal is dismissed. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂದ್ರೆ ಏನಾಯ್ತು? ಮಿಸ್ಲೈನಸ್ ಹಾಕಿದ್ರೆ ಆಯ್ತು. ಸೊ ಡಿಸ್ಮಿಸ್ ಅಂದ್ರೆ ಏನು ಮಿಸ್ಲೈನಸ್? 2 weeks time granted to report the settlement. If settlement is not allowed, appeal will be considered on the next date of hearing. ಹೇಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಸೊ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಈಗ MF ಹೆಂಗ್ ಸರ್ವೈವ್ ಆಗುತ್ತೆ ಮೇಡಮ್? Suit already been dismissed and miscellaneous petition also filed. The same is pending for consideration. Third, the counsel appearing with the appellant would submit that already suit is dismissed and miscellaneous petition is also filed and the same is pending for consideration. And hence this appeal doesn't survive for consideration unless an order has been passed in miscellaneous petition. And if miscellaneous petition is allowed and if need arises to revive this appeal, revive ಮಾಡ್ಕೊಳ್ಳಿ ಪಿಟಿಷನ್ ಅಲ್ಲೋ ಆದ್ರೆ. And at present the appeal is dismissed, not survive for consideration. ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, ರಿವೈವ್ ಮಾಡ್ಕೋಬಹುದು ನೀವು ಅಂತ ನಿಮ್ ಮಿಸ್ಲೇನಿಯಸ್ ಅಲ್ಲೋ ಆದ್ರೆ. ಹರೀಶ್ ಭಂಡಾರಿ ಟಿ. ಹ್ಮ್ 2 days ಎಲ್ಲ ಟೈಮ್ ಇಲ್ಲ, ಏನಿದ್ರೆ 2 ವಾರ. ನೀವ್ಯಾರಿಗೆ 1 to 7 ನೀವೇನೇ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟಾ? ತೋಳಿ. The appellant counsel seeks time and counsel ನೀವು WP ನಲ್ಲಿ ಮಾತ್ರ ನೀವಾ? WP ನಲ್ಲಿ ನೀವಿದ್ದ ಯಾರಿದ್ದಾರೆ ಮತ್ತಿಲ್ಲಿ? ನೋಟಿಸ್ ಆಗ್ಲಿ ಬಿಡಿ ಹಾಗಾದ್ರೆ ಇದರಲ್ಲಿ. ಆಯ್ತು, ಈಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕಲ್ಲ. ನೀವ್ ಯಾರು ತಗೋತೀರಾ ನೋಟಿಸ್ ಇದ್ರಲ್ಲಿ? WP ನಲ್ಲಿ ನಾನು ಕೇಳ್ತಾ ಇರೋದು. ಯಾಕೆ WP ನಲ್ಲಿ ಸರ್ವ್ ಆಗ್ದಲೇನೆ ಮಾಡ Counsel Sri Nayak Ramachandra Rama takes notice for ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ R127 in WP number 24670 of 2023. ತೊಗೊಳ್ಳಿ ನೀವು WP ಮಾತ್ರ ಅಪಿಯರ್ ಆಗದ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ 2 weeks ಟೈಮ್ ಎಷ್ಟು ದಿವಸ ನಿಮ್ಗೆ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹಾ 2 days ಹಾ
You want to come to the question of the since Rambedkar since 1952
ಅಲ್ಲ ಆಯ್ತು ಈಗ ಏನು ಯಾವಾಗ ಕೊಡ್ಬೇಕು ಹೇಳಿ ಆಯ್ತು ಹೇಳಿ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ 22nd ಲಿಸ್ಟ್ ದಿಸ್ ಮಾಡ್ರ 22nd ರೀಚ್ ಆದ್ರೆ ತಗೊಳ್ಳೋಣ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ M Sudhakar Pai 1 and 2 rejected Balakrishna Sastri for R3 and R4 1 2 and 4 to 10 no, dispensed with ಹೇಳಿ ಈಗ ನೀವು ರಿಲೀಫ್ ಕೇಳಿರೋದು ಯಾರ ಮೇಲೆ ಇಲ್ಲಿ ಅದೇ R3 ಅಂದ್ರೆ ಈ ಅಪೀಲ್ ಅಲ್ಲಿ ಯಾರು R3 and R4 ಈಗ ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಈ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಅವ್ರು ಇಲ್ಲ ಈಗ ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅವ್ರ ಮೇಲೆ ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವೀಗ ಹಾ ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ಬಿಡಿ ಬರ್ಲಿ ಅವರು ನೀವೇ ಹೌದೇನ್ರಿ ಪಾಸ್ ಓವರ್ ಆಯ್ತು ಮಾಡ್ತಾರ ಅವ್ರು ರೆಡಿ ಇದಾರಲ್ಲ ರೆಡಿ ಇದೀರಾ ಅಥವಾ ಡೇಟ್ ಬೇಕಾ ನಾಳೆಗಾಗಲ್ಲ ಹಾ ಮಂಡೇ ಇಲ್ಲ MFS ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಮೇಲೆ ತರ್ಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ ಎಲ್ಲ ಕ್ರಿಮಿನಲ್ ಡೇ ಇರ್ತದೆ ರೀಚ್ ಆಗೋದಿಲ್ಲ ನಾನು ಅದನ್ನೇ ಕೇಳಿದ್ದೆ ಈಗ ಅದರ್ ಸೈಡ್ ಈಗ ಟೈಮ್ ಕೇಳೋದ್ರಿಂದ ತರ್ಸ್ಡೇ ತೊಗೊಳ್ಳಿ applicant counsel is present and counsel for the respondent seeks pass over and hence counsel for appellant submits that today has got inconvenience and hence list this matter on 22nd alla madam 22 to interim order granted earlier is extended till then interim order ಇದ್ರೆ ಮತ್ತೆ ಅರ್ಜೆನ್ಸಿ ಯಾಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕಿಗೆ ಫಸ್ಟ್ ವೀಕ್ ಮಾರ್ಚ್ ಹಾಕೋಣ ಆಯ್ತು ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಹಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತುಂಬಾ ಇದೆ ಅದಕ್ಕೆ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಅಂತ ಹಾಕಿದ್ವಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಥರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಏನು ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಇದೆ ಅಲ್ವಾ ಇದು ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಬರ್ತಾರೆ ನೋಡೋಣ 37 ಹೇಳಿ ಅದರ್ ಸೈಡ್ ಇಲ್ವಾ ಹಾ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಊರಲ್ಲಿ ಇಲ್ಲ ಅಂತಲ್ಲ ಏನೋ ಕೇಳಿದ್ರು ಆಯ್ತು ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಏನು ಹ್ಮ್ 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 agreement of sale ಹಾ ಹ್ಮ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ ಏನು ಲೆಟ್ ಹಿಮ್ ಕಮ್ ಹಾ ಪಾಸ್ ಓವರ್ ಕೆ ರವಿಶಂಕರ್ ರಾಕೇಶ್ ಕಿಣಿ ಹಾ ಬಂದ್ರಲ್ಲ ಹ್ಮ್ ಹ್ಮ್ ಯಾವ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದ್ದು? ಹಾ ಹಾ ಕೊಡಿ ಅದೇನು ಕೊಡಿ. Five to 2023
Disconnect.
disconnection. ಹಾ ಏನಿದು ವಾಟರ್ ಪೈಪ್? ವಾಟರ್ ಪೈಪ್ ಮನೆಗೆ ಬರೋ ನೀರು, ಕುಡಿಯೋ ನೀರಿನ. ಹಾ
Operation water correction.
ಹ್ಮ್
You are the regulated which is taking advantage, though it has been stayed. But I have got a child of specially able of 75%. It did not arrive to make the application in time.
Hmm.
1 month away, you are not taking part in that application.
Who has filed the suit?
But
They have filed the suit.
that is decree,
Suit for ಏನು?
declaration that they are the owners of the
ಪ್ರಾಪರ್ಟಿ. ಆಯ್ತು. ಹ್ಮ್ 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 stay of earlier judgment and decree. And the water connection disconnected only in respect of your house. What about other 3 houses?
Other 3 houses, they have obtained a new connection.
They have taken their separate new connection. Ah. Hmm?
They have taken a new connection. Or he has taken a new connection.
Hmm.
My connection has been. Something in the tank and something for a break.
Hmm. ಏನ್ರಿ? Anyhow, council, there is a decree. Decree has been stayed. How will you disconnect the water? 4/1/2023. Complaint filed by the respondent before the Commissioner of Mangalore City Corporation. That is filed by you, na? New water connection was sanctioned. ಯಾರಿಗೆ ನಿಮ್ಗ? ನೀವು ಅಲ್ಲೇ ಇದ್ದೀರಾ? ಹ್ಮ್ ಆಯ್ತು. ಹ್ಮ್ 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 if really they have disconnected the water. ಏನ್ರಿ ಇದು ನೀವು instead of arguing the matter, you have filed an application before the appellate court. Whatever it may be, counsel, according to you, water was disconnected on 4/1/2023. ಆಯ್ತು 5/2 ಆಯ್ತು 5/2/22 ಇಂದ 4 ಸರಿ ಕೇಸ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದೆಯಲ್ಲ. Why you have not mentioned before the particular court that? Huh?
28 matter ಅವರ ಏನಿದೆ ಅರ್ಪಿಸಿ ಕ್ವಶನ್
Hmm.
ಆ ವಾಸ್ ಲೈಕ್
ಅವ್ರೇನೆ? ಹಾ.
he has not produced any order sheet. He is simply saying that I have taken time. It's a appellate court appeal of the year.
ಕೊಡ್ರಿ ಅದು. ಅಪ್ಲೈಂಟ್ ಪೇಡ್ ಟೈಮ್ ಫಾರ್ ಹಿಯರಿಂಗ್ ಆನ್ ದಿ ಸೆಡ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಕೇಳಿದಿರಿ. ಆಯ್ತ್ರಿ, ನೀವು 23/4/2023 ಹೋಯ್ತು. 28/3 ಇದು ಡೈಲಿ ಸ್ಟೇಟಸ್. 28/3 counsel for appellant is present and seeks time to hear on IA number 3. Counsel for respondent is present and submits they are ready to hear on IA main along with IA number 3. Further, counsel for the appellant files application under section 151 CPC seeking for extension of interim order of stay. Peruse the stay order is extended till next date of hearing. Call on to hear on so and so. Oh, at your expense only IA was urgent.
My application for extension of stay. The water connect disconnected on 5/2. I filed the application on 4/3. There is a maybe approximately 20 days.
Not only for filing an application, even when the application was filed before the court, when they come up with a statement of objections, why you have not argued the matter if water disconnection was made? And order was passed in the month of July. Till date, what you have done? ಯಾವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ ನೀವು? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದ ಯಾವಾಗ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದ ಯಾವಾಗ ನೀವು? ಮತ್ತೆ you argue the matter on merits, that's all. Before the appellate court. Essential amenity is very conduct shows your client. Instead of arguing the matter by your counsel before the trial court, files an application saying that water is disconnected. But according to you only, it was disconnected in the month of February. And there was a delay in filing the application. One thing. Then secondary, when the application was filed for restore the water, when the objection is filed, instead of arguing the matter, you have only the dodge the matter, and order was passed in the month of July. Now why the court has to consider this application? It appears that instead of arguing the matter before the trial court, your client made an application for only with an intention to protract the appeal, that's all. Because your client has got the stay order. That conduct cannot be encouraged. I will give direction to appellate court, let it appellate court dispose of the matter on merits. You go and argue the matter before the trial court, that's all. Water connection then ನಿಮ್ಗೆ ಏನು ಬೇಕಾಗಿಲ್ಲ, ನಿಮ್ಮ ಕಾಂಡಕ್ಟ್ ನೋಡಿದ್ರೆ ತೋಳಿ. Heard the appellant counsel and also the counsel appearing for the respondent. This matter is listed for admission. The trial court rejected the application filed under order 39 rule 1 and 2, wherein prayed the trial court to grant mandatory injunction directing the respondent to reconnect water supply pipeline to the residential house of the appellant A scheduled property. In support of the application, and affidavit is sworn to that the respondent is trying to interfere with the peaceful possession and enjoyment of the residential house bearing D number 5.107/1 since several years. It is stated that an attempt is made to forcibly dispose the appellant and his family from the portion of scheduled property. On 4/1/2023, the appellate court has also granted an order of stay of the impugned judgment and decree dated 26/8/22. The house in which appellant is residing having water connection and water supply from the city corporation will directly go through pipeline to the syntax kept in the open terrace. They have been using the water connection since more than 14 years. First of on 5/2/23, high-handedly and illegally the respondent has cut the water pipeline, which leads to the A schedule property by inserting a stopper and thereby completely blocked the water connection to the said property. First of, the respondent has provided a separate water connection to the house bearing the number 5.107 in the cellar portion, only with ill intention, respondent is somehow to forcibly disposes the appellant and his family from the A schedule property in a manner unknown to law. The respondent has also obtained new water connection to his house in the first floor. First of, when the appellant had been to repair the same through a plumber, the respondent has abused the appellant and gave life threat to him. The respondent is creating all types of obstacles, hindrance and illegal acts in the matter of water connection to the A schedule property. Respondent appeared and filed the objection statement contending that the very application is filed with an intention to drag the matter and to cause delay. The present application is nothing but an adjournment application in disguise. Only with an intention to harass the respondent, the present application is filed, and only to mislead the court. The appellant himself disconnected the water connection illegally to other two tenements. First off, as against such act of the appellant, the respondent had filed complaint before the jurisdictional police station and his wife had filed complaint before the city corporation. First off, however, police had issued an endorsement stating that since it is a civil dispute and the same could be adjudicated before the civil court, the respondent had pressed for early disposal of the matter on 17/2/23. First off, however, the appellant had submitted to the court that they would argue the matter on next hearing date without fail. First off, on the next date of hearing, that is on 4/3/23, the present application is filed. If at all the appellants were really in trouble, then they would have sought for advancement of the case and filed the present application. Stop. If not, at least on 17/2/23, the appellant would have filed the present application, and the same was not done. And the application is filed belatedly with an intention to protract the proceedings. The trial court, having heard the appellant counsel and also the counsel appearing to the respondent, taking into note of the alleged disconnection of water on 5/2/23, and the present application was filed on 4/3/23. That is almost after 1 month. And even if really water was disconnected from water supply pipeline to A schedule property, no such delay has been explained. First up, by relying on photographs, it cannot be said that appellant has no water facility as pleaded. And taking into note of the said conduct of the appellant, dismiss the application and hence the present appeal is filed before this court. The counsel appearing for the appellant would contend that the application was rejected only on the ground of delay. And delay has not been explained. And counsel also produced photograph along with the memo before this court, pointing out that water connection is disconnected. The counsel would submit that the same may be restored and appeal can be heard on merits. For contra, the counsel appearing for the respondent used details of events. That suit filed by the respondent was decreed on 26/8/2023, and judgment and decree of the trial court was stayed on 4/1/2023. The counsel would contend that on 25/1/2023 itself, a complaint was given with regard to the disconnection of water in respect of other house by the appellant herein. ಅಲ್ಲರಿ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಅವ್ರು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದಾರೆ 2 ಮನೆಗೆ ಅಂತ ಹೌದಲ್ಲ? ಅದನ್ನೇ ಬರ್ತಿತ್ತು ನಾನು. And also council would submit that a new connection was given on 1/2/23. ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು new connection 1/2/23 ನಲ್ಲಿ. Respondent White filed complaint against the appellant before the Mangalore City Corporation on 8/2/23. That appellant has cut off the water connection pipe. And police complaint was filed by the respondent against the appellant as to cut off the water pipe. An endorsement was issued on 13/2/23. The appellant gives a statement before the police that he will not indulge in conflict with the respondents, and photos showing disconnection have been produced before the learned trial court. So, on the same day, appellant allegedly files a false complaint before the police on 14/2/23. Case was posted for arguments on 17/23. And the very counsel appearing for the appellant press time. And matter was urgent at the instance of the appellant only. And even not address the arguments on IA. And trial court taking into note of filing of objections on 15/3/23 itself. And when the case was posted for 28/3/23, the appellant himself has paid the time to hear on IS. And order was passed on 25/7/23. And present MFA is filed on 20/11/23. In spite of it, even really water disconnection was made. Appellant would not have kept quiet for a longer period, and only with an intention to protract the proceedings, the present application is filed before the trial court. Having heard the appellant counsel and also the counsel appearing with the respondent, it is not in dispute that the judgment and decree was passed on 26/8/22. And also it is not in dispute that the very judgment and decree was questioned in RA number 13/22. And also stay has been granted in respect of judgment and decree. When the stay was granted on 4/1/23, and when the matter was posted for arguments on main, and in the meantime, complaints are given by complaint was filed by the respondent before the Commissioner of Mangalore City Corporation on 25/1/23. And case of the appellant is also that water was disconnected on 5/2/23. On the other hand, new water connection was sanctioned on 1/2/23. And the respondent's wife also filed complaint against the appellant before the Mangalore City Corporation, alleging that appellant has cut off the water connection. And inter say there is a dispute with regard to the disconnection of water pipe, and also approach the police. But instead of filing a necessary application before the court, application was filed belatedly in the month of March. And the same is also taken note of by the trial court, having considered if really there was a disconnection of water, the appellant would have approached the court immediately, and complaint application is filed almost after 1 month. And apart from that, records also reveals that when the case was set down for arguments on IA, appellant ought to have pressed the application and instead of sought time. And matter was urgent at the instance of the appellant only. And when such being the case, there is a force in the contention of the respondent counsel that instead of arguing the matter on merits, he has come up with an application seeking an order of mandatory injunction to restore the water. And having taken note of said fact into consideration, though disconnection was made on 5/2/23, and almost an application was filed, that too for the restoration of water, even though claims that they are residing in the very same building. Without the water, they were staying. And the application was filed after 1 month. And after 1 month filing of the application, also not pursued the matter on IA and also on main appeal. And when such being the case, I do not find any force in the contention of the appellant counsel to set aside the order passed by the trial court. However, taking into note of already matter is pending for before the appellate court, and matter was urgent at the instance of the appellant when the appellant sought time. It is appropriate to direct the first appellate court, the appellate court to dispose of the appeal within a period of 1 month from today. Both the parties and respective counsels are directed to assist the first appellate court in disposal of the main appeal within time bound period. ನಿಮಗೆ ಬೇಕಾಗಿರೋದ್ರಿ ಈಗ ವಾಟರ್ ಇಲ್ಲ ಅಲ್ಲ ಈಗ ಮತ್ತೆ ಎಲ್ಲಾನು ನೀವೇ ಕೇಳ್ತೀರಿ. ಅಲ್ಲಿ ನೋಡ್ರಿ ವಾಟರ್ ಇಲ್ಲ ಅಂತೀರಿ, ಮೇನ್ ಅಪೀಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಅಂತೀರಿ. ಏನಿದ್ ನಿಮ್ದು? ಈಗಲೂ ಟೈಮ್ ಬೌಂಡ್ 1 month ಕೊಟ್ರೆ ಅದನ್ನು ಬೇಡ ಅಂತೀರಿ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನಿಮ್ ಪ್ರಕಾರ ನೀರಿಲ್ಲ, ವಾಟರ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಾರ. ಇಟ್ ಕ್ಲಿಯರ್ಲಿ ಶೋಸ್ ದಟ್ with an intention to protract the appeal only, your client has filed an application under for restoration of water. ಬೇಡವಾ? ನನಗೇನಿಲ್ಲ, ನಿಮ್ಗೆ 1 month ಬೇಡ, ಇನ್ನೊಂದು 1 month ಕೊಡ್ತೀನಿ ಜಾಸ್ತಿ. ನಿಮ್ಗೆ ತಾನೇ ನೀರಿಲ್ಲದೆ ಇರೋದು. 1 month ಬೇಕಾ, 2 month ಬೇಕಾ? 2 months ಆಯ್ತು. 2 months ಆಯ್ತು. 2 months. ಪ್ರಪೋಸ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂದ್ರೆ ಬಟ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು ನೀವ್ ಇರ್ಲಿಲ್ವಾ? ಪ್ರಪೋಸ್ ಡಿಫೆಂಡೆಂಟ್ ಆಗಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ರಿ. ಹಾ, ಪ್ಲೇಂಟಿಫ್ ಹಾಕೊಂಡಿದ್ರು. ಆಯ್ತು. ನಿಮ್ಮ ಅಯ್ಯ ಅಲೋ ಆಗಿರ್ಲಿಲ್ವಾ? ಹಾ, ಮತ್ತೆ
not to put up construction over the property because the defendant putting up by the time on the condition of the plaintiff and defendant the interim order came to be passed.
ಈಗ ನಿಮ್ಮ ಮೇಲೆ ಏನ್ ಪ್ರೇಯರ್ ಇದೆಯಾ ಅಯ್ಯನಲ್ಲಿ against you? How they can seek the relief unless you have been added as party in the suit?
Even there is no prayer in the application also, my lord.
ಈಗ ನಿಮ್ಮ ಮೇಲೆ ಪ್ರೇಯರ್ ಇಲ್ಲ ಅಂದ್ರೆ how you are agreed by the order, counsel? ನೋಡ್ರಿ, putting up of construction in item number 3 property. Item number 3 is the land survey number 54/10 so and so. ಹಾ, ಇಲ್ಲಿರೋದು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅಂತ ಇದೆ, ರಿಸ್ಟ್ರೈನಿಂಗ್ them from putting up construction. Defendant and the proposed defendants are restrained by way of temporary injunction from putting up of any construction item number 3 property till disposal of the suit.
That affected being what is the photograph because it's not the book. It is about to put a mold by the time about the interim order was passed due to the no objection made by the defendant because the trial.
ಆಯ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ ಅದರ್ ಸೈಡ್. ಆಗ್ಲೇ ಎಲ್ಲ RCC ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
RCC ಆದ್ರೆ ನಿಲ್ಸ್ಬಿಟ್ಟಿಲ್ಲ ಈಗ interim order ಆಯ್ತು. ಹಾಗೆ
ಏನ್ ವಾಟ್ ಇಸ್ ದೇರ್ ಕ್ಲೈಮ್? ಎನಿ ಆಫ್ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ RCC ಆಗಿದೆ ಈಗ. ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ, ಹಿಯರ್ ಮಾಡೋಣ. Sorry, opponent counsel is directed to serve the copy of this appeal memo on the counsel appearing for the respondents before the trial court and list this matter. ಯಾವತ್ತು ಮಾಡ್ಕೊ ಬರ್ತೀರಾ? 26th ಆಯ್ತು. 26 to.
But in serial number 40, I appear for the appellant's counsel. Order under challenge is an order where my application under section 8 of the Arbitration Conciliation Act is dismissed. What had happened was that the parties had entered into first of all an MOU.
ಏನ ಕೇವೇಟ್ ಹಾಕಿದಾರಲ್ರಿ ಇಲ್ಲಿ? ಕೇವೇಟ್ ಯಾರು ಇದಾರೆ? ಅನೀಶ್ ಆಚಾರ್ಯ
ಅವರು ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ, ಅವ್ರು ಬಂದಿದ್ದಿಲ್ಲ ಅಂದ್ರೆ ತಾವು ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ we will my lord.
ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದಿರಿ ನೀವು?
ಒಂದು 2 ವಾರ ಮೇಲೆ perhaps I'll just request the instructing counsel to point out to your lordship. ಒಂದು 2-3 ವಾರ ಮೇಲೆ ಆಗಿರ್ಬೋದು.
ಯಾವಾಗ್ರಿ? 31st January. Physical as well as email. ಹಾ ಆಯ್ತು, ಹೇಳಿ. ಅವ್ರಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ನಾವ್ಯಾಕೆ ಮಾಡ್ಬೇಕು? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಅಲ್ಲ ಅಂದ್ರೆ there are two things. One, there is an interim order in that suit. Really speaking, that interim order is
number 3.
ಹೌದು. ಅದರಲ್ಲಿ now the submission to the court is this: the exact same properties that are subject matter of this.
IA3 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಲ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ, ನಮ್ಮ IA
Trial court ಅಲ್ಲಿ.
ನಾವು
ನಿಮ್ಮ IA
ಡಿಫೆಂಡೆಡ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ನಿಮ್ಮ
ಸೆಕ್ಷನ್
IA
8
ಏನು?
ಹಾಕ್ತೀವಿ.
Oh, section 8 application was dismissed.
ಅಪ್ಲಿಕೇಶನ್ ಅಂಡರ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಆಕ್ಟ್ ಅದ್ರ ವಜಾ ಆಗಿದೆ, ಅದರಿಂದ ಅಪೀಲ್ ತಮ್ಮ ಮುಂದೆ ಬಂದಿದೆ.
Told. The appellant counsel is present and KVTR counsel is absent, and counsel for the appellant counsel submit that copy, the physical copy was served in the end of the month of January. And also the same is sent in the email, and the respondent counsel is absent, and if respondent counsel doesn't appear in the next date of hearing, the matter will be heard in his absence. List this matter in the 4th week. You are appearing for respondent? List this matter 4th week of February. At this juncture, counsel appearing for the respondent appears and seeks 1 week time to file statement of objections to IA 1 of 2024, and hence list this matter in the 4th week of February.
Oh, great.
Hmm.
Same is executed in the year
2013.
23 they filed a suit. Conciliator is appointed by both the parties. There is an award passed by the conciliator in the year 2013. They suppress that and filed this suit on the premise that certain amounts were transferred on the 22nd of July 2013 and they were not aware. Now the cause of action for this suit is the appellant who is now no more. He said he wants to mortgage the property. So in the circumstances, they have now come to know they have been terminated. That is this. They suppress the settlement deed. I have produced the settlement deed even before the trial court, even before this order of the court, where how the sale deeds were executed, everything is explained. And it is also stated that this is being a final settlement between the parties. Every year they continue to run the firm. Every year their accounts are filed. They say they have no knowledge that this amount of 12 crores was transferred, a part of the sentence.
Where is the document of settlement? Where is the document of settlement?
Starts at page 88.
$188.
Kindly take
No such 188 page.
Sorry.
ಇನ್ನೊಂದ್ರಲ್ಲ
Common order.
ಎರಡು petition ಇದೆ,
ಎರಡಲ್ಲ ಮೂರಿದೆ ಮೇಡಮ್.
ಅದೇ ಸರ್, ಇನ್ನ ಎರಡಿದೆ.
211 page number.
Page number 188. This appeal arises from the order.
State settlement deed.
How? The part 3 of
This is dated, counsel. This is dated. This is dated July
22 July, but it is notarized on
2013.
executed on the date. Page 206 on 19/8/2013. Date of execution is 19th August 2013. At page 206.
Yes.
The alleged illegal transfer of 12 crores and all is on 22/7/2013.
13.
22/7, 1 month before this date.
Document.
ಈ ಡೇಟ್ ಯಾವತ್ತು ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಯ್ತು ಅದಕ್ಕಿಂತ 1 ತಿಂಗಳು ಮೊದಲು ದುಡ್ಡು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ. No correspondence between the parties that they ever asked for this money. For 11 years now, there is no correspondence. Number 1. Number 2, If they say illegally he has transferred certain amounts, a suit for recovery would like.
Hmm.
Number three, a sale deed is executed. Sale deed is void and sale deed cancellation can until
Hmm.
he was sued for bare injunction after 11 years after executing this settlement deed.
Hmm.
And in
Where-
the sale, in the sale,
Where is the
sale
prayer? Where is the
consideration
where is the prayer in the plaint?
paid.
Prayer in the plaint. Memorandum of plaint, page 56, starts from 56.
And 63 is the sale.
Permanent land, only permanent injunction suit.
How. And that too after 11 years. 10 years.
There is a sale deed. And apart from that, there is a conciliation settlement deed also. Hmm. Hmm.
And why the sale deed, that is the transaction agreement, the settlement. It's not in compliance with section 54 of transfer of property.
Hmm.
Therefore, it is not a sale. Both are all conjoined read together. It
Hmm.
merely becomes an agreement which is being performed.
Hmm.
And the sale consideration of more than 12%, or more than 80% of the sale consideration illegally transferred.
Hmm.
I showed you the relationship between the plaintiff, the appellant and the responsible.
Like, why you are not stated with regard to this conciliation deed in your plaint? In your plaint,
Consideration document which is beneficial to me.
or whatever it may be, why you are not pleaded? Why you are not pleaded the same?
I have not had a copy of the lordship. And most of your lordship, I admit the entire contents of settlement deed.
Hmm.
I never denied the settlement deed at all.
Hmm.
As soon as I produced in the trial court, I have admitted to it, and the settlement deed is actually beneficial to me.
Hmm.
I point out why it's beneficial.
Hmm.
Their cases were suppressed. It's not a suppression. Actually, a settlement deed makes my case better.
Hmm.
I convinced your lordship on the law on maintainability and this one.
What is that maintainability?
Their condition is suit for their intention. And that only this one declaration for cancellation of sale. But sale deed itself doesn't fulfill section 50 for transfer of property. Therefore, there's no sale at all. Sale is void. If at all, if it's any remedy they have,
Even sale is void. Have you sought for any declaration?
but that is very natural. There's no declaration required, and the sale deed itself is void.
How you seek a relief of permanent injunction only when by terming the sale deed as void?
So your lordship, I will convince your lordship
Huh.
to produce a citation.
And we see paragraph 7 of the plate at page 58.
Lordship, I
They
convince-
themselves say,
Right, let him complete first, then I will hear you. 58,
page 58.
Paragraph
7.
7. Plaintiff states that defendant thereafter expressed his desire to retire from the partnership.
And the two respondents were all partners in the firm Restaurants Developers.
Hmm.
Respondent, the firm is the respondent now, it consisted of two partners who are brothers, and the appellant was the other partner. Now, in the paragraph 7, they themselves say, the plaintiff states that the defendant thereafter expressed his desire to retire from the partnership firm and represented that the defendant does not wish to participate in the daily affairs of the partnership firm. And the defendant requested the partners of the plaintiff firm to register 2 apartments in favor of the defendant in lieu of the contributions by the defendant to the partnership firm and additional contribution of rupees 12 crores 26 lakhs 59,601. And by the defendant on 22/7/2013 for registration of the sale deed, construction agreements, and for retirement of defendants from the partnership firm. Let me see the previous paragraph of paragraph 6. Because this 12 crores, the earlier, actually the appellant had paid for the land, the stamp duty, everything, then these apartments were to be constructed through the firm. Now kindly see paragraph 6. The plaintiff submits that during the course of business,
The partners of the plaintiff firm and the defendant contributed funds to the partnership firm through Messrs Integrated Construction Firm, where the defendant and Mr. Avinash Prabhu, one of the partners of the plaintiff partnership firm, were the partners. That the said firm received from the said integrated construction firm was considered investment to the plaintiff firm. And that is why in paragraph 7, in lieu of the contributions by the defendant to the partnership firm. Then again, they claim at paragraph 11 of the claim. Can you tell me paragraph 11? Plaintiff states that as per the partnership deed dated 27/1/2007, the entire maintenance and sole signatory of the bank account of the partnership firm was with the defendant. That to the utter shock of plaintiff after execution of the aforesaid two sale deeds and construction agreements on 24/7/2013, and after taking over the management of the firm, came to know that 2 days before execution of sale deeds and construction agreements, defendant has illegally transferred funds of rupees 12 crores 26 lakhs 59,601 from the firm's account to defendant firms Messrs. Jindal Steel without the knowledge of the plaintiff firm, partners, and misrepresent to the partners of the partnership firm, the defendant shall relinquish his contribution to the firm in lieu of the 2 apartments conveyed to the defendant. Okay, pause here. For a minute, let us accept this fact. Though this is all fraudulently stated after a period of 11 years. Let me accept it for argument's sake. Then you have to file a suit on accounts. Somebody has siphoned out money from the partnership. You continue to be partners. Year after year, you have filed returns. It is not, you cannot say now that no, we did not know that 12 crores was transferred there, which is a total lie. And even if it is admitted that he had siphoned away, what were you doing for 11 years? And you should file a suit for against the firm for recovery of for accounts and for recovery of the money. Sale deed is executed, their admissions are made that the entire sale consideration has been paid. That sale deed came to be executed in lieu of the settlement between the parties and his contribution of monies. Now after 11 years, you wake up and say, no, that plate also is admitted the entire receipt of sale consideration. Unfortunately, the learned judge accepts their contention and says it is void, they cannot seek for a cancellation. Contrary to the judgments of the Supreme Court, which say that once a sale deed is executed and a part of the consideration is not paid, you will have to file a suit only for recovery of that amount. And if you want a declaration, you will unknown declaration. Can you see paragraph 30?
11 ವರ್ಷ ಆದ್ಮೇಲೆ ಡಿಕ್ಲರೇಷನ್ ಅಲ್ಲ, ಅದು ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್.
Settlement deed was there. You shock any person's conscience. Everything is settled. And they say after this there will be no distinction between the parties. Unknown suit again. And unfortunately, even to pass, vacate the order, we have to approach this one to court and see that the learned judge takes up the matter. Can you see paragraph 13 and page 16? Plaintiff states, defendant is taking advantage.
Paragraph?
Paragraph 13, page 60. Plaintiff state the defendant is taking advantage of the sole signatory powers of the firm's bank account conferred under the partnership deed dated 27/1/2011. Defendant has deceived plaintiff to believe defendant is relinquishing his contribution, including the sum of rupees 12 crores 26 lakh 59,601 contributed to the firm to execute sale deeds and construction agreements in favor of defendant. At the same time, taking away the contribution from the firm illegally by transferring rupees 12 crores 26 lakhs 59,601 to defendant's firm as a Tindal Steels in order to enrich itself. Total sale consideration for the two sale deeds is 16 crores and odd. Even if 12 crores and odd had been clandestinely transferred, still a consideration of 3 crores and odd is admitted. Once a part of the sale consideration is admitted, a document cannot be treated as void. You have to seek either for a cancellation or a declaration. Okay, and apart from that, if a part of it has been paid, according to guidance case, you will have to only file a suit for recovery. And that judgment was produced before the trial court. He brushes it aside. He does not even, he just says these documents, citations should be used. Kindly see 14 how they explain it. It's correct. The plaintiff states that when the partners of plaintiff firm confronted defendants on the aforesaid matter, defendant informed plaintiff that defendant shall not claim ownership of the scheduled property as he has withdrawn the funds from the partnership and have not paid any sale consideration under the sale deeds dated 24/7/2013 and construction agreement dated 24/7/2013. No material is produced before the court, even this court, no material is produced to substantiate this. Can you see the next paragraph? The plaintiff states that believing the aforesaid words by defendant, the partners of the plaintiff firms called upon the defendant on several occasions, no material, to come forward to cancel the two sale deeds dated 24/7/2013 and construction agreements dated 24/7/2013. However, defendant has never come forward to execute the cancellation agreement and has shut all channels of communication with plaintiff. It itself is admitted in this paragraph. Document requires a cancellation. Can you see the cause of action? Usually cause of action. Cause of action, paragraph 24 at page 62. Cause of action goes on when the defendant on 19/6/2023, when defendant says to the suitable property and are claiming rights based on the sale deeds dated 24/7/2013, threatened the engineers in the suitable property and that the property belongs to the defendant, and on 21/6/2023 and 22/6/2023, defendant's henchmen contacted partners of the plaintiff firm, so and so, through phone and WhatsApp, and informed that certain bank officials are coming to visit the suitable property to inspect, and when defendant and his henchmen are illegally trying to claim ownership of the suitable property, and it has come to the knowledge of the plaintiff that the defendant has been trying to mortgage and alienate the suitable property, and when the plaintiff issued a legal notice dated so and so, this will continue. Injunction cannot be started against the rightful owner. High Court has chosen to do so. And co-owner, in respect of the undivided interest in the land, they are co-owners. Now, kindly, I straight away take the court to the settlement deed. It's
Hmm.
The next page, 108.
Hmm.
The sale deed came to be registered on 31/7/2013.
Hmm.
7. These are page 112.
Yes.
31/7/2013.
Hmm.
The so-called transfer clandestinely is supposed to have been made on 22/7/2013. That I need to know because they were the continuing partners of the firm. Till 31st, they should have come to the registration account. Then the next sale deal, at page 126. This is also 24/7. Registration date, the 17 and 131. And the construction. 135. 138. This is 138. 135, 138. And the construction agreements. 147. 24/7. In of execution. Registration. Thirty-one seven. Then. Next construction agreement is 24/7. It's 167.
Hmm.
It is still out 31/7. Page 172.
Yes.
Showing all this because these two flags in terms of the settlement on his contribution were considered as full and silent settlement and he retired from the firm. The dates I am mentioning because 22/7 they say clandestinely we had removed, so we did not know on 24. And all these documents are executed 10 days later and then the interim balance sheet is signed by the parties on 24/7, which is evident from the settlement deed. Settlement deed starts at page 188.
Yes.
This settlement deed. Okay.
One. Settlement deed, ಇದೆ.
This settlement deed reached as provided under part 3 of the Arbitration and Conciliation Act 1996 on the 24th day of July 2013 at Bangalore. This is between the deceased appellant and the two continuing partners of the respondent. In 189.
Hmm.
Yes. And you see paragraph 6, Roman 6 at page 192.
Hmm. 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 Hmm.
It is agreed by the parties that Jindal shall retire from rest house developers as stated hereinafter, and that in full and final settlement of his claims for use and in consideration of the investment made by Jindal in rest house developers being more than 70% utilized for purchase of the rest house land, Avinash Group being the continuing partners shall complete the development of Villa Maria at their own risk and cost on or before 18 months from the date of execution of this deed by 23rd January 2015. It was here. Even as of today, that construct not today. And in terms of this deed, I'll point out, they were not to take any other partners. Even that they have floated, we have come to know in 2020, they have taken some other partner. Whatever money was there in the, they come to know now that in 2020, they have taken some other partners, contrary to the settlement arrived at between the parties. Now, and I read the rest of the paragraph. As group being the continuing partner shall complete the development of Villa Maria at their sole risk and cost on or before 18 months from the date of execution of the deed by 23rd January 2015, which shall be as per the said transactions and thereafter delivered to Jindal or his nominees in pursuance to this settlement. 5,971 square feet or 36.25% of undivided share in the rest house land, which is more fully described in Schedule B hereunder, along with the right to own 2 residential apartments, being a penthouse, flat number 6 on the on the 4th floor, measuring 9,633 and measuring so and so. A big area with 8 covered parks, which is more fully described in Schedule C. At number 2, it is mentioned. Within the completion date of Villa Maria was also agreed that for any delay thereafter in delivering vacant possession of the said apartments, along with all licenses, permissions, amenities, and specifications, built completely as per law with an occupation certificate, Avinash Group shall be jointly or severally liable to pay Jindal a sum of ₹20,000 per day of delay without any tenor. In continuation with the settlement of accounts of the firm, rest house developers, the parties keeping in mind that Jindal had invested more than 70% of the money used by the firm towards the cost of purchase of the rest house land, therefore, in order to secure the performance of the obligation as stated supra, Avinash Group stroke rest house developers have agreed to deposit the original title deeds of the rest house land in the manner set out below, and also execute and register the sale deeds for conveying the undivided share of land described in Schedule B to Jindal or his nominees immediately, and agreements for construction of the apartments in Villa Maria for Jindal. Avinash Group has also agreed not to create any encumbrance on the rest of land prior to delivery of apartments in Villa Maria for Jindal, and they shall not execute any sale deed prior to that in favor of any third party without the consent of Jindal. Further, Avinash alone shall be responsible and liable at the risk and cost to meet the obligation of the confirming party to the sale deed of rest house land without any sort of recourse to Jindal whatsoever. Before the foregoing, Jindal has signed the retirement deed, retiring from the rest house developers until the completion of the project. Villa Maria Avinash Group shall not induct any new partners. However, from this date, Avinash Group can operate the bank account of rest house developers and issue checks. ಅವತ್ತಿದಾದ್ರೆ 11 ದುಡ್ಡು ನಾವು ಕ್ಲಾಂಡಸ್ಟೈನ್ಲಿ ರಿಮೂವ್ ಮಾಡಿದ್ರೆ I will show even they have paid TDS. We have got the TDS certificate for that amount. In September, they have paid the TDS also. For meeting the development cost of the project as a partner of the firm. Then kindly turn to paragraph 9. The aforesaid facts are being narrated to place on record as the same are undisputed by the parties, and that the parties have acted upon the same, and it is pursuant to the foregoing that this deed is being executed. In all the meetings held between the parties, Avinash Group was represented by so and so, and Jindal was represented by so and so himself. The parties have delivered all such deeds and documents to to the conciliation as cited in annexure E appended here too. You kindly see 1.2 below the last question. The consideration agreed to be paid for Jindal retiring from the firm rest house developers. He arrived at by keeping in mind that he had invested more than 70% of the funds to rest house developers for purchase of the rest house land. And kindly turn to 1.5. Parties agree that the method of arriving at the consideration payable and which is payable to the parties interested is fair and correct, and the method shall not be questioned at any future point. The parties affirm that they have acted in good faith and that all deeds and records produced by each party on which premise this deed is entered into is true and not false, and in case the same deed proved to be false or a concocted document or deed, the enforcing party shall have the right to relief as provided under law. An agreement between two business persons will organize. In return to Article 5 at page 198. 5.1. 5.1. Jindal has invested in the firm rest house developers a sum of rupees 16 crores 9 lakh 4,806. This is in his personal capacity, Mohanlal Jindal has invested. In view of the settlement and as per the investment made in the firm by Jindal Infra, the scheduled B and C property is being conveyed to Jindal or his nominees, and the balance sheet of rest house developers dated 31/3/2013 and the interim balance sheet dated as 24/7/2013 has been signed on this day. Either produce model. In consideration of the investment made by Jindal in the firm and in full and final settlement of Jindal, the rest house developers have on this day executed and registered the sale deed to convey undivided share of land as described in Schedule B to Jindal or nominee, and also executed two construction agreements to construct and deliver the said apartments. Describe the Schedule C herein to Jindal nominee. Firm rest house developer has now been reconstituted as Avinash Group by Avinash Group, executing a fresh partnership deed with Jindal as a consenting witness. In the said deed, it is recited that Jindal has resigned from the firm under the settlement deed upon the undertaking by Avinash Group as recited here. Until completion of the project, Villa Maria as certified by the consolidator, with the assistance of any project management company it chooses, Avinash Group shall not induct any new partner in the rest house developers, create any encumbrance of third party rights in the rest house land. 5.6. Avinash Group has deposited the title deeds of rest house land with the conciliator and shall be entitled to collect it back upon delivery of the apartments in Villa Maria to Jindal with the completion of date of Villa Maria. It is agreed that as and when the obligations are fulfilled, as mentioned supra, more specifically when Avinash Group stroke rest house developers is ready to deliver the apartments in Villa Maria for Jindal as certified by the conciliator, Avinash Group shall intimate the conciliator to release the title documents of the rest house land. As and when the project Villa Maria shall be complete in all respects, as per the design and specifications appended here too, and built according to the local laws and in compliance thereof, and being issued a license by all the statutory authorities, use and occupy the entire building shall be deemed to be that day when the project Villa Maria is ready for occupation by Jindal or nominee, and that shall be certified by the conciliator. Prior to taking delivery of the property, documents of the rest house land from the conciliator, Avinash Group shall obtain any penalty to pay. Then again, 5.12. Avinash Group is entitled to any agreements and receivables from the interested party for the flats proposed to be developed in project so and so, in which regard 100% of the receivable shall be entitled to the sale deed shall be executed only after delivery of the apartments in Villa Maria to Jindal. Then again, 7.3 is 201. This settlement is binding on each party hereto upon signature. Initialing on each page confirms that such clause accurately confirms the settlement terms. Again, at 202, the parties have on this day duly approved the execution of the settlement deed and have authorized the conciliator to execute the settlement deed. And then 7.7 and 7.6, and then just one line. The terms of the settlement deed shall have immediate effect. The fulfillment of the terms of the settlement deed as set out herein shall be full and final settlement of all claims by each party or the other in relation to the agreement and MOUs between the parties and the scheduled property. That this deed is executed in the presence of a notary public and made in 3 sets and registered as per the Karnataka Stamp Act in 1 set for each party hereto. The friend just said that they didn't have the property. They had a ಇದಿಷ್ಟೆಲ್ಲ beneficial and ಅವ್ರಿಗೆ. How is it beneficial? Then this document is executed at page 206. 19/8/2013 is notarized. Executed. On 19/8/2013. This is the date which has to be taken. Then, what documents are issued? Sets of parallel broadcast. One with Moonlar Jindal as inclusion. That is the appellate, deceased appellate. One with Jindal Steels. So Jindal Steels already page 222. They have produced the letter report which they have themselves maintained of Jindal Steels. First April 2005 to 31st March 2018. Much after the appellant left the entity. Kindly see at page 223, opening balance of 1/4/2013. Opening balance 12 crore 26,69,601.34 paisa. Credit of respondent from Jindal Steels. That is transferred on 8/7/2013 back to Jindal Steels. How they ledger, how maintain money. Then again, the next one is Restos Developers. At page 24. They are maintained of Jindal Steels from 1st April 2011 to 31st March 2018. Either to 8/7. Credit entry is there. All the other credits are there.
Hmm.
Document 25. General voucher of- Take by respondent. Source, the legal states and paid a sum of rupees 4 crores.
25.
Number matches with the city. Then the next one is stamp duty, 1 crore 28 lakhs. ಅದನ್ನು ಇದರಲ್ಲಿದೆ. Then meanwhile, settlement deed talks of balance sheet. Balance sheet, one is interim and one is 31. The balance sheet one thing was produced by today. At page before the trial court also was produced again. Page 227 is the memo. To show that it was produced even before the trial court. And is signed by all the partners, 10 partners of resource development. Really, 34 rooms. This is their own signed balance sheet. Item 2, long-term borrowings. ಅದರಲ್ಲಿ ಒಂದು unsecured loans from partners. Moon law general ಇದು at profit. ಅವಿನಾಶ್ ಪ್ರಭು ಇಷ್ಟು, ಧೀರಜ್ ಪ್ರಭು ಇಷ್ಟು. 34 lakhs, 3 crore 82 lakhs 45,205. That is the contribution by Moon law general in his personal capacity. As of 31st March 2013. Then again, other two partners ಇದೆ. ಆಮೇಲೆ ಜಿಂಡಲ್ ಸ್ಟೀಲ್ ಬೇರೆ, ಜಿಂಡಲ್ ಸ್ಟೀಲ್ಸ್ ಕೆಳಗಡೆ ಆಗ್ತದೆ. It is not from the partners, it is from ಜಿಂಡಲ್ ಸ್ಟೀಲ್ಸ್ ಅಂತ. ಹೌದು, 12 crores 26 lakhs 59,601. This is the exact amount which they claim was clandestinely transferred by Moonlight Jindal to Jindal Steels. It is signed by all the parties. This they are trying to mix up and say whatever Jindal Steels has got nothing to do. Jindal Steels had invested on its own certain monies, which amounts were paid back when Moonlight Jindal retired. This is that amount of 12 crore 26 lakh 59,600. Then again at page 239. ಗೊತ್ತಿರಲಿಲ್ಲ ನಮ್ಗೆ ಇವಾಗ ಗೊತ್ತಾಯ್ತು ಅದು ಇದು ಅಂತಾರೆ. Or they say that we have told them, we have sent it to them, we came to know. That they have claimed that Mohanlal Jindal used to manage the accounts. Rest house developers on 14 September 2013 on page 239 has paid TDS of 14 September 2013. Jindal in favor of Jindal Steels. Because these TDS certificates, the board is aware, can be downloaded by anyone. This amount had been clandestinely transferred. Then why did they pay TDS? Stores developers ledger report, mail notice of Mohanlal Jindal. This is of Mohanlal Jindal as an individual. 1st April 2005 to 31st March 2018. They say that 3 crores. This is 2013 he retires. How much after he left, they have provided this ledger report. 1/4/2013, opening balance 82,45,203. Tallies with the balance sheet. And then 12 crores 26,59,600 month. They have been received to rest house developers from more large. Then the flats are registered. They show it as debit 16 crores 9,04,200.
That's fine.
Additional documents same. All these documents were placed before the time. Waiting.
Fifth February. Hmm.
First document is the journal voucher
Hmm.
showing the initial of the respondent, showing the initial contribution, 3,67 lakhs 38,000. It's all to fortify the earlier. I know several documents are there. This is again. And the second document is Jindal State's ledger account maintained by rest of developers, which again there is a April 1st April 2007 to 31st March 2000. Tallies with the ledger. The relevant is at page 7. First April 13 to 31st March 2015. 12 crores 26 lakhs in it is there, it's credited later. Then on 22nd July 2000. The bank account statements have been produced in order to show Jindal Steels has had several transactions, a lot of monies have been deposited into the respondent. But, legal notice concerned. Even before the legal notice is delivered on us, they file a suit.
Hmm.
It's delivered on 25th, page 31. And the suit is argued on 24. What was the burden of it? Sir, WhatsApp messages are also produced. On the document that legal notice is only a ruse in order to file the suit. This is the sale deed. Other extent of the property page 34, known large in the appellant, deceased appellant is said. So that state consideration. State consideration and stamp duty is paid by the appellant and the page 39. PG number matches with the journal also. Even the stamp duty and the consideration. Quotes by demand draft on page 44 and come on. This matches with the general voucher which they will be. This WhatsApp message is also used at 49. So other question is we will like to make it in again.
Because Kamlar Jindal was alive and he was in ICU and they needed money from the street. That was the reason why they wanted to mortgage the property. That is why this, it was a construction site, even till today, no construction has been done. In spite of all this. It is abandoned by them that siphoned out the money. It's pigment.
33.
It's 33 in sugar. It started 46. Seventeen.
Yes.
That of meticulous observation of all the materials placed, especially the sale deeds and construction agreement. The total consideration towards the two registered sale deeds and the two registered construction agreement by the plaintiff firm in favor of the defendant cumulatively would be 16 crores 9,04,806, which is exactly the amount the defendant claims to have invested or contributed in the plaintiff's firm as per the settlement deed dated 20. Article 5 of the settlement deed provides that Mr. Jindal has invested in the firm rest house developers of rupees 16 crores 9,04,806. And in view of the same, the schedule B and C properties were being conveyed to Mr. Jindal Steel and this is wrong. Because the property was conveyed to Mohanlal Jindal or his nominees in terms of the settlement deed in his individual capacity. Sale deed also depicts that. Current judge and misconception says it is Jindal Steel. And the balance sheet of rest house developers dated 31/3/2013 and the interim balance sheet of 24/7/2013 has been signed on this date. Therefore, it clearly establishes the fact that the partners of the plaintiff firm Mr. So and so have executed the said two sale deeds and two construction agreements in favor of the defendants towards his contribution of rupees 16 crores 9,04,906. Significantly, it is pertinent to note that out of the defendant's contribution, so the learned judge arrives at the conclusion we have contributed 16 crores in this. Significantly, it is pertinent to note that out of the defendant's total contribution of 16 crores 9,04,906, the defendant has transferred rupees 12 crores 26 lakhs 59,601 to the plaintiff firm on 22/7/2013, and thereafter on the same day, the defendant in his capacity as the partner of the plaintiff firm transfers the same amount to Jindal Steel. It is admitted that the full consideration ಬಂದಿಲ್ಲ ಅಂತ ನಾವು ಹೇಳಿಲ್ಲ. 12 ಕೋಟಿ ಚಿಲ್ಲರೆ ಮಾತ್ರ ಅವರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು. So that means that 3 crores and what has been paid. A part of the sale consideration has been paid, even if we believe their person, which is untrue in the documentation. Based on which, how was the present suit maintainable to treat the document as void? He should have, rightly or wrongly, he should have sought for cancellation or for a declaration or a higher suit for recovery of the funds in view of guidelines.
There is no limitation because 2013 ಇಲ್ಲಿವರೆಗೂ ನಿದ್ದೆ ಮಾಡ್ತಾ ಇದ್ವಿ ನಮ್ಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ. So now they have this ingenious way of filing this. And thereafter on the same day the dependent in his capacity as partner just 2 days. More so the dependent has transferred the said amount to Mr. Jindal Steel just 2 days before the execution of the 2 registered sale deeds and 2 construction agreements by the plaintiff were in favor of the dependent. May possible. The sale deed shows that the document was not registered on 24. One document came to be registered on
30th and 31st.
another that 1st August and one on 31.
Hmm.
Thereafter, the settlement is 1908. They had all the time in the world to find out any such clandestine activity at taken. They signed the interim balance sheet on 24/7. Then again, paragraph 26. 20, I read 24, 25 and 26. Further, the defendant in his affidavit submitted that in view of the said investment by Jindal Steel in the plaintiff's firm right from the year 2007, the plaintiff has transferred a sum of rupees 12 crores 26 lakhs 59,601 to Messrs. Jindal Steel along with interest with the full knowledge and consent of all the partners. It is clear from Article 5 of the settlement deed dated 24/7/2013 that the total contribution of the dependent in the plaintiff firm is 16 crores 9 lakhs 4,906. And out of the said investments through contribution, 12 crores 26 was made on 22/7/2013 to the plaintiff firm. Surprisingly, the dependent being one of the partners has transferred 12 crores 26 lakh 59,000 to Messrs. Jindal Steel on the same day. This is quite contrary. Learned judge does not even bother to look into the documents which are produced in order to demonstrate that Jindal Steel had a separate running account with the rest of developers, and in lieu of that, that amount was returned. They had a separate transaction. All the settlement and the apartments being delivered was in lieu of Mohanlal Jindal having purchased it and having. However, the said fact is not coming forth in any of the documents. He doesn't bother as to how those journals, those ledger accounts of the different bank statements, balance sheet are. He refuses to look into any of those documents. It's not something in cash which is done clandestinely. All these transactions are legal transactions. Further, it is also not coming forth as to whether the plaintiff firm has executed 2 registered sale deeds and 2 registered construction agreement in favor of dependents towards the contribution made by the dependent, excluding the money of 12 crores 26 lakh 59,601, which was transferred to Mr. Jindal Steel by the dependent in the capacity as partner of the plaintiff firm. Further, the plaintiff contends that the sale of immovable property has to be for a price, and if the sale deed in respect of an immovable property is executed without payment of price, and if it does not provide for payment of the price at a future date, it is not at all valid in the eyes of law. May I pause here? The learned judge under the misconception, he himself says 16 crores. 16 crores is the sale consideration, out of which only 12 crores is transferred, even if it is accepted, it is true, in spite of all the documents produced. So 3 crores and all is paid towards the sale consideration. So in the circumstances, it cannot be void, the document cannot be void. You will have to either seek for a cancellation, in view of the fact that part of the sale consideration is paid. The apex court would say you can only file a suit for recovery of the amount. It is not, it is of no legal effect, and therefore such a sale will be void. In his support, he has relied upon the judgment of Honorable Apex Court decided in so and so on 22/11/2021, wherein it is held that payment of price is an essential part of the sale covered by section 54 of the TP Act. If a sale deed in respect of immovable property is executed without payment of price, and if it does not provide for the payment of price at a future date, it is not a sale at all in the eyes of law. It is of no legal effect. Therefore, such a sale deed will not affect the transfer of immovable property. On the other hand, the defendant has relied on the judgments reported in so and so, Ella Helter. However, under the how it is not applicable, nothing is explained. No discussion about the documents produced in respect of the any of the documents, and no discussion about any of the citations that are produced which go to the point. Now I produce the same citations here also.
Yes.
Five were produced before the trial court. Additional 4 have been produced here.
Yes.
The entire sale consideration for registered sale deed is not paid. Remedy lies in law. And summary was also given. The learned judge takes the trouble of quoting the other judgment produced by them. At least a summary in our report and say how it does not. Internal page 10. Internal page 10, paragraph 1. Analysis and findings.
Yes.
Internal page 10. Analysis and findings. We have carefully perused the elements in the claim, read with the documents relied upon. On the reading of the plaint and the documents relied upon, it is clear that the plaintiff have admitted the execution of the registered sale deed dated 2/7/2009 in favor of the defendant number 1, respondent number 1. Herein, paragraph 5 of the plaint reads as, thus, subject of the aforesaid terms, the plaintiff has executed sale deed selling the suit property to opponent number 2 by sale deed dated 2/7/2009. Serial number 5158. The case made out in the plaint is that even though they had executed the registered sale deed dated so and so for a sale consideration, amount of rupees 40,000 only was paid to them. The remaining 31 checks mentioned in the sale deed, which covered the balance amount of 1,73 lakhs and all, were alleged to be bogus or false and allegedly remained unpaid. We find the elements in the plaint completely contrary to the recitals in the sale deed, which was admittedly executed by the plaintiffs in favor of the respondent 1. In the said sale deed, the plaintiff have expressly and unequally acknowledged that the entire sale consideration was paid by defendant number 1. Hearing to the plaintiffs. In the present case also, they claim that out of the 16 crores, 12 crores was transferred by Mundra General to his vote for single sticks. Entire amount. First they say entire amount is received. Then they say 12 crores was transferred by him. The deed says that the entire amount has been paid. In the circumstances, even here, at least here they say that post-dated checks were given, etc. In our case, they say in the same deed, already transferred a bill. And again, paragraph page 11, 15.2. If the case made out in the plaint to be believed, it would mean that almost 99% of the sale consideration that is so allegedly remained unpaid throughout. It is, however, inconceivable that if the payments had remained unpaid, the plaintiff should have remained completely silent for over a period of 5.5 years. Here it is nearly 11 years. Without even issuing a legal notice for payment of the unpaid sale consideration or instituting any proceeding for recovery of the amount till the filing of the present suit in December 2014. ಆಮೇಲೆ next paragraph they discuss the section 54 of the Consumer Property Act, which my friend is relying upon. And then they say, in view of the law laid down by this court, last paragraph of the same thing. Even if the arguments of the plaintiffs are taken to be true, the entire sale consideration had not in fact been paid. It could not be a ground for cancellation of the sale deed. The plaintiffs may have other remedies in law for recovery of the balance consideration, but could not be granted the relief of cancellation of the sale deed. In this, at least they ask for cancellation. Number cancellation very suit for issue. Cancellation to ಕೇಳಕ್ಕಾಗಲ್ಲ ಅಂತಾರೆ. Supreme Court you only have to file a suit for recovery. Then again paragraph 15.5. The conduct of the plaintiffs is relevant even here. In not taking recourse to legal action for over a period of 5.5 years from the execution of the sale deed in 2009 for payment of the balance sale consideration also reflects that the institution of the present suit is an afterthought. The plaintiffs apparently filed the suit after the property was further sold by respondent number 1 to respondent number 2 to cast a doubt on the title of respondent number 1. The suit property. We want to mortgage it. At that time, when we inform them, they will come up with this. Then the just read the motion. Objection cannot be issued against a true owner or title holder in favor of. I have registered to registered sale deeds in my and in injunction. Injunction cannot be issued against a true owner or title holder and in favor of person in possession of land in the assumed character of owner. These are the ordinary rights of perfectly good titling is all the blood, but the rightful owner, and hence is not entitled to any injunction and or protect his possession against rightful owner. More particularly when he fails to get declared and dispute with respect to title comes to an end. The process will not maintain more relief from injunction. Line, but document will not. I hope they find that the documents speak for themselves. Here are registered sale deeds, registered construction agreement. Observation at page 31. Internal main page 31. Deadline. When may lie, but the documents do not. These two unimpeachable documents clearly establish roles. Here the unimpeachable documents are the two registered sale deeds and the two registered construction settlement deed. Apart from that, bank statements, ledger, balance sheet, their both ledgers signed, all the documents signed by all the parties. And then the next issue. they admit the settlement date, so they do not refuse it. So the appropriate and you can't say one part of the document will apply, another part of the document will not accept.
Hmm.
They deny that balance sheet of 24/7 interim balance sheet with their side. Principle of appropriate and reprobate is based on doctrine of election, which postulates that no party can accept check same instrument and that the person cannot say a contract that the transaction is valid and therefore obtain some advantages to which he will only be entitled to putting that it is valid and then turn around and say it is void for the purpose of securing some other contract. Unknowingly accept benefits of a contract or conveys or order is stopped from denying validity of the binding effect of such contract or conveys or order on himself. Here, we have produced umpteen number of documents in order to demonstrate. Apart from the settlement deed, there are the settlement itself, multiple transactions between the parties. It's all admitted by them. Kindly see the settlement. I only read out what concerns us, rest of them. There are others also.
Hmm.
188 was there. Just point to 196 integrated constructions data. Article 3,
Hmm.
3.
Hmm.
And Article 4, angry developers. And Article 5, I've taken the code to resource developers. Article 6, Skyline Beverly Park. There are other entities and other transactions. None of them have been questioned. The only thing they question is the interim balance sheet, which is at Article 5 at page 198. Can you approve and disapprove what is not now? You are saying after a period of 11 years, can you now? No, we have not executed. Plus, yes, usual bench of our right. Generally, a registered instrument can be cancelled or revoked only by a deed of revocation or cancellation duly executed and registered. When a plaintiff seeks to establish a title in himself and cannot establish that title without removing an insuperable obstacle, such as a decree or a deed to which he has been a party or by which he is otherwise bound, then quite clearly he must get the deed or decree or deed cancelled or declared void by making such a prayer. Then the plaintiff is seeking to establish a title finds himself threatened by a decree or deed. The proper remedy is to get a declaration that the decree or deed is invalid so far as he himself is concerned. Page 59, paragraph 20.
Yes.
What has been done? The next statement. Say to an agreement is caused by coercion. They're executed. The judgment of the attestation. They're executed of a deed, wants it to be annulled. He has to seek cancellation of the deed. But if here is an executed, we'll have to take vote on that and seek for cancellation. But if a non-executed, that won't apply here. seeks annulment of a deed, he has to seek a declaration that deed is invalid or non-west or illegal or that it is not binding on him. Difference between a prayer for cancellation and declaration in regard to a deed of transfer of domains. If the executant's deed seeks cancellation of deed, he has to pay ad valorem court fee on consideration stated in the same. The difference has been gone into when the person concerned itself has executed the document, and if the person concerned has not executed the document. 6 and 7 days. Yes. Statement. Court of Kerala. This is section 19 of the
Yes.
contract. Consent to an agreement is caused by coercion, fraud, or misrepresentation. Agreement is a contract voidable at option of party whose consent was so caused and not null and void even if entire amendments in plain are accepted as correct under section 19 of the Indian Contract Act. 19 of the Indian Contract Act of my will. Voidability of agreements without the consent. Page 66. 28.9. It is 28.9. What I have found out the same thing is.
There was the copy of the plaint that was made available to me during hearing today.
Fraud was played on her, which is result. Here also they claim fraud was played 2 days ago to transfer Section 19 of the Indian Contract Act deals with the effects of fraud. According to this section, when consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. It is therefore clear that the three documents which are the subject matter of the suit in question are actually voidable and not null and void, even if the entire amendments in the plain are accepted as correct. From that perspective, the actual prayer that should have been included in the plain on the amendments contained therein was not only to set aside the document and not declare the same as invalid. No provision of law has been placed before me, which should show that the alleged fraudulent documents can be treated as void and not voidable.
We contract opinion.
So,
Hmm.
they carry it to you guys.
Yeah, provision is very clear that if consent is caused by coercion or any other reason, it is voidable at the not well.
Void and the trial judge also says it is
Voidable.
It is only voidable, even if God has been. The next statement. One co-owner cannot sue another co-owner for permanent because in respect of the land, we are all co-owners because we have an anti-by So this only two are sold to me, the rest of them cannot be sold till possession is handed over. 3 at page 69. that one co-owner cannot sue another co-owner for possession, permanent injunction, restraining him from interfering with the joint property. And the next statement.
Hmm. 86 arbitration.
Thoughts or suggestion by parties. Suggestion by parties for settlement of disputes. On his own schedule, or at the invitation of the conciliator, submit to the conciliator suggestions for the settlement of the dispute. By reading the recitals of the settlement deed, it says settlement agreement 73. When it appears to the conciliator that there exists elements of the settlement which may be acceptable to the parties, he shall formulate the terms of the possible settlement and submit them to the parties for their observation. After receiving the observation of the parties, the conciliator may reformulate the terms of the possible settlement in the light of such observation. If the parties reach agreement on the settlement of the dispute, they may draw up and sign a written settlement agreement. If requested by the parties, the conciliator may draw up or assist the parties in drawing up the settlement agreement. When the parties sign the settlement agreement, it shall be final and binding on the parties, claiming under them respectively. I point out from the settlement deed that this settlement is drawn under 72(3). Conciliator says. The conciliator shall authenticate the settlement agreement and furnish a copy thereof to each of the parties. Status and effect of settlement agreement. The settlement agreement shall have the same status and effect as if it is an arbitral award on agreed terms on the substance of the dispute rendered by an arbitral tribunal under section 30. So kindly take the PDA to the settlement deed. That's the money. He moves part 3 of the Arbitration Conciliation Act. Then at page heading itself again. On page 194 only. Again the conciliator says, page 194.
Yes.
Now therefore this settlement is recorded in terms of section 73(2) of the Arbitration Conciliation Act 1996. Point 6, 7.7, 12.1, which I've already covered before.
Yes.
They all say that the settlement is final. Now, this division of the let's go under section 73(3) of the Arbitration Conciliation Act, the settlement agreement signed by the parties is final and binding on the parties and persons claiming under them. Such a settlement agreement has status and effect of legal sanctity of an arbitral award under section 74 of the Arbitration and Conciliation Act 1996. So in view of this, in view of everything else which I have pointed out, suit is not made. In view of this, would such a suit be maintainable? Would the party be entitled to the things that they 31 of the specific notice. Document produce ಮಾಡಿ ಎಲ್ಲ ಇಗ್ನೋರ್ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲ ಇಗ್ನೋರ್ ಮಾಡ್ಬಿಟ್ಟು kindly see section 31 of the specific notice. Then cancellation will be done. Cancellation of instruments in heading chapter 5. Any person against whom a written instrument is void or voidable and who has reason either void or voidable and has reasonable apprehension that such instrument is left outstanding may causing serious injury may sue to have it adjudged void or voidable and the court may in its discretion so adjudge it and order it to be delivered up and cancelled. If the instrument has been registered under the Indian Registration Act, shall also send a copy of the decree to the officer in whose favor the present suit could not have been maintained. And paragraph 15 of the plaint where he himself says, never come forward to execute the cancellation. So there is an admission that a document requires cancel. Circumstances are proposed.
This concept.
See, common order, same.
More.
Like a statement of objection, the same in
Hmm.
First, I would want to establish the relationship between the applicant and the respondent and Jinda things, which is where a training contributions made. So, take your contribution forward. To a deed of partnership project at page number. Page number annexed R to your lordship at page number 42.
42.
Actually, this is a partnership is executed by Mohanlal Jindal as the deceased appellant, Mr. Avinash Prabhu and Dheeraj Prabhu. These are the original partners of the partnership. Okay, this partnership firm purchases the social property where all the partners are contributed towards the transaction. And it's admitted Mohanlal Jindal also contribute. At page number 44, in clause 6 of the partnership deed. The partners shall manage the firm on the terms and conditions contained therein. However, for ensuring efficiency of the firm and for ensuring proper delegation and accountability thereof, whereby the firm shall prosper, the first partner hereto shall be responsible for taking care of the financial and the administration of the firm, and whereas the second and third partner shall be responsible for taking care of the construction and development and marketing of. So this clearly establishes that the entire management of account and sole signatory of the bank account was the first partner. And all the ledger statements they produced was maintained by him. We have not produced that before. But in para number, clause number 8 here, bank accounts. The firm will open a bank account in its name, which shall be operated by the first partner alone. The bank account was in complete control of the particular settlement date was executed as immediately on 98 as stated by them. Okay, now at paragraph page 46 at 9.3 the sharing and profits and losses and expenses shall be divided between the partners in the following manner unless otherwise agreed upon. 50% first partner and second and third partner 25%. Lordship, even if such a liability of Jindal schemes was there, which has been created by the defendant himself, the appellant here, he was liable for 50% of the loss of the liability which is due to Jindal. He will be liable for 50% of liability, including the contribution made by the other two partners and the making partners. Lordship, thereafter, I would take your lordship to the sale deeds are lordship under the MSA, where they have, in their appeal, page number, your lordship. Addition J, page number 100.
In appeal MFA 211, annexure.
Addition J, page number from the, that's a sale deed. Came by them. As admitted in the trial court, 16 crores. Taken. Now, your lordship, see the recitals of the sale at clause number 5. The vendor has obtained a license.
One second, counsel. Annexure J. Karan.
Recitals. Clause number. Transaction. Like number one, so for the need for development of the apartment building. The construction of building is in progress, not completed. As soon as the building sanction plan is obtained, undivided share in apartment cannot be bifurcated. Now, your lordship, I will show the deed decisions in the sale deed. Now, this deed of sale witnesses as follows. In pursuance of the foregoing, the vendor admits and acknowledges sum of rupees 1 crore 39 crores, being the full sale consideration which he does not hereby, accept, admit, and acknowledge in full and final payment, and vendor does hereby grant, transfer, and convey unto the purchaser by way of sale 2,324 square feet of undivided share in the land described in Schedule A property, with all rights, easements, of privileges, appreciated. To have that hold the same and as absolute owner along with their own, the undivided share of the land is not fully listed. The vendor on this day has delivered vacant possession of undivided share land to purchaser by placing the purchase in joint possession of Schedule A property along with the purchaser, nothing of which is admitted by the later. But if here they claim that they have taken possession of the property, the undivided portion of the scheduled property has been conveyed to the applicant. Lordship, now I will take you to number 151, your lordship, that is the corresponding construction agreement with respect to this apartment.
Okay.
151. Recitals agreement, your lordship. Here also clause number 5 and clause number 6. Talks about the same. No consideration. That is pursuant to the foregoing, the vendor admits and acknowledges sum of rupees 7 crores 63 lakhs 83,634. The full and sale consideration, cost of construction scheduled income. Also, the case is 16 crores is sale consideration for the entire 2 apartments. Sale deed and body here 1 crore 39 crores. Stamp duty they pay for 1 crore 39 crores. Remaining 7 crores are they show in the construction agreement. And kindly look at the stamp duty. They pay 1,350. Stamp duty construction agreement. They pay some 8,500 as a registration charges. Worship this. Both these agreements are hit by the Karnataka stamp set, not properly stamped. It cannot be acted on. Now, your lordship, in the construction agreement, very important to note that Article 2, your lordship. Page number 153. Completion and handing over possession. The definition of construction and completion of apartment building shall be defined in the settlement deed. The vendor shall complete the construction of the apartment building as per the terms of the settlement deed so and so. The possession of the said apartment will be delivered to the vendor to purchase within 18 months, that is by 23/1/2015. Your lordship, this is a contract of specific performance where the date of performance is fixed on a calendar date, that is 23/1/2015. From the day of handing over possession by the vendor, person shall be liable to pay electricity so and so. In case there being a delay in delivery of the said flat, as per the terms of the settlement deed, the vendor shall pay the purchase the sum of rupees 20,000 per day per delay. Admittedly, also the 2 sale is 2 concession agreements. Per day 20,000, 2,013 and letter per day. They can purchase the same property 5 times your option. Ashtu penalty will be accrued in this property. And it's a time fixed performance. It's requires section 54 of Limitation Act. So the conjoint reading of sale deed and construction agreement establishes the agreement which is to be performed. Where the time is for fixed at a specific date, which is 23/1/2015. I will just take your lordship to the limitation.
Yes, if it is same is essence of the contract, 3 years.
This date fixed your lordship. It's not like 6 months, 7 months, it's a date fixed. So the agreement, the sale deed and construction agreement read together is an agreement which is to be performed by both the parties. That is, we have to deliver possession. They have to pay a sale consideration. Admittedly, they have not taken possession. Even in their arguments in the appeal memo, they say constructive possession. They never say they are absolute possession, and for land or building sanction plan is there is no option of taking possession of undivided. So both these agreements are an agreement to be performed. Both the sale deed, first sale deed and construction agreement, the second sale deed and construction agreement. Form an agreement to be performed, which is expressed section 54 of Article 54 of Limitation Act in time part. Therefore, they cannot come and say that after 13 years, sale is no. If it's 20,000 rupees per day penalty, third agreement is 40,000 rupees per day. So that amounts to almost 50 crores rupees. And suddenly they come, we don't want the money, we don't want possession, we will mortgage the property. Lordship, in my statement of objections, the last page, page number 110. India earlier appeal. They are not filing written statement in the trial court.
Statement of objections, page.
Page number 110. That is their grounds in their earlier appeals. Paragraph number 31. The applicant is currently 82 years old and having health issues which is unable to move on freely, was wanting to mortgage the said expense. He had an urgent requirement including towards medical expenses. Said ex parte increment is causing irreparable loss to the appellant. But the cause of action, their cases, we are coming to the court after 11 years. The actual fact being is that for 11 years they have slept on it. They are not claiming performance of the contract. They are not demanding 40,000 rupees per day from the plaintiff. And they say 40,000 rupees, 50 crores rupees penalty I don't want. I don't want possession. I will mortgage the property. Even the appellate lordship was not interested. Only the appellate legal as now. That is in the WhatsApp chat that you can make for the document that I have produced. Cause of action is bank officials work there. And on 60 crores sale consideration will show, they take loan of up to 60 to 70 crores. They default. Automatically bank will come and take possession. Take their sale deeds are valid. Bank also wants to valid mortgage. So this clearly shows that established an agreement, not a sale deed. Now your lordship, at annexure R6 in my statement of objections.
Next, sir.
R6. R6 and R5.
Page.
Before that, page number 72, your lordship. Page number 72, statement of accounts of rest of the page. Here, page number 72. Also be kindly removed. 22/7/2013. More than 12 plus 26 lakhs. Same days only. 24/7/2013. 22/7/2013. Jindal Steels. 12 plus 26 lakhs. Same this they transferred both the money lordship. Now I show you Jindal Steels is your lordship. At page number R6. Annexure R6 at page number 75. Mohanlal Jindal is the appellant, deceased appellant. Tushar Kumar Jindal is son. Lordship, there is no difference between the appellant and Jindal Steels. Both are the same entity. So if you wanted to pay sale consideration from on one hand in his personal capacity, on the same day transfer the same amount back to him. How is this a logical explanation in logic? 12 crores he pays, saying that I'm register the two salaries in your property. Same day, he transfers the amount to Jindal and sold. This clearly established a lordship. He has not paid the sale consideration under the sale lease. Lordship, this being the case, this is one aspect I wanted to establish. Now, coming to their annexure T1, settlement deed and annexure T1. The settlement deed is admitted.
Next, sir.
Their settlement deed which they have produced,
Hmm.
which I have also admitted.
Hmm.
Page number 188 of their.
Hmm.
You can find 5.1.
Hmm.
Jindal has interest in the firm Resco developing the sum of 60 crores 9 lakhs 4,000 change.
Hmm.
Actually, this contribution is 16 crores, we admit 16 crores is contribution. That is earlier from integrated construction, where both the plaintiff partners and defendant are partners.
Hmm.
And later they get some money from the partnership, and certain amount is proportionate. Second, that 16 crores has come because he has contributed 12 crores on 22/7
Hmm.
on his personal capacity to his account. But using the sole signatory power,
Hmm.
same day he transfers that amount to
Jindal.
Jindal.
Hmm.
So immediately the sale consideration is now 16 crores.
Hmm.
He has taken out that money.
Hmm.
And under this settlement deed, we execute partnership deed and we take control of the accounts of the firm.
Hmm.
We took the control of the accounts of the firm and paid him a 206 years. The settlement deed.
Hmm.
1980 2030.
Hmm.
Although the defendant, the appellant itself was in control of the accounts.
Hmm.
He does various transactions and then he executes. He receives us to execute two sale deeds and construction agreement,
Hmm.
and he just walks away from the firm.
Hmm.
After 11, then when we made the representation, is that I want the ownership. I admitted it 2015 is the date for performance. He has not come forward, issued legal notice, give me the apartment, pay me 40,000 rupees per day. He has not asked. Suddenly he wakes up after 11 years and mortgage the property to the public fund to keep the public and keep the building.
Hmm.
Until now, they have not paid possession, they have not paid taxes to the property, being more than 33%. We are in complete enjoyment and possession of the property, and we have spent crores and crores of money in constructing an apartment,
Hmm.
which we are entitled to enjoy.
Hmm.
No. Now, one more document, the rely is annexure T1.
But according to him, you have not made any construction?
We have completed the construction.
Completed.
Complete.
Hmm. Council made submission that not done anything about the construction.
That's what 2050 they should ask this question. Now they are asking.
Hmm. Now still it is vacant.
It is vacant here. We want to sell it in a later date when it's value operations. Annexure T1, page number 229.
229.
229, that is used by in their appeal memo.
Hmm.
This is
229. Rest house developers. Hmm.
This also the FAQ surface. We didn't have a copy of this because we were the sole management of accounts, but we admitted this is my signature on this document.
Hmm.
Lordship, now come to page number 234, your Lordship. Senior counsel had pointed out long-term borrowings
Hmm.
from partners. Mohanlal Jindal 3 crores change, Avinash Prabhu 2 crores change, Dheeraj Prabhu 2 crores change, Jindal Steel 12 crores change, related parties, Skyline developers 1 crore change, 18 lakhs change.
Hmm.
All these are borrowings of the.
Hmm.
So, who is liable to pay this loan? As per the original partnership deed, Mohanlal Jindal owns 50% profit and loss. So, for the entire amount, he is liable for 50%,
Hmm.
and we are liable for 25%.
Hmm.
What he does is, your Lordship, he puts settlement is arrived much later to this execution of this statement.
Hmm.
What happens is, parties decide there's so much liability in the room, and we have to do the construction to cost of. Parties enter into a settlement deed, we admit, saying that okay, I will walk away from and put 12 crores, all his dues are put 12 crores. You clear the dues and clear the dues, or you create, build the construction apartment and convey the apartments to me. This is what the understanding is. But what he does mischievously using the source inventory of this, he'll show 12 crores were given. There's liability, I admit. Then same day he transfers the same amount to his own firm, and then he executes 2 settlement deed and sits on it. And after 11 years, he comes to me. And a 12 crore amount here also, it's transferred on the very same day. Their cases, we have signed the interim balance sheet. We have signed this balance sheet. In this balance sheet, there is not been a single transaction to show that 12 crores was transferred to Jindal Steels, and we have signed it. We acknowledge it's being paid. It's not forthcoming in Lordship. And learned trial judges clearly made out this point. And even though this statement says 12 crores is due to Jindal Steels, there is no document to prove that 12 crores was transferred and we have signed it acknowledged. And interim balance sheet, we don't deny it. If such an interim balance sheet is there, where 12 crores has been transferred to Jindal Steels, and we admit it's valid, then we will go on to the case. We will just withdraw the case if they produce such an interim balance sheet. They don't have it. And there is no such document which exists. But also, when the second thing is, 12 crores something money was due under for Jindal Steels. A comprehensive settlement deed with the arbitration act as allegedly claimed by him. We have at least a single line mentioned that there was a liability of 12 crores for Jindal Steels. I'm taking out that money for Jindal Steels. Nowhere in the settlement deed it mentions about 12 crores. So it's clearly a case where the defendant has paid fraud. He has shown he has paid 12 crores and he has taken out 12 crores on the same day. And he gets the benefit of all his agreements. And after we catch hold of him, he's like, for 11 years, he's like, okay, I won't claim. Performance is fixed at 2015 date. He doesn't claim. And now he wants to mortgage the property, and his legal has also want to mortgage the property. Even Mohanlal Jindal himself does not contest this suit before the time. It is his son, the power of attorney Gundar, who is the partner of Jindal, who has contested the suit. Mohanlal Jindal apparently was never interested in his property. Suddenly his legal has woken up, like as a property, in a very nice property in Bangalore, that has encashment and mortgage. They have not come for position putting 40,000 rupees per day, 100% pay. They only come and say mortgage. Now, I will tell you why this suit for injunction is medium. I'm coming to the maintainability of the suit. Produce a memo of citation.
Continue at 2:30. Now 1:30. Now you are relying upon citations, you have to.
30 maximum purpose.
No, you have already started. How much time you require now for citations? 20 minutes. Then what time you are coming in the afternoon? You have finished that and then come here. What all? Where hotel? 17. You finish that work and then come here. How much time you require for reply? 15, 40 minutes. Elaborately have argued. Reply why 20 minutes? Notes ಇಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಅಥವಾ ಇದು ಅದರಲ್ಲಿ ಇಟ್ಕೊಂಡಿರಿ. You can come at 3 p.m. Let him also finish. 21. 21, what happened? Morning, what happened? Why it was passed over? Interim application, Miller. Avoid service of notice in respect of R4 to 14. Notice issue ಆಗಿದೆಲ್ಲ, ನೋಟಿಸ್ ಅವಾಯ್ಡ್ ಇದೆ, ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಮತ್ತೆ ಅದೇ ಇಲ್ಲ ಅಂತೀರಿ, ಮತ್ತೆ ಇದೆ ಅಂತೀರಿ. ಸ್ಟೇಟಸ್ quo is also an order. Maybe it's an ambiguous order, but there is an order. ಯಾವಾಗ ಅವಾಯ್ಡ್ ನೋಟಿಸ್ ಇದೆ, ಏನಾಯ್ತು? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 to 14 ಯಾವಾಗ ಹೋಗಿರೋದು ಮೇಡಮ್? ಡಿಸ್ಪ್ಯಾಚ್ ಆಯ್ತು, ಏನಾಯ್ತು? ನಿನ್ನೆಯಿಂದ ಇವತ್ತು ಹಾಕಿದೀವಿ.
ನಿನ್ನೆಯಿಂದ ಹಾಕಿರೋದು ನಾನು ರಿಪೀಟ್ ಕೊಟ್ಟೆ, ಅದಕ್ಕೆ ಆಸ್ ಇಟ್ ಈಸ್ ಬಂದಿದೆ. ಅವರು ಆಮೇಲೆ ಪುಟಪ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ನೀವು ನಿನ್ನೆ ಹೇಳಿದ್ರಿ ಅದನ್ನ, ಬಟ್ ಅದನ್ನ ಕಮ್ಮಿಗೆ ಹೋಗಿರೋದ್ರಿಂದ ಅದು ಆಸ್ ಇಟ್ ಈಸ್ ನಾನು ರಿಪೀಟ್ ಕೊಡ್ಸಿದ್ದೆ ಅದನ್ನ. ಅದಕ್ಕೆ ಅದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬಂದಿದೆ. ಬಟ್ ನೀವು ನಿನ್ನೆ ಹೇಳಿದೀರಾ ಇದು ಪುಟಪ್ ಆಗಿದೆ ಸರ್. ಅದು
ಆಗಿದೆ ಈಗ.
ಆಗಿದೆ, ಇದ್ರಲ್ಲಿ ಪುಟಪ್ ಆಗಿದೆ. ಬಟ್ ಅಲ್ಲಿ ಕಾಸ್ಟ್ಲಿಸ್ ತೋರ್ಸೋಷ್ಟೊತ್ತಿಗೆ ನಾನು ಹೇಳ್ಬಿಟ್ಟಿದ್ದೆ ನಾನು ರಿಪೀಟ್ ನ.
ಆಯ್ತು, ಈಗ ಏನಾಗ್ಬೇಕು? ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ರು. 21st ರೀಚ್ ಆಗಲ್ರಿ. 21st ಹಾಫ್ ಡೇ ಮಾತ್ರ. ಇನ್ ಹಾಫ್ ಡೇ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಇರುತ್ತೆ. 22nd ರೀಚ್ ಆಗೋ ಡೌಟ್. 23rd ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ರ ನೀವು? ಹಾಕಿದೀರಾ? ಯಾವಾಗ? The counsel appearing with respondent would submit that he has filed a statement of objections to IA number 1 of 23 and hence put up the same and list this matter on 22nd. ಯಾವ್ದಾರು ಒಂದೊಂದು ಹೇಳಿದ್ರೆ ನಾನು ಕೇಳ್ಬೋದು. ನನಗೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್. ಪೇಜ್ ವೈಸ್ ಕರೆದು ಬಿಡ್ತೀನಿ, ಹೇಳಿ ಆಗ್ಬೋದಾ? ಯಾರಾದ್ರೂ 20ಗಿಂತ ಹಿಂದೆ ಯಾರು ಇದೀರಾ? ಯಾವ್ದಾರು ಇದೆಯಾ ಮೆನ್ಷನ್? ಹಿಂಗಿಲ್ಲಲ್ಲ. 20 to 22. ಕೊಡಿ ಮೆಮೊ ತಗೊಳ್ಳಿ. ನೀವು ಯು ಆರ್ ಫಾರ್ ಅಪಿಯರಿಂಗ್ ಟು ದ ಅಪಲೆಂಟ್. The appellant counsel files memo stating that already suit has been disposed of and hence this appeal doesn't survive for consideration and hence ಏನು ನಿಮ್ ಪ್ರೇಯರ್ ಏನಂತ ಮಾಡಿದ್ರಿ? ಇಟ್ ಮೇ ಬಿ ಪ್ಲೀಸ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ಡಿಸ್ಮಿಸ್ಡ್ ಫಾರ್ ರಿಜೆಕ್ಷನ್ ಆಫ್ ಪ್ಲೈಂಟ್. ಏನ್ರಿ ಇದು? and in view of the memo it becomes infructuous. Next 23 to 24. ಹೇಳಿ. ಇದಾರ? ಈಗ ಇಬ್ರು ಇದ್ದೀರಾ? ಇಬ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. ಇಬ್ರು ಇದ್ರೆ ಕೊಡ್ತೀನಿ. ಅಪಲೆಂಟ್ ಇದ್ರಲ್ಲಿ ಯಾರು? ವರದರಾಜನ್ ಇದಾರಲ್ಲ, ಇದೀರಲ್ರಿ ಅದರ್ ಸೈಡ್. ಇನ್ನೊಬ್ರು ಹಾಕಿದಾರ? ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ನೋಡಿ. ಈಗ ಯಾವ್ದಾದ್ರು ಮೆನ್ಷನಿಂಗ್ ಇದ್ರೆ ಮಾತ್ರ ಹೇಳ್ಬೇಕು. 25 to 27. 25 to 27 ಇಲ್ಲ. 28 to 30. ಹೇಳಿ 30 ಅನ್. ಏನಾಗಿದೆ ಅದು? ಈಗ ಕಾಸ್ಟ್ ಹಾಕಿ 23 ಹಾಕಿದೀವಿ. ರೆಡಿ ಏನು? ಈಗ ಅರ್ಜನ್ ಆಗೋಗಿದೆ. ನೆಕ್ಸ್ಟ್ 31 to 35. 31 to 35. ರೆಡಿ. ನನ್ಗೆ ಗೊತ್ತಲ್ರಿ, ಕೇಸ್ ಕರ್ದಾಗ ನೀವಿಲ್ಲ. 2016 ಅದರಿಂದ ಅರ್ಜೆಂಟ್ ಮಾಡಿದೀವಿ ವಿತ್ ಕಾಸ್ಟ್. ಪೇಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ. 31ರಿಂದ 35 ಇದೀರಾ? ಇಲ್ಲ. 36 to 40 ಯಾರ್ದು ಇಲ್ವಾ ಮೆನ್ಷನಿಂಗ್? ಹಾಗಾದ್ರೆ 53. ಹೇಳಿ. 53 ಯಾರು? ಅದರ್ ಸೈಡ್ ಯಾರಿದಾರ? ವಿಜಿ, ಭಾನುಪ್ರಕಾಶ್, ಹನುಮಂತರಾಯಪ್ಪ ಇಬ್ರು ಇದೀರಾ? ಇಬ್ರು ಇಲ್ದವ್ರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಡಿ ಕೌನ್ಸಿಲ್. 46. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇದೆ. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ? ಸರಿ. Serial number 46. The counsel for the appellant has furnished the copy of the notification to the counsel for respondent, and counsel for respondent wants to verify and submit. ಯಾವಾಗ ಬೇಕು? ಪಾಠ ಆಡೋದು ಇರೋದೇ 1 week ರೀ. ಮತ್ತೆ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗ್ತದೆ. 23 ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 55 ಏನಾಗ್ಬೇಕು? ಇಬ್ರು ಇದ್ದೀರಾ? ಏನಾಗ್ಬೇಕು ಹೇಳಿ. Appellant counsel seeks time and government AGA is also present. List this matter in the first 2016 first week of March. 59. ಹೇಳಿ ಏನಾಗ್ಬೇಕು? ಹೇಳಿ ಏನಾಗ್ಬೇಕು? ಅದರ್ ಸೈಡ್ ಇದಾರಾ? ಇಲ್ಲ. ಇಲ್ದವ್ರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಡಿ. ಅವ್ರು ಬಂದ ಆಮೇಲೆ ನಮ್ಮ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ ತಗೊಂಡವ್ರೆ ಅಂತ ಹೇಳೋದು ಬೇಡ. ಇಬ್ರು ಬೋತ್ ಸೈಡ್ಸ್ ಇದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಸರ್ ಅದೇನು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕು ಸರ್?
ನಾಳೆಗೆ ಹಾಕ್ಸಿ. ಅವ್ರು ನಿನ್ನೆ ಅದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ, ಯಾವುದು?
Next.
Monday, Monday, probably no sitting, Tuesday. But in that judgment also, both the judgments, nowhere it is discussed that an amount of rupees 8 lakh has to be. Hmm. Serial number 1 ಅಲ್ಲ? Holy madam. First, the explanation submitted by the earlier POs. And the reason stated in the explanation regarding non-disposal of OS number 3930 of 2011 as directed by this court. Taken note of. Particularly explanation given by the officer. Who is working at First Additional District and Session Judge Kolar is not satisfactory. Apart from the other explanation, the officer who is working at Special Court for trial of rape cases along with POCSO cases also not satisfactory, and officers are warned to be careful in future while complying with the directions of this court. This court has perused the explanation given by the present who is working. When the directions are given for time-bound disposal of the case, when the suit is also more than a decade, ought to have taken note of the same and also direction issued by the court and take up this matter day-to-day basis and dispose of the same within 2 months from today. And the earlier order passed in 2020 MFA was not adhered by the respective POs. Flimsy reasons are given. No further time will be extended in future. So,
Yes, sir.
ಬರ್ಲಿಲ್ವಾ? The appellant, this matter is called twice in the early morning and also in the afternoon, and no representation by the appellant counsel, and in view of the earlier order dated 1/2/2024, wherein made it clear that if counsel not paid the cost and not paid the PF and not complied with the office objections, cost that will be dismissed, and accordingly matter appeal is dismissed. Same order. Date on ನೋಡಿ ಮೇಡಮ್, ಯಾವ್ದು ಸೇಮ್ ಡೇಟಾ ಅಥವಾ
6.
ಅದು ಡಿಸ್ಮಿಸಲ್ ಅಲ್ವಾ? ಬೇರೆ ಏನಕ್ಕಿದೆ ಅದು?
ಬೆಳಿಗ್ಗೆ
ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಇಲ್ವಾ? ಇಬ್ರು ಇಲ್ವಾ? Both the counsels are absent. List this matter after 2 weeks. Dismissal ಇರ್ಬೇಕು. Same order ನೋಡಿ ಮೇಡಮ್, ಲಾಸ್ಟ್ reference code earlier order dated 1/2/24. ಏನಾಯ್ತು ಇದು? What are the relief? Ah. Ah. Hmm. 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 ಈಗೇನ ನೋಟಿಸ್ ಹೋಗಿತ್ತಲ್ಲ ಇದ್ರಲ್ಲಿ ರೈಟ್ ಅಂತಿದೆ.
ರೇಟ್ ಅಂತ ಇದೆ.
ಹ್ಮ್.
ಪ್ರಕಾರ ನೀವು ಇದನ್ನ ಮಾಡಿದೀರಾ ಸರ್, ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಕ್ ಹೇಳಿದೀರಾ?
ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಪರ್ಮಿಟೆಡ್ ಟು ಟೇಕ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ. ಬಟ್ ಅವರು
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಏನಾಯ್ತು? ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಅನ್ಅವೈಲಬಲ್ ಅಂದ್ರೆ ಏನು? ಕೌನ್ಸಿಲ್ ಆಫೀಸಿಗೆ ನೀವು ಹೋಗಿದ್ರಾ? ಮತ್ತೆ ಅವ್ರು ಜಾರಿನೇ ಆಗಿಲ್ವಾ? ಈಗ ಮತ್ತೆ ಯಾರಿಗೆ ಜಾರಿ ಆಗಿದೆ? 12 to 14 ಜಾರಿ ಆಗಿದೆ. The appellant counsel files memo stating that he has served the notice against respond number 12 to 14. ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದ್ದು? to 14 ನೀವೇನೋ ಹಾಕಿಲ್ಲ ಯಾವ ಡೇಟ್ ಅಂತ notice and respond number 12 to 14 have not engaged any counsel and hence held sufficient for by ನೀವೇ ಅವರಿಗೆ ಡೈರೆಕ್ಟ್ ಇವರಿಗೆ ತಗೊಂಡಿದ್ರಲ್ಲ held sufficient. The counsel submits that the respond number 9 to 11 were not available for the service. Hence returned the hand summons. Hmm. 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 9 to 11. Will the paper publication application, madam? The appellant counsel also filed an application under order file rule 20. For substituted service against respond number 9 to 11 by permitting them to take out paper publication. Paper publication ಯಾವಾಗ ತಗೊಳ್ಳೋದು counsel? ಅದೇ ಯಾವಾಗ ಅಂದೆ? ಥ್ರೂ ಕೋರ್ಟ್ ಹೋಗಿದೆಯಾ? ಏನಾಗಿದೆ ಏನು ಹೋಗಿದೆ ಕೋರ್ಟ್ ಇಂದ? 3 ಸರಿ ಹೋಗಿ ಬರ್ಬೇಕು. ಹೋಗಿದೆಯಾ? ನೋಡಿ ನೋಡಿ ಸಲ ಹೋಗಿದೆಯಾ ನೋಡಿ. ಯಾವ ವರ್ಷದ ಇದು? 2023 ಫಸ್ಟ್ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಏನಾಗಿದೆ ನೋಡಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಇಲ್ಲಿ ನಾನು ಕೇಳ್ತಾರೆ ಇಲ್ಲಿ.
ನೀವು ಆರ್ಡರ್ ಮಾಡಿರೋದು 7-2ಗೆ, ಅದಕ್ಕಿಂತ ಮೊದಲು ಆಗಿದ್ದು ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂತ.
ಫಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಆಗಿತ್ತು.
ಆಗಿತ್ತು ಸರ್,
ಏನಾಗಿದೆ
ಆಗಿದ್ದು
ಅದು?
ಹೋಗಿದೆ. ಅದ್ರಲ್ಲೆಲ್ಲಾನು ಲೆಫ್ಟ್ ಇನ್ಸಫಿಶಿಯಂಟ್ ಅಡ್ರೆಸ್
ಲೆಫ್ಟ್ ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್
ಅಂತೆಲ್ಲ
ಅದೇ ಯಾವಾಗ ಹೋಗಿದೆ? ಎಷ್ಟು ಸರಿ ಹೋಗಿದೆ ಕೋರ್ಟ್ ಇಂದ?
ಇದು ಎರಡು ಸತಿ ಹೋಗಿದೆ. ಇದು ಸೆಕೆಂಡ್ ಟೈಮ್. ಒಂದ್ಸತಿ ಹೋಗಿದೆ ಸರ್. ಒಂದ್ಸತಿ ಹೋದ್ಮೇಲೆ ನೀವು ಮತ್ತೆ
ಲೆಫ್ಟ್ ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ
ಒಂದ್ಸತಿ
ಬಂತು.
ಹೋಗಿ
ಆಮೇಲೆ?
ಅದಾದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ಬಂದಾಗ ಈ ತರ ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ. ಅದು ಮೊನ್ನೆ ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ ಸರ್, ಅದು
ಹಾ.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ
ಮೊನ್ನೆ ಶುರು ಮಾಡಿರೋದು ಅಷ್ಟೇನೆ. ಅಲ್ಲಿ ಒಂದೇ ಸರಿ ಹೋಗಿರೋದು. ಒಂದೇ ಸರಿ ಹೋಗಿರೋದು. ಅದಾಯ್ತ್ರಿ, ಬಟ್ ನೀವು ಕೋರ್ಟ್ ಇಂದ ಹೋಗಿರೋದು RPD ಹೋಗಿದ್ಯಾ ಏನಾದ್ರು? ವಾಪಸ್ ಬಂದಿರೋದು ತೋಳ್. Start of paper publication in the local Kannada morning daily newspaper. On verification of the records, only once notice was issued against the respond number 9 to 11 and the same were returned with an endorsement left and insufficient address. And the council has not taken any steps again for furnishing of the sufficient address and also the correct address since the notice was issued is returned with an endorsement left the address. And when such being the case, the question of taking the notice by way of substituted service in the paper publication doesn't arise and the applicant has to take the steps by ಯಾವಾಗ and hence IA is rejected. ಈಗ ಏನಾಗಿದೆ ನೋಡ್ರಿ
16 ಸತ್ತೋಗಿದ್ದಾರೆ. ಅದೊಂದು ಬಂದಿದೆ. ಅವ್ರಿಗೆ
16.
steps ತಗೋಬೇಕು. 16
ಅವರು ಸತ್ತೋಗಿದಾರಾ?
ಸತ್ತೋಗಿದ್ದಾರೆ.
ಹಾ.
ಅವ್ರಿಗೆ steps ತಗೋಬೇಕು.
R16 9 to 11 ಆಯ್ತು. R16 ಏನೋ ತೀರ್ಕೊಂಡಿದಾರಂತಲ್ಲ. ತೀರ್ಕೊಂಡಿದಾರಂತ. R16 is no more. ಹಾ, ಇನ್ನು ಅಲೋ ಆಗಿಲ್ಲ. ಅಲ್ಲಾಗ್ಲಿ ಬಿಡ್ಲಿ, ನೀವೆಲ್ಲ ಹಾಕ್ಬೇಕಲ್ಲ ಅಪ್ಲಿಕೇಶನ್. ಹಾ,
R16 R28. R28 is I represent.
you are represent one of
I represent R28 is the son
Ah.
of Himant Rai, who
Ah.
is R16, and they are not included my mother and my sister.
ಮದರ್ ಸಿಸ್ಟರ್ ಈಗ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ ಇದಾರ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಇಲ್ಲ,
R28 ಮಾತ್ರ ಸನ್ ಮಾತ್ರ ಇರೋದು.
son ma.
ಹಾ. ನೀವು ಮಾಡ್ಬೇಕಲ್ಲ ಅಪ್ಲಿಕೇಶನ್. ಇಲ್ಲ ರೀ, ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀರಿ, ಇಲ್ಲ ಹಾಕ್ಲಿಕ್ಕೇನ್ರಿ? ಬಿಕಾಸ್ ಯು ಆರ್ ಎಂಜಾಯಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡಾರ. ಹಾ, ಸರಿ. ಈಗ ನೀವ್ ಯಾಕೆ ವೈ ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್ ಸ್ಟೆಪ್ಸ್ ಬ್ರಿಂಗಿಂಗ್ LRs ಆಫ್ R16? 28 ಒಬ್ರು ಇದಾರೆ, ಅವ್ರಾಯ್ತು. ಇನ್ನಿಬ್ರಿಗೆ ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ರೀ. ಅಲ್ಲಿ ಅಮೆಂಡ್ ಆದ್ಮೇಲೆನೆ ಇಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತಿಲ್ಲ, ಗೊತ್ತಾಯ್ತಲ್ಲ. ಅದರ್ವೈಸ್ ಐ ವಿಲ್ ವೆಕೇಟ್ ದಿ ಎಂಟ್ರಿ ಮಾಡರ್. ಮತ್ತೆ ಯು ಆರ್ ಎಂಜಾಯಿಂಗ್ ದಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಅಂಡ್ ನಾಟ್ ಟೇಕಿಂಗ್ ಸ್ಟೆಪ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಪರ್ಸನ್ಸ್ ಹೂ ಆರ್ ನೋ ಮೋರ್ ಅಲ್ವಾ? ಹಾ, ದೆನ್ ಯಾವಾಗ ಮತ್ತೆ ನೀವು ತಗೊಳ್ಳೋದು? ಹಾ, ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ನೀವು R28 ಇಲ್ಲಿ ಎಷ್ಟನೇ ಅವರು? ಇಲ್ಲೂ R28. ಅದೇ R28 submits that R28 is the LR of respond number 16 and mother and ಇನ್ಯಾರು ಮಾಡಿಲ್ಲ? Mother and daughter is also mother, daughter and another brother our also there and not taken steps. ನೆಕ್ಸ್ಟ್ ಆಮೇಲೆ ಈಗ ಮತ್ತೆ ಇನ್ನೇನಿದೆ ಮೇಡಮ್, ಅದು ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಕೊಡಿ. ಹಾಕಿದಾರ ಯಾವಾಗ? ನೀವು ಹಾಕಿದ್ದೀರಾ? The respondent council files memo to dispense the notice against R9 to 14 and 24, 27, 24 to 27 and the same doesn't survive. ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? ಹಾ, the respondent number 27 is represented through council. ಎಷ್ಟೇನಾಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ ಇನ್ನ? ಅಷ್ಟೇನಾ? ಹಾ, ಯಾವಾಗ ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ತೀರಿ ಬೇರೆಯವ್ರಿಗೆ ಮತ್ತೆ ಹಾಕ್ತೀರಾ? ಅಯ್ಯನಾ? The appellant council submits that he is going to bring the LRs of R16. ಇದ್ರಲ್ಲಿ ಯಾವ್ದು ಅವೈಟ್ ನೋಟಿಸ್ ಏನೋ ಇದೆಯಲ್ಲ ಮೇಡಮ್? ಯಾವತ್ತು ಇಶ್ಯೂ ಆಗಿರೋದು? ಹೋಗಿದೆಯಲ್ಲ ಈಗ, ಬಿಟ್ಬಿಡಿ. ಈಗ R9 to 11 ಮಾತ್ರ ನೋಡ್ಬೇಕು. ಈಗ 12 to 14 ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್ ಆಯ್ತಲ್ಲ. ಈಗ ನಾವು ನೋಟಿಸ್ ಹೋಗಿದ್ದೀವಿ. ಯಾವತ್ತು ಇರೋದು? 9th ಯಾವತ್ತು ಇಶ್ಯೂ ಆಗಿದೆ ಅಂತ ಕೇಳಿದೆ. ಬೆಳಗ್ಗೆ 9th ಅಂದ್ರೆ ನೀವು. ಹಾ, the notice issued against R9 to 11 is awaited and hence 2 days time is given to file necessary application to bring the LRs of appellant number 16. ಅದೇ ಸಾರಿ, respond number 16 list this matter next week ಎಲ್ಲ ಕೊಡ್ರಿ. ಹಾ, ಹೇಳಿ. ಹಾ,
Essence of these persons are objections of this cases. They were not, though they were parties, he did not take any steps against them, but took a chance of arguing the matter on all the legal applications. That is, now to wait, he is enjoying the day. Nature of influence is wrong with the president. It's the chance in the age. Because a 10 ನಿಮಿಷ time allot ಮಾಡಿ 10 minutes ಇರಬೇಕು ಅಂತ ಹೇಳಿದ್ರು because their presence so far as presence before this MFA is concerned are not required so far as admissions, because they were not heard before that time.
or these persons were not heard
They
before.
were not heard. He did not take steps.
Oh.
And he chose to argue the matter.
ಅದಾಗರ್ ಬೇಡ. ಹಿಂದಿನ ಲಾಸ್ಟ್ ಏನೋ ಮಾಡಿದ್ವಲ್ಲ, ಒಂದ್ ನಿಮಿಷಕ್ಕೆ ಹೇಳ್ತೀನಿ. ಏನಾಯ್ತು ಮೇಡಮ್? ನೀವೇ ಓದ್ಕೊಂಡ್ರೆ ಹೆಂಗ್ರಿ ರೀ? ನಾನು ಕೇಳಬೇಕು. ಮತ್ತೆ ಲಾಸ್ಟ್ ಏನ್ ಸೆಂಟ್ ಹೇಳ್ರಿ. necessary application, full stop. I'll full stop it. The council appearing for the R28 submits that the notice awaited in respect of respond number 9 to 11 for not heard before the trial court, and appellant has not taken any steps before arguing the applications which have been filed before the trial court, and hence they are not necessary to consider this appeal when their case has not been heard before the trial court. ಹೇಳಿ ನೀವು ಹೇಳಿ.
And respondent number 18 is the.
Why you argued the matter without taking the steps against them?
18 ಇದೆಲ್ಲ ಒಬ್ಬೊಬ್ರು ಬರೋದು ಒಕ್ಕಲತ್ತಾಗಿದ್ದು objection ಆಗ್ತೀನಿ.
ಅದೆಲ್ಲ ಆಯ್ತು, ಬಿಟ್ಬಿಡಿ, ಅವ್ರದ್ದು ಬಿಟ್ಬಿಡಿ. ಈಗ ಅವರಿಗೆ ಇದಿತ್ತು, ಅರ್ಜಿ ಇತ್ತು, ಅದಕ್ಕೆ ಬಂದ್ರು. ನೀವ್ ಯಾಕೆ ವೈ ಯು ನಾಟ್ ಟೇಕನ್ ಸ್ಟೆಪ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೂಡ ನಾವು ಅದನ್ನೇ ಪ್ರೆಸ್ ಮಾಡ್ತೀವಿ. ಬಟ್ ಒಂದಾಗದೇ ಕೊಡೋದು ಒಂದು ಒಕ್ಕಲತ್ತಾಗಿ ಡ್ರ್ಯಾಗ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರು.
ಅವ್ರು ಡ್ರ್ಯಾಗ್ ಮಾಡೋದ್ ಬಿಡ್ರಿ, ನಿಮ್ಮದ್ ಹೇಳ್ರಿ, ನಾನ್ ಕೇಳಿರ್ ನೀವು ಅವ್ರದ್ದು
ಬಿಟ್ಟೆ ನನ್ ಕೈಗೆ ಹಿಯರಿಂಗ್ ಮಾಡಿ ಬಂದಿರೋದು ಒಕ್ಕಲದಿಂದ ಬಂದಿದ್ದಾರೆ, ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, ಸಂಸ್ಕೃತಿಕ ನಮ್ಮನ್ನ ಕೇಳಿ ಅಂತಂದ್ರು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಾಡಿ ಎಂಟರ್ಟೈನ್ ಮಾಡಿರೋದು ನಮ್ಮನ್ನ ಕೇಳಿದ್ರೆ ಕೇಳಿ ಅವ್ರ ಐಡೆಂಟಿಟಿ ಪಾಸ್ ಮಾಡ್ಬೇಕಾ ಬೇಡವಾದ್ರೆ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು. ಇವ್ರನ್ನೆಲ್ಲ ಅಲೋ ಮಾಡಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾವು ಐಡೆಂಟಿಟಿ ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇರೋದು ಅಪ್ಲಿಕೇಶನ್. ಅದರಿಂದ ಐಡೆಂಟಿಟಿ ಅಪ್ಲಿಕೇಶನ್ ಕೇಳಿದಾಗ ಇವ್ರನ್ನೆಲ್ಲ
you have sought the relief against all.
8 to 11 ಮಾತ್ರ ಅವರು ಎಲ್ಲರ ಮೇಲೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. ನಾವು ಐಡೆಂಟಿಟಿ ಕೇಳಿದ್ರು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಾಡಿರೋದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅವರು IL ನಂಬರ್ 1 2 3 ನ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರು. ನಾನು ಕೇಳಿದ್ದೀನಿ 28 ಅಥವಾ 18 ಮಾತ್ರ ಕೇವಿಟ್ ಹಾಕಿದ್ದಾರೆ, ನಿಮ್ಗೆ ಏನು ಪ್ರೆಸೆನ್ಸ್ ಅವಕಾಶನೇ ಇಲ್ಲ, ನೀವು ಯಾರನ್ನು ಹಿಯರಿಂಗ್ ಮಾಡಲ್ಲ, ನಿಮ್ಗೆ ರೈಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ರು.
ಅವ್ರ ಸಬ್ಮಿಷನ್ ನಿಮ್ ಸಬ್ಮಿಷನ್ ಹೇಳಿ ಏನು ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ.
ಎರಡನೇದು ಈಗ ತಿರ್ಗಾ ಅವ್ರನ್ನ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ರೆ ತಿರ್ಗಿ ರಿವ್ಯೂ ಆಗ್ಬೇಕು. ಅವ್ರ ಬದಲು ನಮ್ಗೆ ಅಪ್ರೂವ್ ಮಾಡಿ ಈಗ ಅವ್ರ ಮೇಲೆ ಹೋಗ್ಲಿಕ್ಕಿದೆ ಅಂತ ಹೇಳಿ ಚಾನ್ಸಸ್ ಇರೋದ್ರಿಂದ ಸರ್ವಿಸ್ ಆಗ್ತಿದೆ.
The council submits that the presence of those parties are also necessary, having considered the submissions of the appellant counsel and also the counsel appearing for the respondent, and also it is an admitted fact that those who have not been appeared before this court are not appeared before the trial court, and in their absence an order has been passed, and hence question of considering and question of issuing notice against them and hearing before this court doesn't arise, since this is a miscellaneous first appeal is filed against the order passed by the trial court. ಹೇಳಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ ಎಲ್ಲರೂ. Was there any interim order before the trial court? ಇರ್ಲಿಲ್ಲ. ISR rejected. I will set aside this order and remand the matter. You take service notice against all of them. ಯಾರು? ಆಯ್ತು, ನೀವು ತಗೊಳ್ಳಿ ಸ್ಟೆಪ್ಸ್. ನೀವು ರಿಲೀಫ್ ತಗೋಬಿಟ್ಟು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದೆಲ್ಲ ಇದ್ರೆ ನಾವೇನ್ ಮಾಡ್ತೀವಿ? Any of counsel others have not been heard before the trial court. I will set aside the matter, consider the applications after securing all of them, and dispose of the matter on merits. That's all. How a court can pass such an order? That's what I am telling him. Let the trial court decide.
Because some person he has made parties here.
Even if they comes and appears before this court without any pleading, how can this court can consider them in a miscellaneous appeal? The right course is to set aside the order and remand the matter to consider the matter before the trial court after giving them notice, because they sought the relief against all of them.
Another sufficient. No order is asked against.
Whatever it may be. Now, if this court passes an order, it will affect them. Already, our Saru Madaru Nanen Madaka, first of all, no pleadings before the trial court. Alwa, our objections are Akilla. How this court can sit and decide in an MFA? Their absence.
Another sufficient is.
Ah.
We serve here and.
ಈ ಸ್ಟೇಟಸ್
ಅಲ್ಲ ನಾನೇನ್ ಮಾಡೋದಿಲ್ಲ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಹಾಕ್ತೀನಿ ಅವ್ರು ಯಾವಾಗ ಸರ್ವ್ ಮಾಡ್ಕೋತಾರೋ ಐ ವಿಲ್ ಗಿವ್ ಎ ಟೈಮ್ ಬೌಂಡ್ ಇದನ್ನ ನೀವು ಸರ್ವ್ ದೆಮ್ ಅಂಡ್ ಕನ್ಸಿಡರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆನ್ ಅಫ್ರೆಶ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ದಟ್ಸ್ ಆಲ್ ದಟ್ ಈಸ್ ದಿ ಕರೆಕ್ಟ್ ಕೋರ್ಸ್ ಆಫ್ ಆಕ್ಷನ್ ಈವನ್ ಇಫ್ ಯು ಸರ್ವ್ಡ್ ಹಿಯರ್ ದೋಸ್ ಪರ್ಸನ್ಸ್ ವಿತೌಟ್ ದೇರ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಂಡ್ ಹೌ ಕ್ಯಾನ್ ಕಮ್ ಅಂಡ್ ಆರ್ಗ್ಯೂ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಅವರು ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ. You get it served the same on the other parties also. That's all. That is the correct course of action. ಆದ್ರೂ ಏನಾಗಲ್ರಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ಸೂಟ್ ಆಗಿದೆ ಹೌದಲ್ವಾ ಸೆಕ್ಷನ್ 52 ಅಟ್ರಾಕ್ಟ್ ಆಗ್ತದೆ ಈವನ್ ಖಾತಾ ಚೇಂಜ್ ಆದ್ರೂ ಏನು ಅವ್ರಿಗೇನು ದೇ ವೋಂಟ್ ಗೆಟ್ ಎನಿ ರೈಟ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಸೂಟ್ ಏನು ಹಾ ಮತ್ತೆ ತಗೊಳ್ಳಿ heard the appellant counsel and also the counsel appearing for the respondent. Appellant counsel submits that the trial court committed an error in rejecting IA number 123, wherein a prayer is made to not to change the kata and not to encumber the suit schedule property and not put up any construction. And trial court committed an error in dismissing all the IAs and it requires interference. The respondent's counsel would submit that the trial court considered the applications on merit and relief is also sought not only against the respondents who are before this court and the order has been passed even without service of notice against the other respondents and question of granting any interim order before this court doesn't arise. Having heard the appellant counsel and also the counsel appearing for the respondents and taking into note of the plaint averments and also the IAs which have been filed inter alia seeking the relief of temporary injunction and main prayer is declare the plaintiffs number 1 to 6 are the absolute owners of the suit schedule A property and suit schedule B and C are portion of suit A schedule A property belong to them. The appellants have also filed the appellants also sought for the relief of mandatory injunction against the defendants to restore the physical possession of the suit B and C property, which is portion of suit schedule A property, and direct the defendants number 1 to 28 to pay a sum of rupees 1 lakh per month towards the illegal and unauthorized occupation of the suit schedule B and C schedule property from the date of suit, until the restoration of possession of the said properties in favor of the plaintiffs. And to declare common final order dated 19/12/2019 passed in RRT between defendant number 1 to 25 and the file of the Deputy Commissioner Bangalore is not binding and also to declare withdrawal of appeal number 174 bar 2020 which is a collusive act of defendant number 1 to 25 and also sought for permanent injunction. This court has already pointed out that the interim orders are also sought not to change the nature of the not to change the kata and also not to encumber and also not to put up any constructions. And when this suit summons has not been served against the other respondents and trial court also considered those applications and when the relief is sought against all the respondents and trial court when not issued any ad interim injunction ought to have taken care of other respondents also and directed the plaintiff to get it served the summons against the other respondents also and thereafter considered the applications and the same has not been done. Before this court also, this court has directed to serve the other respondents also, but respondent counsel expresses his inability to serve the notice against the respondent number 8 to 9. And when such being the case, appellant's counsel And when the appellant counsel is unable to secure them before this court also, it is appropriate to set aside the order of the trial court and to consider the matter afresh. And the appellant is directed to serve the notice against the respond number 9 to 11. And also to bring the legal heirs of respond number 16. And counsel submits that already has filed the application and the same is pending for consideration. Hence, the trial court is directed to consider the LR application in respect of respond number 16. And if the appellant counsel serves the notice against respond number 8 to 11, and the trial court to give an opportunity to both of them to complete their pleadings and within 15 days from their appearance, and thereafter consider the pending IAS, consider this IAS within span of 15 days from that date. With this observation, MFA is disposed of. Manjunatha G. 11th and ಏನ್ ಪಾಸ್ 6th ಏನ್ 6th ಏನಾಯ್ತು ಆಫ್ಟರ್ 2 weeks ಅಂತ ಮಾಡಿದ್ವಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಜಾಸ್ತಿ ಇದಾಗಲ್ಲ, ಅದಕ್ಕೆ 2 weeks ಮಾಡಿರೋದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೀವು ಮಾಡಿದ್ರು ರೀಚ್ ಆಗಲ್ಲ. ಏನ್ ಮಾಡೋಣ ಆಗಂತ ಇಲ್ವಲ್ಲ. ಹರ್ಡಿಂಗ್ ಪಾರ್ಟ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್, ನೋಟ್ಸ್ ಅನ್ನೋದು ಇದೆಯಾ? ವೈ ಇಟ್ ವಾಸ್ ಅರ್ಜೆಂಟ್ ಮೇಡಮ್? ಇದು ಹರ್ಡಿಂಗ್ ಪಾರ್ಟ್ ಆಗಿದೆಯಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದ್ರೆ ನೋಡಿ ಹಾಕೊಳ್ಳೋಣ ಅಂತ. ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ನೋಡ್ತೀರಾ? ನಾನು ನೋಟ್ಸ್ ಮಾಡಿದ್ದೀನಾ? ಏನ್ ಹೇಳಿದ ಹರ್ಡಿಂಗ್ ಪಾರ್ಟ್ ಅಂತಂದ್ರೆ ಐ ಕುಡ್ ರಿಕಲೆಕ್ಟ್ ಮೈ ಮೆಮೊರಿ. ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ, ಕೊಡಿ ಮೇಡಮ್. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಾರಲ್ಲ ಯಾರು? ಲೆಂತ್ ನಮ್ಮ ಹತ್ರ ಏನ್ ನೋಟ್ಸೇ ಇಲ್ಲ. ಆಯ್ತು, 2 ವಾರ ಬಿಟ್ಟು ನೋಡೋಣ. ನಮ್ ರೋಸ್ಟರ್ ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ ಬೇರೆ ರೋಸ್ಟರ್ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ. Statement of objections on 31-124 and he has served the copy of the same on the other side. Heard the learned illidiala madam. Heard the learned counsel of respective parties in part anta ಮಾಡಿದೀವಲ್ಲ 31-1 ಅಲ್ಲಿ. ಅದೇ ವರ್ಡ್ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತೆಲ್ಲ ಬರಿಬೇಕಾ? ಮತ್ತೆ ಇಲ್ಲಿ ಇದೆಯಲ್ಲ, heard the learned counsel for respective parties in part ಅಂತ ಇದೆಯಲ್ಲ. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಇದರಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಡೇಟ್ ಕೊಟ್ಟಿದೆ 2 weeks ಅಂತ. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡಿ ಮುಂದಿನ ಯಾವ್ದಾದ್ರು ವೀಕಲ್ ಹಾಕಿರಿ, ನೋಡೋಣ ರೀಚ್ ಆದ್ರೆ ನೋಡೋಣ. 22nd ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರ ಇದ್ರಲ್ಲಿ? ಇಲ್ಲ, ಅವರು ಇದ್ರ ಅರ್ಜೆಂಟ್ ಆಗುವಾಗ ಬೆಳಗ್ಗೆ ಅಲ್ಲ, ನಾನೀಗ ಅರ್ಜೆಂಟ್ ಮಾಡುವಾಗ ಇದ್ರ ಇಲ್ಲ, ಅವ್ರು ಇರ್ಲಿಲ್ವಾ? ಆಯ್ತು ಸರಿ. ನೋಡ್ಬೇಕ್ರಿ, ಅವ್ರು ಹಾಕ್ಬೇಕಾರ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲಿ. 11 ಹೇಳಿ ಮೇಡಮ್. ಕೌನ್ಸಿಲ್ ರಿಗಾರ್ಡಿಂಗ್ ಫಾದರ್ ನೇಮ್ ಅಪಲೆಂಟ್ ಟು ಬಿ ಕರೆಕ್ಟ್ಲಿ ಸ್ಟೇಟೆಡ್ ಅಂತೇನೋ ಇದೆಯಲ್ಲ, ಅದೇನದು ಏನ್ ಸಬ್ಮಿಷನ್ ನಿಮ್ದು? ದೊಡ್ಡ ಮೋಟಪ್ಪ ಅಂತಿದೆ.
ಮೋಟಯ್ಯ ಅಂತ ಇದೆ. ನೆಕ್ಸ್ಟರ್ ಸಿ ಪ್ರಕಾರ ನಾವು ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ನೆಕ್ಸ್ಟರ್ ಸಿ ಪ್ರಕಾರ ನಾವು ಆತರ ಹೆಸರು ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ ಸರಿ, ನಿಮ್ ಸಬ್ಮಿಷನ್ ಏನು ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲೇ ತಪ್ಪಾಗಿ ಮಾಡಿದಾರೆ ಅಂತನಾ? The counsel appearing to the appellant would submit that the name of the father of the first respondent correct ಯಾರು? ಇಲ್ಲಿ appellant ಅವ್ರಿಗೆ appellant ಇಲ್ಲ. appellant is mentioned as Dodda Motaya and his name is and the same is based on the annexure C, and while filing the suit before the trial court erroneously mentioned as Dodda Motappa, and hence counsel submission is accepted. ಅದ್ ಬಿಟ್ರೆ ಇನ್ನೇನಿದೆ ಬೇರೆ? ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಷ್ಟಿದೆ ಬೇರೆ? ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಎಷ್ಟಿದೆ ರೀ? ಎಷ್ಟು ದಿವಸ ಬೇಕು?
ಆದ್ಮೇಲೆ 2 ದಿವಸ
ಎಷ್ಟು ದಿವಸ ಬೇಕು?
ಕರೆಕ್ಟ್ ಆಗಿ ಸ್ಟಿಚ್ ಮಾಡ್ಬೇಕು ಅಂತಿದೆ.
ಸ್ಟಿಚ್ ಮಾಡ್ಬೇಕು ಅಂತ ಒಂದು ಆಮೇಲೆ
ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಇನ್ ದ ಮೇನ್ ಇಂಡೆಕ್ಸ್.
ಮೇನ್ ಇಂಡೆಕ್ಸ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಹೇಳಿಲ್ಲ ಅಂತ ಆಯ್ತು. ಕೌನ್ಸಿಲ್ is given another 2 days time to comply with other office objections. If office objections are complied, if other ಇಲ್ಲ 2 ಇದೆ ನೋಡ್ರಿ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲೇನೆ ಇದೆ 2 ಮಾಡಿ. 2 ದಿವಸ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಉಲ್ಟಾ ಮಾಡಿದ್ದಾರೆ ಸರಿ.
ನೋಡಿ ಎಲ್ಲ ಉಲ್ಟಾ ಮಾಡಿ ಇಟ್ಟಿದ್ದೀನಿ ಪೇಜಸ್ ಎಲ್ಲ. ಬಟ್ ಅದನ್ನೇ ಕರೆಕ್ಟ್ ಮಾಡಿ. ಹಿಂದಿನ ಪೇಜ್ ಉಲ್ಟಾ, ಹಿಂದಿನ ಪೇಜ್ ಇನ್ನೊಂಥರ. ನಾವು ಹಿಂಗ್ ಉಲ್ಟಾ ತಿರ್ಸ್ಕೊಂಡು ಓದ್ಬೇಕಾ? ಮತ್ತೆ ಮಾಡಿ ಮಾಡಿ ಮಾಡಿ. 2 days ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ರೀ. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ನಿಮ್ಗೆ? ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಏನು? ಆಯ್ತು. ಕೌನ್ಸಿಲ್ ಇಸ್ ಗಿವನ್ 2 days ಟೈಮ್ ಟು ಕಂಪ್ಲೈ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ 22nd ಹಾಕ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ತೀನಿ. ಹೇಳ್ಬೇಕು ನೀವು. 22nd ಆಯ್ತು. 22 2 ಎಷ್ಟು ರೀಚ್ ಆಗುತ್ತಾ ಎಷ್ಟು ರೀಚ್ ಆಗೋಲ್ಲ ಗೊತ್ತಿಲ್ಲ. 22nd 19 ಹ್ಮ್ 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 That is also considered in the earlier order also. ಆಯ್ತು. 26th ಮೇಲೆ ಏರ್ ಮಾಡೋಣ, ಅರ್ಜೆಂಟ್ ಇಲ್ಲಲ್ಲ. ಅವಾಗೇನ ಲೀಸರ್ ಆಗಿದ್ರೆ ನೋಡೋಣ. ಯಾಕೆಂದ್ರೆ MFS ಬಹಳಷ್ಟು ಅಡ್ಮಿಷನ್ಸ್ ಇದೆ. ಹೊಸ ಮ್ಯಾಟ್ರಸ್ ಇರುತ್ತೆ, ಅರ್ಜೆನ್ಸಿ ಇಂಟ್ರಿಮ್ ರಿಲೀಫ್ ಬೇಕಾಗಿರುತ್ತೆ, ಆ ತರದ್ ಇರುತ್ತೆ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇನ್ ದಿ 4th week ಆಫ್ ಅದಂಗೆ ನಮ್ಮ ಮುಂದೆನೆ ಬರುತ್ತೆ. ಡೇಟಾ ಕೊಟ್ಬಿಡೋಣ, ಕೊಡಿ ಮೇಡಮ್. RP ಅದು ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಸ್ಟ್ 4/3 ಡೇಟ್ 4/3. ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್? 24. ಹ್ಮ್ Partition and separate possession.
With respect to 1/3 share, they have contended that Janardhan Reddy is their father. He is touching the witness of the fruitful property. Janardhan Reddy has acquired property through mutual partition deed from his father. But is not
ಅಂದ್ರೆ suit for property originally belongs to one Janardana Reddy.
father of the appellant and the first point. The first point, without mentioning the.
ಅಲ್ಲ, Janardana Reddy is still alive or how many children he is having?
It's about 104.
104.
Janardhan Reddy had 3 wives. First wife is Usharani. She died. And she had a daughter by name Kavita, that is the first one.
Right.
The second wife by name Rajamma. And for Rajamma, the appellant number 2 upper these appellant 1 to Rajamma. And the third wife by name Manadashi.
Second wife having 2 children.
Yes.
Third
wife by name Manadashi. She also died. All the mothers died. And
third wife.
Unmarried. Now, the Janardhan Reddy is only 3 children. Kavita and Anthony Raj and Santosh Kumar.
Who is the plaintiff now?
Plaintiffs are Anthony Raj and Santosh Kumar. The second wife children.
Plaintiff number 1 and 2.
In the suit for partition, they filed an application and order 39 rule 1 and 2, that is I number 1, for not to alienate the social property. And I number 2, for not to put up any construction. The trial court considers the request of the plaintiff granted an interim order. Thereafter, the
Add interim order.
thereafter, the respond number 2 and 3. 2 and 3, being the developers, have filed an application for vacating the stay.
2 and 3.
They are, they came before this hour for filing an application for vacating the interim order.
Before this honorable court. They have not filed any. They are also the
Yes,
parties
yes,
there.
yes. And the lawsuit may kindly read the para 12 of the.
Is there any dispute that property is not belongs to this Janardana Reddy?
Other
Dispute illa.
dispute.
Right.
The issue is, they are disputing that the appellants are not the children of Janardana Reddy. Really, para 12 of the order of the learned translate at page 35. Very clear. It is page 35. It is to note that the plaintiffs have produced copies of the Aadhaar card of themselves and their mother Rajamma. Rajamma's also. Their school leaving certificate and SSLC marks in order to prove the status of their mother as legally wedded wife of Janardana Reddy and their own status as legitimate sons of Janardana Reddy born through Rajamma. It is worth to note that in the Aadhaar card, the plaintiff's mother, Srimati Rajamma, has been described as wife of Janardana Reddy. Further, in the other cards, these plaintiffs have been shown sons of Janardana Reddy. That apart, in school leaving certificates issued by Mahatma Children's Home, CH-11 Primary and High School, third page, JP Nagar, the name of Janardana Reddy is reflected in the father's column. Further, the father's name of these plaintiffs have also been shown in the Janardana Reddy in the SLC marks card issued by the Karnataka Second Education Board. It is needed to say that the entry of the name of Rajamma as wife of Janardana Reddy in the Aadhaar card and the entry name of these plaintiffs as sons of Janardana Reddy in their school records have been affected undisputed point of time. Therefore, these entries have got evidential value as per section 32, 2 and 5 of Indian Evidence Act. Thus, these entries in the Aadhaar card and school records prima facie records to believe that this state that plaintiffs are legitimate sons of the deceased Janardana Reddy. Then, the lawsuit may turn to page 43, para 15, fourth line. I have heard that plaintiffs have produced
Paragraph, which para?
paragraph 15, page 43.
No, 43.
Interview. While discussing point number 1, I have heard that plaintiffs have produced prima facie records to believe at this stage that they are the legitimate sons of the deceased Janardana Reddy. And having undivided 1/3 share each in the scheduled property, the learned judge has accepted the contention of the plaintiff's mother. Now, while passing the impute order, the learned judge has partly allowed the application filed by these appellants. Impute order is that they have stated that the defense number 1 to 3 are hereby temporarily restrained from alienating 35% of the share of the first defendant. Here, the first defendant, in collision with respondent number 2 and 3, have created a registered agreement of same, registered joint development agreement.
JDU.
And registered general power attorney, and also registered amalgamation case. Those that in the said registered document, nowhere they have mentioned about the appearance here in the. Admittedly, the court has also held that this property comes to the property of Janardana Reddy. Now, this respondent 2 and 3, being the developer and agreement holder, have also filed a written statement. And the first defendant Kavita also filed a written statement. Nowhere in the written statement, my lord, she has disputed with respect to the position of this appellant. If the appellants came before the trial court saying that they are not the children of Janardana Reddy, she is having the option to file a criminal case and other proceedings against her. In the written statement, except denial, she has not stated anything before the trial court. In the vacating stay application, they have filed objection to my application. Objection, sir. Page number para 7 ಗೆ deny ಮಾಡ್ತಾರೆ.
Vacancies there, objections. When we, para 7 in the ಮುಂಚೆ, 4 ಬೇಕು. It is pertinent to objection power.
ಏನಿದೆ ಪೇಜ್ ನಂಬರ್
Vacancy application.
ನೀವು ಹಾಕಿದ್ರೆ ಇಲ್ಲಿ
ಹಾಕಿದ್ದು,
Page.
vacancy application.
ಆಯ್ತು ರೀ ಪೇಜ್ ನಂಬರ್ ಯಾವ್ದು ಹೇಳಿ ಯಾರು ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ ಈಗ ಹಾಕಿ
Vacancy application.
ಇಲ್ಲ ಹಾಕಿದಾರ
ಹಾ. Vacancy application file ಬೇಕು.
ಇಲ್ಲೇನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಈಗ ಅರ್ಲಿಯರ್
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ 55% ಆಫ್ ದಿ ಶೇರ್ ನ ಮಾರ್ಬೇಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಆಯ್ತು
ನಂದು they are entitled for she is entitled only for 33.3 points share
ಹಾ
over the entire extent of that.
ಆಯ್ತು
ನಂದು 63 points add ನಂದು share ಇದೆ.
ಹಾ
ಇಲ್ಲಿ ಈ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವೇಕೆಂಟ್ ಸ್ಟೇಲ್ ಅಲ್ಲಿ
ಹ್ಮ್ ಅಲ್ಲ ಇಸ್ ದೇರ್ ಎನಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್
Yes, sir.
ಏನ್ ವಾಟ್ ಇಸ್ ದಟ್ ಆರ್ಡರ್
ಅಲ್ಲಿ ನಾನು
ಇಲ್ಲಿ ಮಾಡಿರೋ ಎಂಟೈರ್ ಆಗಿದ್ರು ಹಾ
ಇಲ್ಲಿ ಅವ್ರ ವೇಕೆಂಟ್ ಸ್ಟೇಲ್ ಅಂತ
ಹ್ಮ್
application dated 1
memorandum of application
filed by respond number 2 and 3.
ಯಾವಾಗ ಅದು ಡೇಟು ಹಾ 1/2/24
Para 7 is interesting. You wait. Para 7 ಮೇಲ್ para 6 ರಲ್ಲಿ it is pertinent to note that.
ಪ್ಯಾರಾಗ್ರಾಫ್
Para 7
Seven ಅಲ್ಲಿ, ಹಾ.
Para 7 ಗೆ ಮುಂಚೆ 3 ಲೈನ್.
ಹಾ
It is pertinent to note that. I'll not cut it.
ಹಾ one second one second para 7 above paragraph number
Para 7. It is pertinent to note that the construction of apartment.
it is pertinent
It is pertinent to note that the construction of apartment in the scheduled property is an improvement of the joint family property of the family of the first respondent.
Hmm.
When the respondent number 2 and 3 are also aware that
Hmm.
this property is the joint family. My prayer before your lordship is,
Hmm.
suppose by virtue of the learned trade or input order, and restrain the respondent number 2 and 3 to not be let 35% of the share of the Kavita.
Hmm.
My share, suppose if they sold entire property,
Hmm.
I will be in the streets.
Hmm.
That's why my prayer before your lordship is, she is entitled for 33.3% share.
Hmm.
Let the developer be enjoy this authority in terms of the registered document.
Hmm.
He dispose of this.
Hmm.
If they are sold the properties, the apartments have been 93 apartments have been constructed.
Hmm.
And without my knowledge, they are going to sell the property.
Hmm.
In order to protect the interest of these appellants,
Hmm.
my prayer before your lordship, Kavita is entitled only for 33.3% share in social property.
Hmm.
The alleged registered documents are not binding on these.
Hmm.
That is, by virtue of it, I have filed appeal and I have paid this court as of a hearing the matter. Entire portion.
Hmm.
Now they have filed
Hmm.
an application for a hearing.
yes
Even 8/21.
31
8/21. December 21, the earthworks started on the top.
December
21, the earthworks started.
ah
The actual construction started in the month of June 2022.
hmm.
Suit is filed on 13/3/23.
Hmm.
By which time we had already constructed 4 floors.
4 floors
4 floors.
ah
That was the time when they came before the Supreme Court. This English imperative, without there being any litigation, there was a sharing agreement on 4/11/22 on sharing of floor area basis.
that is between you and the developer
Yes.
Ah.
Floor to floor are sharing 65% and 35%. 35% floor area has gone to them in every floor. That 65% has gone to come to in every floor. The adjustment is 32% if it is given in the ground floor. You will get 2%, 3% extra.
in other floor
That's all.
Hmm.
This is the adjustment which we made.
Hmm.
And this entire, now he comes up and says, because what is stated in the joint development agreement, and what has been stated is that this is the actual property. Because whatever documents they gave, they say that they are the only owners.
Hmm.
They came and said that they are also entitled for this. So what we are saying is only this. That is what we said even before the time. I'm already putting my entire investment on this building. The building is virtually in the zero. I'm entitled to 65%. There is a sharing agreement dated 4/11/22.
And how you are entitled for 65%?
It's after construction.
After construction in constructed area.
Constructed area ನಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಅವರು 1 ಕೋಟಿ ರೂಪಾಯಿ ಆಗಿಲ್ಲ ಅವರು ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂ
ಗೊತ್ತಾಯ್ತು.
ನಾವು 2 ಕೋಟಿ ರೂಪಾಯಿ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ 4 ಕೋಟಿ ರೂಪಾಯಿ ದುಡ್ಡು ಬರುತ್ತೆ ಈ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್
ಆಯ್ತು ಗೊತ್ತಾಯ್ತು ಬಿಡ್ರಿ ನಾ ಏನೋ ಆಯ್ತು.
ಹಾಗಾಗಿ reason why I'm saying is the value of construction will be more than the value of the land. That's the reason why 65%, 25%, wherever it is sharing of the built-up area. So now I'm entitled to 65% of the constructed area. Because they have not raised any objection that there is anything inequitable in 4/11/22 sharing agreement. ಏನಾದ್ರು sharing agreement ಇದು acceptable ಅಲ್ಲ ಅಂದ್ರೆ 4/11/22
sharing agreement.
Sharing agreement, I'm going beyond that and taking this statement. We have done the sharing agreement in a way that in every floor, there is a sharing of 35/60. If 2 floors are taken together, it is 35/65. Because when the saleable area comes to, there is some variation. We have understood the next floor. That is what we have done this. If you also to see the sharing agreement, you understand exactly how that. There's no grievance over this. But there are a series of judgments to like this, ask them to get all the judgments like this, market and given to us. Consistently, this one will go after the other items are consistently taken into. And once a development is made over a property, it belongs to multiple persons. And to the extent of the property which is entitled to by the owners, that can be subject matter of litigation. Because property is already developed. That can be subject matter to this. But for my investment, they should not because they will also get the benefit. If they had taken just the land, it would have been just about say, if it was 1 crore, they would say 60 lakhs. But now their value, even if they are taking, if it was 60 lakhs, they'll be taking more than 1 crore because of the construction which I have put up. So they stand to get benefited. That is how this one will put also accepted the scenario. Wherever development is made in a manner that there is a enhancement of the value of the estate, then they cannot come and say that there is some injury cost to them because it's actually an enhancement of estate. Now what they get is, they should also understand. ಜಮೀನು ಇಟ್ಬಿಟ್ಟು ಭಾಗ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ 3 ಜನ 4 ಜನ ಭಾಗ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಎಲ್ಲೇ ಯಾರಿಗೆ ಭಾಗ ಮಾಡ್ಬೇಕು ಇಲ್ಲಿ ರೋಡ್ ಇದೆ ಅಲ್ಲಿ ರೋಡ್ ಇದೆ ಎಲ್ಲ ತಕರಾರು ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಬರುತ್ತೆ 30 ಅಪಾರ್ಟ್ಮೆಂಟ್
ಆಯ್ತು ನಿಮ್ಗೆ ಈಗ ಆಲ್ರೆಡಿ ಪ್ಲಾನ್ ನಿಮ್ಮ ಪ್ರಕಾರ ಪ್ಲಾನ್ ಎಲ್ಲ ಇದೆ ಏನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಎಲ್ಲ ಇದೆ ಎಷ್ಟು ಫ್ಲಾಟ್ಸ್ ಬರುತ್ತೆ ಈಗ
95 ಅಪಾರ್ಟ್ಮೆಂಟ್ ಬರುತ್ತೆ
ಟೋಟಲ್ 95 ಫ್ಲಾಟ್ಸ್ ಅದ್ರ ನಿಮ್ಮ ಪ್ರಕಾರನ ಈಗ 65-35 ಆದ್ರೆ ಎಷ್ಟು ಫ್ಲಾಟ್ಸ್ ನಿಮಗೆ ಬರುತ್ತೆ ಅವ್ರಿಗೆ ಎಷ್ಟು ಹೋಗುತ್ತೆ ಸೂಟ್ ಇಟ್ಕೊಳ್ಳೋ ಬದಲು ಇಲ್ಲ ಡಿಸೈಡ್ ಮಾಡೋಣ ಅಂದ್ರೆ ನಿಮ್ಮ ಅಲ್ಲ ನಾನು ಹೇಳೋದು ಈಗ 65-35 ಅಲ್ಲೇ 31-34 ಅಲ್ಲಿಗೆ ಆಗದೆ ಅಲ್ಲಿ ಟೋಟಲ್ ಬರೋದೇ 93.
Share, it will be 32 flats. As mentioned, the fact that if they have no grievance against this, sharing agreement.
You can accept the sharing plan. You are 50-50 ಅಂತ ಅಲ್ಲ ನಾನೇನ ಮಾಡಿ. ನಾನು 15% share I will
sharing agreement ನೋಡಿ. sharing agreement ನಲ್ಲಿ ಯಾವುದಾದ್ರೂ ರೀತಿಯಲ್ಲಿ ಇವರೇ ಒಂದು ಪಕ್ಷ ವ್ಯವಹಾರ ಮಾಡ್ತಾರೆ ಅನ್ಯಾಯ ಆಗಿದೆ ಅಂತ ಏನ ಬಗೆಹರಿಸಿಕೊಂಡಿದೆ
Anyhow, they have also invested the money for the development of the property. ಆಯ್ತು ಈಗ ನಿಮ್ಮನ್ ಬಿಟ್ಟು ಮಾಡಿದಾರೆ ಆಯ್ತು ಈಗ ನಿಮ್ಮನ್ ಬಿಟ್ಟು ಮಾಡಿದಾರೆ ಅಂತ ಅಂದ್ರೆ ಈಗ ಶೇರಿಂಗ್ ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ ಏನ್ ನೋಡಿ ಮಾತನಾಡಿ ಏನಾಗುತ್ತಾ ನೋಡ್ಕೊಳ್ಳಿ ಈಗ ನಾರ್ಮಲ್ ಈ ಬಿಲ್ಡಿಂಗ್ ಸೈಟ್ ಓನರ್ ಅಂಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನಾರ್ಮಲ್ ಎಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ But ನನ್ನ ಪ್ರಕಾರ ಇಲ್ಲಿ 35-65 it appears to be on higher side.
Something like this.
45.
Just indicate.
ಈಗ ಇವನ್ ನಾವು ಪ್ರಾಪರ್ಟಿ BDNR ಇಂಪ್ರೂವ್ ಮಾಡೋದಾದ್ರು 60-40 ಬೇಸಿಸ್
ಹೌದು.
ಅಲ್ಲ, ಅದು
ಹಾ.
I-
ಹಾ
whenever we are doing on the plotted development ನಲ್ಲಿ 120 ರೂಪಾಯಿ ಒಂದು ಚದರಡಿಗೆ ತುಂಬಾ ಹೈಟೆಕ್ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ 200 ರೂಪಾಯಿ ಒಂದು ಚದರಡಿಗೆ ಇಲ್ಲಿ ನಮಗೆ ಮಿನಿಮಮ್ 2,500 ಕಾಸ್ಟ್ ಬರುತ್ತೆ. ನಾವು ಕಟ್ತಾ ಇರ್ತಕ್ಕಂಥದ್ದು ಇಟ್ಸ್ ಹೈಯೆಂಡ್ ಅಪಾರ್ಟ್ಮೆಂಟ್. ಇಟ್ಸ್ ಎ ಗುಡ್ ಕ್ವಾಲಿಟಿ ಅಪಾರ್ಟ್ಮೆಂಟ್.
ಗುಡ್ ಕ್ವಾಲಿಟಿನಲ್ಲಿ ಗುಡ್ ಇದು ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಇರುತ್ತೆ. ನೀವು ಫ್ಲೋರ್ ಮೇಲಕ್ಕೆ ಹೋದಂಗೆಲ್ಲ ಜಾಸ್ತಿ ರೇಟ್ ಇರುತ್ತೆ. ಎಷ್ಟು ಫ್ಲೋರ್ ಇದೆ ಇದು?
5 floors. 5 floors ಇದೆ.
Hmm.
The reason why I am saying this is what benefit I get, the same benefit they also get. ಈಗ
only the dispute is with regard to the percentage of sharing agreement. ಈಗ 65-35. ಹಾ.
ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ನಲ್ಲಿ 65-35 65 is the norm. ತುಂಬಾ ಕಳಪೆ ಡೆವಲಪರ್ಸ್ ಯಾರು ಬಂದ್ರೆ 62% ತನಕ 65% ಇದು ನಾವು ಎಂಬಸಿ ಅವರಿಗೆಲ್ಲ ಕೊಡ್ತಾರೆ. 70-30. ಯಾಕೆಂದ್ರೆ ಈಗ ನಾನು ಇಲ್ಲಿ 90 ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇರ್ತೀನಿ. ನನ್ನ ಬ್ರ್ಯಾಂಡ್ ನೇಮ್ ಅಲ್ಲಿ ನಾನು ಒಂದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ನ 1 ಕೋಟಿ ರೂಪಾಯಿ ಬರುತ್ತೆ. ಎಂಬಸಿ ಅವ್ರಿಗೆ ಕೊಡ್ತಾರೆ, ಅವ್ರು 70-30 ಮಾಡ್ಕೊಡ್ತಾರೆ. ಏನಕ್ಕೆ ಅಂದ್ರೆ ದಟ್ ಸೇಮ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಐ ಕ್ಯಾನ್ ಸೇಲ್ ಇಟ್ at 1.2 crores. So it all depends even on the bidder.
You both sit together and take decision ಅಷ್ಟೇ.
ನಾನು ಹೇಳ್ತೀನಿ ನಾನು ಸೇಲಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್ ನೋಡಿ ಅವರು ಅಪೆಲೆಂಟ್ they have to sit and find
Sit
out
together.
ಏನೇನ್ 35% ಏನ್ ಕೊಟ್ಟಿದ್ರೆ ಅದು ಏನ್ ಹಂಚ್ಕೋಬೇಕು ಅವ್ರು ತೀರ್ಮಾನ ಮಾಡಿ. ಅವರು
ಎಲ್ಲ ಒಪ್ಪಿದ್ದಾರೆ.
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
These are all arguments. On the premises that the babies on the children of Janasari, that itself is a disputed fact to be tried for. ಇಲ್ಲಿ MFN ನಾವು ಆರ್ಟಿಸ್ಟ್ ಡಿಸೈಡ್ ಮಾಡೋದು that.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಟ್ ಇಸ್ ಒನ್ ಟೈಮ್ ಸೊಲ್ಯೂಷನ್ ಫಾರ್ ದಿ ಡಿಸ್ಪ್ಯೂಟ್ ಅಷ್ಟೇ. if you are agreeable to consider them also they are the children, ಆಗ you can sit and take a decision for compromise. or otherwise ಈಗ ಏನಾಗ್ತದೆ, ಈಗ ಮತ್ತೆ ಈಗ ರಿಲೀಫ್ ಸ್ಟೇ ಕೊಡೋದು 65% 35% it will not materialize.
ಸಮಸ್ಯೆ ಇದೆ. ಅವ್ರು ಗಮನಕ್ಕೆ ತರ್ತಾ ಇದ್ದಾರೆ. Page 103 ನೋಡ್ಸಿದ್ವಿ. 103 is the family tree. Page 104. ಇದು there are Hindus. Janardhan Reddy is a Hindu. Anthony Raj and Santosh Kumar are converted to Christians. There is an embargo on section 26 of the Hindu Succession Act for them to claim for succession. I am not going on that point. If they have to contest on the merits.
My friend replied, Rajamma is easy to change. I am not. His father's
father is a Hindu.
father is a Hindu. I am not converted. He is not converted. You are in all the record. His name is shown as. I will furnish document.
Anthony Raj
Allah, even in the Aadhaar card, I am.
ಅಲ್ಲ ಇಲ್ಲಿ ಒಂದು ಅಂತೋಣಿ ರಾಜ್ ಇದೆ, ಇನ್ನೊಂದು ಸಂತೋಷ್ ಕುಮಾರ್ ಇದೆ.
I'm saying because if Rajamma was
ಅಪ್ಪ ಅಮ್ಮ ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡಂಗ
what happens? In that event, what happens? Section 26 of the Hindu Succession Act, where before or after the commencement of his acting, cease or ceases. He has either ceased.
If I converted.
He has ceased or ceases to be Hindu. Either by conversion to any other religion, children born to him or her after such conversion and their descendants can be disqualified from
ಆಯ್ತು ಇಲ್ಲಿ
property of the Hindu.
ಫಾದರ್ ನ ಲೆಕ್ಕಕ್ಕೆ ತಗೋತೀರಾ, ಮದರ್ ಲೆಕ್ಕಕ್ಕೆ
His
ತಗೋತೀರಾ?
father has to be taken into account. If father's property has to be claimed by the children. If children have claimed themselves to be the Christians, then succession is closed under section 26. This is a debatable point, assuming that there is a relationship.
ಈಗ ಏನ್ ಬೇಗ ಹೇಳಿ, ಸೆಟ್ಲ್ ಆಗಾದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಅದರ್ಸ್ ಆರ್ ವೇಟಿಂಗ್. ಏನ್ರಿ, ಯು ಬೋತ್ ಸಿಟ್ ಟುಗೆದರ್ ಅಂಡ್ ಟೇಕ್ ಎ ಡಿಸಿಷನ್.
ನಾನು when I have done this, I have done to the best of my abilities in bringing about equity. One principle with which I know is, if equity is not worked out, there is a disgruntled fellow who will always initiate proceedings against you. We have carried out the division in a manner that there is no grievance. That's the reason why I said, if he has got any details about the sharing agreement, the manner in which we have done, let him come, I am open for discussion.
Now you both sit together and heard in part. Both the council submits that there is an element of settlement. Element of settlement ಅಂತ ಬರ್ದಿರ್ತೀನಿ ಆಗ್ಬೋದಾ ಅಂಡ್ ಲಿಸ್ಟ್ ಮಾಡ್ರಿ ಎಷ್ಟು ದಿವಸ ಬೇಕು ನೀವು ಎಲ್ಲರೂ ಕೂತ್ಕೊಂಡು ಒಂದು ಡಿಸೈಡ್ ಮಾಡಿ.
ನಮಗೆ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಇವರು ಈಗ ನಮಗೆ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಅವ್ರಿಗೆ ಏನು ಅಂತಂದ್ರೆ ಮೂರು ಹಿಡಿದು ವ್ಯವಹಾರ ಮಾಡ್ತೀನಿ ಹಾಕೋದಿಲ್ಲ. ನನಗೆ ದುಡ್ಡು ಬಂದ್ರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ, ಅವ್ರದ್ದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಂಪ್ಲೀಟೆಡ್ ಸಿಗುತ್ತೆ, ನಮಗೂ ಸಿಗುತ್ತೆ. ಇದರಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಸೆಟ್ ಪೈಪ್ಲೈನ್.
ಈಗ ನೋಡ್ರಿ ನಾವು ಇಟ್ ಈಸ್ ವೈಟ್ ಅಂಡ್ ಬ್ಲಾಕ್. ಯಾಕೆಂದ್ರೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಎಷ್ಟು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗುತ್ತೆ, ಎಷ್ಟು ಫ್ಲಾಟ್ಸ್ ಬರುತ್ತೆ, ಯು ಆರ್ ಹ್ಯಾವಿಂಗ್ ಎ ಪಿಕ್ಚರ್. ಆಯ್ತಾ? ಈಗ ನೀವು ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. You go ahead with the construction and complete the construction and sell it and give them ಅಷ್ಟೇ. ಹೌದು.
ಬೇರೆ ಕಡೆ ದುಡ್ಡು ಹಾಕಿ ಮಾಡಂಗಿಲ್ಲ. ಇದ್ರಲ್ಲಿ ಬಂದಿದ್ದ ದುಡ್ಡು ನಾನು ಒಂದು ಎಕ್ಸ್ಟ್ರಾ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಇಟ್ಟು ಅದರಿಂದ ಖರ್ಚು ಮಾಡ್ಬೇಕು. ಇದ್ರಲ್ಲಿ ನಾನು ದುಡ್ಡೇ ಬರಂಗಿಲ್ಲ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. ಅದಕ್ಕೆ ಹೇಳ್ತಾ
ಇರೋದು ಈಗ ಆರ್ಡರ್ ಇರೋದ್ರಿಂದ ಯೂಸ್.
ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ನಾವು ನನಗೆ ಎಕ್ಸಲ್ಷನ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ರೀಸನ್ ವೈ ಐ ಫೈಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಸಿಟಿಂಗ್ ನೆಗೆಟಿವ್ ಇಸ್ if the court doesn't exempt me from mission,
I will submit before. 50% we let them share.
50% ಹೆಂಗ್ರೆ ಆಗ್ತದೆ?
Construction market ಇಲ್ಲ ಬಾಸ್ ಆಫ್ ಏನಾದ್ರು ಬರಂಗಿದ್ರೆ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ 50% to let them
ಏನ್ 50%?
94
ಅಲ್ಲ ಅದ ಹೆಂಗ ಅವ್ರ ಸ್ಟೇಜ್ ಬೈ ಸ್ಟೇಜ್ ನಿಲ್ಸಕ್ ಆಗುತ್ತಾ?
ಮಾರ್ಚ್ 15 ಅಡ್ವಾನ್ಸ್ ಕೊಡ್ತೀವಿ 50% let them.
45 ಫ್ಲಾಟ್ ನಮಗೆ ಸೇಲ್ ಮಾಡೋದಕ್ಕೆ ಪರ್ಮಿಷನ್
45
that is 50% off. That will be 50% off. 45 ಅಷ್ಟು ಮಾಡ್ತೀನಿ, ಇನ್ನೂ ಮಿಕ್ಕಿದಿರುತ್ತೆ. ಅದನ್ನೇ ಅವ್ರು ಹೇಳ್ತಿದ್ದೀರಿ. Let them be restricted. I have gone through the joint development agreement and the sharing agreement.
ಹೇಳಿ.
ಇವಾಗ 65-35 sharing ಇದೆ. That's bonus sharing. ನಾವು dispute ಮಾಡ್ತಾ ಇದ್ದೀವಿ relation, that is another matter. Dispute ಇಲ್ಲ ಅಂತಂದ್ರೆ late is 194, first defendant will be the owners. Together they are entitled to about 23 apartments.
ಹೌದು.
ಈ ಶೇರ್ ಇದೆ. ಅದರಲ್ಲಿ 230 ಗೆ ಅವರು ಲಾಭ ಹಾಕಿದ್ದಾರೆ. 230 ಡಿಗ್ರಿ ಆಗುತ್ತೆ, they will be getting 22 flats. ಅಪ್ಪ 11 ಫ್ಲಾಟ್ ಗೆ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಇರಬಾರದು.
ಗೊತ್ತಾಯ್ತು.
ಅದಕ್ಕೆ ಸಾಲ ಇದೆ. ಕೇಸ್ ಲೆಕ್ಕ ಹಾಕ್ತಾರೆ.
ಅವ್ರಿಬ್ರಿಗೂ ಅನುಕೂಲ ಆಗಕ್ಕೆ ನಾನು ಮಾರಾಟ ಮಾಡಕ್ ಬಿಟ್ರೆ ನಾನು ಪ್ರಾಜೆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಆಮೇಲೆ ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಇರುತ್ತೆ, ಅವ್ರು ಏನು ಕಿತ್ತಾಡ್ಕೊಳಕ್ಕಾದ್ರೆ ಏನೋ ಉಳ್ಕೊಳಕ್ಕೆ ಇವತ್ತು ಅದು ಕಿತ್ತಾಡಕ್ಕೂ ಏನಿಲ್ಲ.
ಅಲ್ಲಿಗೆ ನಿಲ್ಸ್ಬಿಟ್ರೆ ಯಾರಿಗೂ ಇಲ್ಲ ಅಂತ. ಅಲ್ಲಿಗೆ ನಿಲ್ಸ್ಬಿಟ್ರೆ ಯಾರಿಗೂ ಇಲ್ಲ, ಅವ್ರಿಗೂ ಇಲ್ಲ, ಇವ್ರಿಗೂ ಇಲ್ಲ, ನಿಮ್ಗೂ ಇಲ್ಲ.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಬೈ ದ ಎಂಡ್ ಆಫ್ ಜುಲೈ ಒಳಗೆ ನಾನು ಕಂಪ್ಲೀಷನ್ ಮಾಡಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಹೋಗ್ಬೇಕು ಯಾರಾಗುತ್ತೆ. if I complete the project within the time frame, I will just indicate what is my problem. ನಾನು ಪ್ರಾಜೆಕ್ಟ್ ನ ಟೈಮ್ ಅನ್ನು ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ರೆ ನನಗೊಂದು ರೆಪ್ಯುಟೇಷನ್, ನನ್ನ ಟೈಮ್ ಅನ್ನು ಕಂಪ್ಲೀಟ್ ಮಾಡಿಲ್ಲ ಅದೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಪ್ರಾಜೆಕ್ಟ್ ನಾನು ಡಿಲೇ ಮಾಡ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ ಪ್ರಾಜೆಕ್ಟ್ ನಾನು ವೇದಾಸ್ ಶುರು ಮಾಡಕ್ಕೆ ಹೋದಾಗ ಯಾರು ಬರೋದೇ ಇಲ್ಲ. ಕ್ಯಾಸ್ಕೇಡಿಂಗ್ ಎಫೆಕ್ಟ್ಸ್ ಇದೆ. But I have some problem because in the business
ಈ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನಿಂತ ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತು? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಯಾವಾಗ ಆಗಿದ್ದು? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಗಿದ್ದು ಯಾವಾಗ? 8-2 ನಾವೇ ಕೊಟ್ರದ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ 8-2 8-2 not to create any third party interest. ಹಿಂದೆನೆ ಕೊಟ್ಟಿರ್ಬೇಕು. 12-12-23 directed not to create any third party interest in respect of the social property till the next date of hearing ಅಂತ ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. That has been extended periodically.
45 apartments that is 45 apartments specify ಮಾಡ್ಬಿಟ್ರೆ I will complete the project. ಆಮೇಲೆ at least there is something for them to make. ನಾನು ಹೇಳಿರೋದಿಲ್ಲ ವೇಟ್ ಮಾಡಿ. ಈಗ ನಾನು 3 ಫ್ಲೋರ್ ಬೇಸಿನ್ ರಿವರ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ 2 ಫ್ಲೋರ್ ಬೇಸಿನ್ ರಿವರ್ ಸ್ಟಾರ್ಟ್ ಮಾಡೋದು.
Let him carry on the work. Carry out the work. They can take the advance also. Not in respect of remaining.
Remaining better. It's recommending.
Heard-
Everything in the.
Heard the appellant counsel and also the counsel for the respondents. This court, with order dated 12/12/23, passed an order that parties are directed not to create any third party interest in respect of the suits and property till the next date of hearing. The said the interim order has been extended periodically. Having heard the appellant counsel and also the counsel appearing for the respondent, the dispute is with regard to the joint development work taken by the respondents. And the appellants are also claiming the relief of partition. And trial court also granted the interim relief partly. And against that order, the present interim order has been passed by this court. Having heard the respective counsel when the construction is going on, it is appropriate to modify the earlier order, permitting the respond number ARR new 2 and 3 to go ahead with the construction work, and also given permission to take the advances. Take the advances. Permitted to sell the total 45 flats. 45 flats, and remaining flats is concerned, there should be an interim order not to alienate the same, and next date of hearing consider ಮಾಡ್ತೀನಿ ಅದನ್ನ ಪೂರ್ತಿ ನಿಮ್ದೇ ನೀವೇನು ಈಗ ನೀವೇನು 15 ದಿವಸದಲ್ಲಿ ಮಾಡ್ತೀರಾ ಇಲ್ಲಲ್ಲ ಮತ್ತೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಆಯ್ತು ಏನಾಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಾದ್ರು ಫೋರ್ತ್ ಫಿಫ್ತ್ ಯಾವ ತರ ಕೊಡ್ರಿ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಸ್ ಕಂಟಿನ್ಯೂಡ್ ಅಂತ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್ ರಿಮೈನಿಂಗ್ ಫ್ಲಾಟ್ಸ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಸ್ ಕಂಟಿನ್ಯೂಡ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 5/3/2024 ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡಿದಿರಲ್ಲ ನೋಟ್ಸ್ ಇಟ್ಬಿಡಿ ಅಲ್ಲೇ ತಗೊಳ್ಳಿ ಅವರ್ ನೆಕ್ಸ್ಟ್ 31. Alienating status to verify. ಏನಾಗಿದೆ ಸ್ಟೇಟಸ್ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಅಥವಾ ಏನಾಗಿದೆ? Opt for termination and substitution of the arbitrators. In that view of the matter, the point number 2 is answered in the affirmative.
This order from the arbitrators are abandoned arbitration. They are already parties. They are already parties in this petition also. Can we see?
ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ 2016 ಇಂದ ಏಕೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕಲ್ರಿ ಮತ್ತೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾಕೆ ಮೊದಲೇ ಮ್ಯಾಟರ್ ಇಷ್ಟ ಆಗಿಲ್ವಾ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 2016 4+4 ವಿತೌಟ್ ನೋಟಿಸ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ವಿಧಾನ ಬರೋದೇ ಇಲ್ಲ ಮತ್ತೆ ಇನ್ನೊಂದು 4 ವರ್ಷ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಅಂತ ಹಾಕಿ PF ಕೊಟ್ಬಿಡಿ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಟ್ಸ್ ಇದೆಯಾ ನೋಡು ಕೌನ್ಸಿಲ್ ನೋಡಿ ನಿಮ್ಗೆ ಬೆಳಗಿನ ಟೈಮ್ ಆದ್ರೆ ಪಾಸ್ ಓವರ್ ರಿಕ್ವೆಸ್ಟ್ ದೇರ್ ಇಸ್ ಎ ಮೀನಿಂಗ್ ಇನ್ ಸೀಕಿಂಗ್ ಫಾರ್ ಪಾಸ್ ಓವರ್ ನೌ ಟೈಮ್ ಇಸ್ 3:40 ಲೆಟ್ ಇನ್ ಕಮ್ ಅಷ್ಟೇನೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಟೈಮ್ ಇಲ್ಲ ಅಂದ್ರೆ ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ ನಮ್ ಕೋರ್ಟಲ್ಲಿ ಏನ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಏನಿಲ್ಲ ಆಯ್ತಾ? ಓನ್ಲಿ ಹ್ಯಾವ್ ಟು ಪ್ರೆಸೆಂಟ್ ದಿ ಕೇಸ್. ನಿಮ್ ಕೇಸ್ ನಿಲ್ಲಿಸ್ಬೇಕಷ್ಟೇ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನಿಲ್ಸಿರು ಒಂದೇ, ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ ನಿಲ್ಸಿರು ಒಂದೇ. ಹಾ, ಹೇಳಿ. ನೋಟ್ಸ್ ಇದೆ ಮೇಡಮ್, ಆಲ್ರೆಡಿ ಏನು ಬಹಳಷ್ಟು ಕೇಳಿದೀವಲ್ಲ ಇದರಲ್ಲಿ. ಏನಾಗಿದೆ ನೋಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ ನೋಡೋಣ. ಸೂಟ್ ಫಾರ್ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್
This matter.
ಹರ್ಡ್ ಅಂತ ಆಗಿದೆ ಅಲ್ಲ, ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಆಗಿದೆ.
First part.
ಹಿಂದಿನ ಸರಿ ನೋಡ್ರಿ,
ಹೌದು ಸರ್, ಪಾರ್ಟ್ ಹರ್ಡ್ ಇದೆ.
ಪಾರ್ಟ್ ಹರ್ಡ್ ಅಲ್ಲಿ ಏನಂತ ಮಾಡಿದ್ವಿ? ಇವ್ರ ಸೈಡ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ ಅಥವಾ ಬಾಡಿ ಪಾರ್ಟ್ ಮಾಡಿದ್ಯಾ ಯಾವತ್ತು?
Heard both 31 ಗೆ heard both the learned concept of the appellant as well as the respondent in part. ಇಬ್ಬರಿಗೂ in part ಅಂತ ಮಾಡಿ.
ಇಷ್ಟು ನೋಡ್ಸಿದೀರಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಹೇಳಿ ಬರ್ದಾಗಿಲ್ಲ. Earlier you have completed your argument? Oh, there are one matter ನಲ್ಲಿ. ಈಗ now you are arguing in second matter? Both?
Now, this is the first suit is OS number 25,561/2023.
There are two suits. OS number?
25,567 of 2023.
25,567 of 23.
Filed by the present
Appellant.
Yes. Is a plaintiff suit. For injunction, restraining the defendant from interfering with the social property.
That is MFA number 6684?
Some cases.
67?
36.
Or 6736?
Yes. That's why I'm going to synopsis makes it. I have connected both. For MFA is 6738 2023. It's a suit filed by the defendant against me, and wherein I am restrained to alienate the property. Now, what the plaintiff and the defendant can 1611, the facts of the case, admitted facts of the case proceeding. 1611/2023. Both the plaintiff, I have termed it as BKC, the plaintiff, and
NSP. What is that NSP in the defendant? What is that VKC in the plaintiff? NSP? Defendant. Jointly purchased, both of them.
And in that part, there was a power of attorney came to exhibited by the plaintiff, BKC in favor of the defendant. Wherein in
He had received an amount of rupees 2 crores.
that I found, right? Then on 21/4/2014, the next event, even though I was about, before I cancelled the GPA, which was executed on the same day, 16/11/2013. That came to be cancelled by me on 13/5/2014. 5/2014.
13 cancelled.
Yes. Before that, he created an unregistered agreement of sale and investment of the same property. That is on 21/4/2014. In this, my lord, I request your lordship turn to the statement of objection. People are very interesting. This thing they have made. The schedule of the property in the statement of objection filed in MFA 6736 of 2023 filed by them. That is document number R9.
MFA?
MFA number statement of objection filed by them.
ಅದು ಯಾವ್ದ್ರ
6736 of 2023.
6736.
Yes. The statement of objection. I need turn to MFA.
ಮೇಡಮ್ ಇನ್ನೊಂದು ರೆಕಾರ್ಡ್ ಕೊಡ್ರಿ. ಇದಾ
Statement of objection filed by them.
6736.
Yes.
Hmm.
In that, kindly turn to
Page number in
page number 43. Annexure R9.
Statement of objections R9. Hmm. Hmm.
Now this is agreement before a cancellation of that power of attorney.
Hmm.
He creates a document wherein I have not signed, but he shows my name.
Hmm.
And in that, interestingly, my lord, if your lordship sees the schedule of that document,
Hmm.
which is at page 52,
Hmm.
it makes 16/11 they jointly purchased.
Hmm.
Within a span of a couple of months or 21/4/2014,
Hmm.
he makes it an enter into an agreement with a third party that case as if there is a entire apartment consisting of 29 lakh flats and 2 penthouses.
Hmm.
That is as per 21/4/2014 itself.
Hmm.
Before I cancelled, kindly see now the third document, that is GPA deed. I cancelled the GPA deed subsequently.
Hmm.
Now this is a wherein the schedule of that document, kindly see the cancellation of the document at page document number 3 in this present MFA 86 to 90. It's a registered document, mine is 86. General corporate. Document number 3.
Cancellation of general power of attorney.
General corporate attorney on 13/5/2014. That is after this.
Hmm.
This is a registered document.
Hmm.
Wherein kindly see the schedule, you know, page 92.
Hmm.
It's a registered document. 90,800 square feet. No apartment, no penthouses.
Hmm. Hmm.
So then, Lord, after the cancellation, this is a created agreement, which wherein it is the present status, 29 flats and penthouses, everything.
Hmm.
Now, on 19/6/2015, Lord, there I have cancelled the agreement. And I'm sorry, on 13/2/2015, he released half share. We jointly purchased on 16/11/23, 2013. Half share of it gave to me relinquished in my favor by means of a registered release deed that is on 13/2/2015.
Hmm. Hmm.
That time also, if your lordship sees that release deed also, the
Same boundary,
also
Hmm.
vacant.
same schedule.
Yes,
Hmm.
same schedule.
Hmm.
Same schedule as the GP.
Hmm.
So that is document number 7. Your lordship at this juncture, 13/2/2000, he received 2 crores. Your lordship was pleased to know, and he relinquishes, which is available at page 160 of the main papers.
116.
Yes, document number 5.
Hmm. Hmm.
Shiva Prasad, the defendant releases in my favor, and he the 2 crores what he has taken,
Hmm.
which is at page 120.
Hmm.
Full consideration of the excess,
Hmm.
and he relinquishes.
Hmm.
So he is out of possession as on 13/2/2015 itself.
Hmm.
The entire client share property is in my possession.
Hmm.
Then, coupled with this, on 19/6/2015, this is very important.
19.
On 19 after that, 19/6/2015, he entered into an agreement of sale in respect of 1 flat. He is out of possession, and he enters into now that is at page document number 7, pages 140 to 153.
One?
140.
40.
Yes.
That,
Document number 7. Title copy also if you not I can show. But this is a document agreement of sale in respect of after he became he gone out of possession. He enters into the agreement of sale on 19/6/2015. I give a lordship
19/6.
2015.
15.
After
Ah.
cancellation, after release date also.
Hmm. Hmm.
It is found your lordship you can see. The title copy I have there. 154 page.
Hmm.
So as of 19/6/2015, the very first recital witnesses as follows. Whereas the vendor is the absolute owner of all the piece and parts of indoor property wherein present
Principal BB
means for farming so and so. Now, your lordship can see what he proposed to purchase, which is that schedule, which your lordship can turn to the apartment to be built. That is at the schedule. IDP page 172. He has agreed to purchase. Page 172, CH-11. A 3-bedroom apartment bearing number 29 on the description of the apartment to be constructed. And you see, up to 1962, nothing is constructed. So he agreed to purchase one bed. So from this recital at page 154, I have shown, he admits the fact that I am the observer. He has already, he is out of possession. He wants to purchase a to be constructed flat in the center. So this is the position up to 2015. That of course not. There is two other incidents. He tries to 11. I will come to that little later. The sequence of events on 6/4/2023, I filed a suit for injunction on the ground that even though he has relinquished his share by taking 2 crores, even though he has entered into an agreement with the department to be constructed, he started interfering with my peaceful possession in the entire 19,800 square. That is my case. On 6/4/2005, at page 5 of my synopsis, I filed a suit OS number 25/5/2023. Now, on 10/4/2023, I can find out from pages 199, the temporary injunction came to be
Granted.
in my favor. On 19/4/2023, now he seeks, he files a first complaint on in PCR number on the last occasion I passed on, otherwise it is complaint. PCR 554/151 of 2023, where he states he is a neighbor, he is beyond this compound, he stays there, and his address also in the complaint is given as that, and there is nothing to do with any code from the social property, much less in flat number, so-called flat number 29. So he files a complaint on 19/4/2023. So from that it is clear that as of 19/4/2023, that is after the injunction came to granted, he was not in possession of any property. So on the same day, on 19/4/2023, he files an application in my court where an injunction came to granted on 10/4/2003. After lodging a complaint before the learned magistrate, he comes before the civil court and files a modification, files an advancement application, and files an application seeking modification of the injunction order. The trial court, now I will take the trial court's order on that. We kindly turn to this paper 2, page 2 not. I will show the how I got the order.
201 na?
Page 197, it is the 25/5/67, amendment number 10, 197. So 198, the ad interim order is very clear at page 198. Order portion I will read. An ad interim injunction granted restrain the defendant from interfering with plaintiff's possession of social property in next period. Now this incident of 19/4. I got an order of injunction ad interim. On 19/4/2023, he files a complaint from 19/6/2015 for 8 long years. He was admittedly out of possession, which is very clear from his own documents. Admitted out. So on 19/4/2023, after I obtained an injunction order, he seeks for modification of the interim order on the ground that he is in one of the apartments in the property. And you see, he has entered into an agreement of sale on 19/6/2015, wherein in terms of the agreement, he had agreed to purchase the said property for a consideration of 50 lakhs, not even 1 rupee paid. In spite of that, by virtue of this method, he comes to the court, files a complaint, wherein it has nothing to do with that he was in possession of any flat in that, and admittedly he was out of possession. Now, can you see page 201? This is very relevant. At this stage, you also got it 201. The injunction ಕೊಟ್ಟ ಮೇಲೆ 19/4/2023.
ಅದೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ಅಂತ ಏನೋ ಮಾಡಿಫೈ ಮಾಡಿ ಏನೋ ಮಾಡಿದ್ರು ಆರ್ಡರ್.
ಹೌದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಯು ರೆಡ್ ದಟ್ ಆರ್ಡರ್. ಹಾ.
What? 19/4/199 is okay. Or short. The case is advance of the application filed by the council dependent taken board. Since the advance copy of the application served on the plaintiff, council is the council for defendant has filed written statement includes this along with adopting the written statement as objection to IA number 1. He has also filed list of documents produced 9 of. Council for the plaintiff has filed IA accordingly interim notice extended till next day. Third, council for the defendant on the prayer to modify the interim order to recognize your lordship is very important. From 8 long years, he was not in possession. Even on 19/4/2003, he was not in possession. Even the agreement of sale in the plan, kindly see, council on prayer to modify the interim order to recognize the possession of the defendant over the terrace area of social property. He is not, he is totally out of possession. Then for further hearing, so it's next on 20/4/2003, council for the defendant has filed additional copy of the document and also memo enclosing two affidavits on the person said to be neighbor and another social court. At this stage, it is brought to my notice that so and so satisfied for defendant number 1 along with the advancement agreement in the order sheet 19/4 by interpreters, the Vakala also is not so. Counsel for the plaintiff has filed affidavit of plaintiff and list of documents with deed on. Third, both the sides further on item number 1 and request to defendant 1 to modify the interim order granted earlier to protect the possession. Again, your protect the possession of the defendant in respect of flat in the 6th floor of the social property. And you see, he is not on the ground possession, he seeks protection. That is why on the first occasion, I had submitted before this court. Here is a case, as of the date of suit, he was out of possession, under the garb of interim modification. He enters upon the property. And you see, now we everything in. At this stage, do not, from the documents produced today, mainly the gas bill he produces apart from the complaint, gas bill dated 24/2023, which shows that the defendant is in possession of 29 SRT square 6th floor and also from Westcom document which confirm the possession of defendant in the flat in the top floor of the Tucson property and from the content taken by the beginning. But legal notice. It produced as document number 3. It is prima facie appears that the defendant is presently in possession of flat bearing 29 in the 6th floor apartment complex on the Tucson property. Only IA granted earlier modified holding that the plaintiff shall not interfere with the defendant access. Can you see? There also there is no recognition of this so-called lawful possession. Access and possession in the 6th floor Zoom property and car parking area in the basement and also basic amenities to the site plan, including water and electricity, possession and enjoyment of the remaining. Since the hearing was better than this. At this juncture, I would like to point out certain questions. Now here is a case, he was out of possession admittedly. Now under the garb of this he tries, he enters upon the property. My difficulty is he has entered upon the property and he has ready with that construction. He has started parking space he wanted. All those things now he recognized. Now let us see on the last occasion I have your worship I have drawn your attention to the so-called gas bill. It doesn't say anything. Statement of objection at page 76. Two documents. Over document. 15 and 15. Page 76.
HP gas consumer details.
Is there? That doesn't kindly see first document 76. So document R14 here only 14.2 kg cylinder. E flat here address nothing is there. And next that is illegal work of the conveniently consumer name item. Interestingly 13/3/2007 document. Kindly see. Over the document I am not showing the annexure R which is relied upon by the client. 13/3/2007. It is much prior to both of us acquired this property. That is the next R6.
ಎಲ್ಲಿದೆ ಡೇಟ್ 2007 ಅಂತ
R14 ನಲ್ಲಿ 605788 ಅಂತ ಇದೆ 9
ಹೌದು R14 ಅಲ್ಲಿ ಇದೆ.
R14 ನಲ್ಲಿ page 76
76 ಆಯ್ತು.
ಅದರಲ್ಲಿ
ಅದು 13/3/2007 ಅಂತ ಇದೆ.
ಅಲ್ಲೇ
ಹಾ
right 13/3/2007.
This
is have to 16 land to the both of us acquired. And this here he conveniently writes on the date of complaint of 19/4/2003 his address is outside this department. Admitted. Now in this, he includes Shiv Prasad, who is the head, established bank.
Next.
Next document, and is in on the gas. It has nothing to do except mentioning the address at page 77. It can be construed as when he himself shows that he was out of prison for 8 years. After I obtained an injunction, prima facie court comes to the conclusion I am in lawful position. Can these documents show that he has entered upon a particular flat, admittedly when the flat is in particular, he is about to be to constructed flat, and he had to buy it only after paying 50 lakhs. Nothing is paid. The next document, 17. These are all now your lordship can see further documents of that R16 page 70 18 ಇದನ್ನೆಲ್ಲ under the garb of that he filed first an injunction under order 39 that I have violated. He comes into possession under the garb of the court order. He develops his property. He meddles with my car parking. Everything my lord he does that. And then after that my lord, and you see I obtained on 19th. In May 2023 he files a suit on the grounds here there is no counterclaim as far as his the relinquishment of SAP, that is 13 to 2015. No say in the entire except the court helps him to modify, makes him enter, and one more document is one registered notice exchange between the parties. That cannot be, no doubt I have said, your lordship is well aware, even for an admission, he only created a document in favor of some third party and got a registered notice to both of us, wherein we were the parties, and then he was now in the second suit after this. On 23/5/2023, that is after this modification of that, he becomes wiser. And now, in this written statement, what he says is that 32/2005 release is the nominal one. And on 23/5/2015, he seeks a relief in the nature of declaration that the release dated 32/2015 is a nominal one. It is liable to be declared null and void. And in that order, the trial court in that suit passes an order of permanent injunction restraining me from alienating any other flats. Whatever flats he entered upon some property, whatever convenient to him, he virtually barged into that. My definite story on 6/4/2023, he was trying to barge into the property by driving over my worker. Now, under the garb of the interim order, he comes into the property, he meddles with that, he because I am away in Tamil Nadu. He does. Now, in the second suit, your lordship, I see, in MFA 6738 of 2023, it's a suit filed by him, page 34, if you know.
Voice number?
Voice number 25762 of 2020, filed by him. ಅದು before your lordship. In that 7th June 2023, 23rd ಗೆ ಹಾಕ್ತಾರೆ, 23rd May, after all his modification, he becomes wiser and he tries to. Now in this document, you see, I only first take your lordship to page 52. Document question. Higher number order, under order 39/2 of the CPC finds the basic law and temporary institution is granted, restraining the defendant from alienating or creating any third party interest over the suit property till the disposal of the suit. Now, this is notwithstanding the 32/2015. This relief, I will take your lordship to the plain in that 25. Kindly see the plain. Page 62 in that same copy. His prayer is
Where?
to adjudge the release dated 32/2015 executed by the plaintiff in the defendant in respect of the property and registered as document number so and so in the office of the student as void and order to be delivered by the defendant and cancelled subsequently and send a copy of the decree to the student. This is a registered instrument. When I filed a suit, he did not have any except saying it's a nominal. Now then, that the second prayer is partition of hardship. So who has taken 2 crores, who has not even paid 50 lakhs interest to the property apartment, he seeks this relief. And third is permanent injunction, restrain their servants and legal representative, anyone claiming to or another from preventing the plaintiff from enjoying the social property. Now, in this plot, at this juncture, I request now to come back to how in the second suit, how the court was carried away by the version of the defendant is very clear from there. Page 6 yours.
You are referring improved order?
Improved order, yes, I will. You may say 6736, I will come. In the input, that is, I am restrained from. No, this is also.
6736.
6736. Improved order, which is starts from page 37.
Hmm.
The very page 61 itself makes the position very clear. Okay, question. There I am restrained from eliminating. Yeah. How did his possession of vehicle? I remember 580. Not about it.
Page,
Page 61.
61.
6736.
61.
I have 580 for not the claim limit. And I have 75 by the defendant section 1. By protecting the position of both the plaintiff and the defendant over those portions of the suit that can be immediate, they were in possession as of the date of suit. This is an assumption. He is not in possession. Next, in other words, kindly see the possession of the defendant for flat number 29 penthouse in the 6th floor of the suit property, along with various amenities, therefore, in the form of electricity and water connection and access thereto, including access maybe of lift, along with one carpet slot in the basement is protected. This was a present suit and the plaintiff is restrained from interfering with the defendant's possession of the said flat 29 penthouse 6th floor property together with the aforesaid amenities and access to the same otherwise than in accordance with what is the However, it is very clear that this order shall not come in the way of the plaintiff seeking kindly see ejectment, eviction, or recovery of possession of the said portion from the defendant through the process of the court by filing a property. Now, I am a lawful person. My lawful person is
Whether all these prayers are made by the defendant?
no, it is only defendant.
Hmm.
Now, that's what first it recognizes possession.
Hmm.
It allows it to get into the property.
Hmm.
He manages the property. Kindly see, here is a case where one other aspect I request you not to know. Here is an apartment. We have got permanent electricity connection. And now the by virtue of this court order, which I will read, it permits him to occupy, and I am directed to provide him
Provide
electricity.
electricity also.
It's only temporary connection. 60 in further. It is further made clear that interest of the basic amenity, such as electricity, this is a order. Electricity,
Or water bill or other documents.
now there is nobody.
Hmm.
Now there is a facility note, it is under the fantasy. Including the electricity, this is before including electricity for the light, lift, all expenses. Lift also I cannot operate.
Hmm.
I have not even got occupancy certificate. I sought for permanent connection. For that, temporary connection has to be disconnected.
Hmm.
This person entered into the property, meddled with the property. He wants the court protection. All expenses that shall be borne by the defendant, making it clear that the defendant cannot claim any equity or benefit on the ground of electricity bill or water bill or other documents reflecting the name of the defendant pursuant to this order. Conversely, the defendant is hereby restrained from interfering with the plaintiff possession. I am not in my declared 29 nobody is occupying. 29 apartments are there. And that is why kindly see, it's there the remaining portion. IR number 6, 5 was the plaintiff. Now then what happened to her? Since the court has said that I should evict him from flat number 29, he himself is not clear. Now he was by virtue of the agreement dated 19/6/2015. How he will come into possession? Can a gas bill or can an exchange of notice contain that he is in a particular portion? Now it is his duty to show when exactly he occupied after a span of 8 years.
Hmm.
Where exactly he is occupied. Now plaintiff carrying on. Now then I have filed in the suit an amendment application because to declare that I have got the amended rate, to declare that wherever he is in physical possession. In fact, I have filed an application before the court instead of filing one more suit to evict in a non-existent property. Then he himself is not sure. I find that he is in possession under the garb of the court. Please, in the report of the court, please declare his possession in so-called flat number 22 is illegal. Our declaration amendment again. That amendment application is allowed. Now I can find out for the temporary connection of.
Make it short. Last time also you argued elaborately.
Yes.
Yeah.
That's what, but now,
Hmm.
according to me, the trial court has committed a gross error in permitting him occupy a particular apartment, and he has effected improvement. He filed a criminal case, and apart from that, in the synopsis I made, several suits have been filed. In Gondiala to harass me. Order 39 rule to it. That suit missed also. I have given the notes. At page 9, various suits. One is OS number. This was citizen only Mevalani.
30, 43, 30, 54.
He is further injunction from committing slander of title. That is. This is 2020. Next, OS number 22. TV Lokesh Goda. That without schedule I have already pointed out. Ask for the special performance ಆಗಿದ್ದಾರೆ. Property illegal. ಎಲ್ಲ ಫ್ಲಾಟ್ ಅನ್ನು ನಾನು ಮತ್ತೆ ನನ್ನ ಪಾರ್ಟ್ನರ್ we have agreed to sell ಅಂತ ಮಾಡಿ. Then voice number 3050 seeking damages. ಈಗ ಅಲ್ಲಿ ಹೋಗುವಾಗ he himself created a total mess. He has completely, because he took weakness of my property. He virtually meddled in the property. ಎಲ್ಲ ಇವನು demolition ಮಾಡಿ ಅವನಿಗೆ ಬೇಕಾದಂಗೆ spread down ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. That is why I sought for injunction here. Apart from this, in this case, I sought for legally mandated injunction, and office has raised an objection to the effect. You legally mandated ಎಲ್ಲಿಂದ ಅವರು ಹೊರಗಾಗಬೇಕು ಅಂತ ಕೇಳ್ತೀರಿ ಅಂತ ಹೇಳುವಾಗ, and the plaintiff, I mean the defendant himself, is not sure where exactly, except stating that 29, and nothing is aside. The imaginary portion is there. So, last aspect of matter, they also rely upon one compromise petition, which was filed in 2015. Other than now, you party. In that, there is a recital in the compromise that you both are the owners. For that, they rely upon. In that, that compromise petition they have produced before this one court. I will show this suit schedule property is not only property. Kindly see, this is another fraud played by them. This is the page 192 of 6736 of 2023. In this, not page 192.
192.
Voice number 10490. So 2006. This is the earlier. In this, we both are parties. That is plaintiff and the defendant. Kindly see 5 and 6. 193. ಇಲ್ಲಿ, what they say is in this court, both of us have agreed that they are it is ordered and agreed that in the compromise petition. It also produced compromise petition article. Which is that page 181. What they say is, as per this court, they have agreed. Even though this aspect has been taken by the tribunal. And in page 182, 7, the first plaintiff hereby concedes. You are not sure what it is. Concedes efforts declared that the defendants are in lawful possession and enjoyment of the rights of property. However, as described now, let us see the schedule. This is nothing to do with that. Even they say that both of us admitted that this compromise happened on 10/10/2017. That is after that release period. According to them, by virtue of the recitals contained in the compromise, a suit for specific compromise is came to be dismissed. There is a recital in page 7 that we are in lawful possession. They joint owners of that. Not admit material 2017. So for that, if your lordship sees the schedule,
House list number 188.
Page 195. Schedule note. None of these yes, page 195. House list number 188, nothing to do with the racial property. Again 188, number 2 also nothing to do with that, and 3,188 also nothing to do with that, and 5 is BBMP 9. In the how that they misled the court by obtaining a modification of the order, stating that in the compromise petition, both of us agreed that after 2013, 2013 we are joined over. Either though they want to make mind. And this suit ultimately, a suit for specific purpose to settle, it was dismissed. How can that be binding? Because the legal notice also, I am not bound by the, your lordship is when our admission, it can be explained. Admission covered the first hearing and when I am the absolute owner, he cannot be permitted to enter. And kindly see the operator, take possession or recognize his possession. In this case, can the clerk expect me to file a suit against them and evict him? Where we should go?
Yes.
That's why you must take the signals and give the copy also. I think what the
Yes, counsel. No, counsel, no time.
Will require sufficient hearing, but I will address some of the points that have been raised.
Continue first. We have another 30 minutes.
The argument that if you give a and I learned my already given a very large, elaborate synopsis. I will just explain what is my case. Really, this property was purchased by both plaintiff and defendant back in the year 2002. Thereafter, in the year 2008, the appellant proposed order to the court is a ministerial appeal. By certain funds for the election. Therefore, he said, I require the property to be the loan. And I stood as guarantor to that loan, which will be produced. I stood as guarantor to that loan in order to make him raise funds. I have always been occupying this property. I have already saw certain photographs. My house is there. It's not this contention that he is taking today that I have, by virtue of the interim order of the trial court, 20th April, that I have suddenly gone and taken possession and shifted my entire house, constructed house, furnishing everything. That is definitely not something that is plausible. In any event, he has admitted in several instances. One is the legal notice which he did not read out even though he adverts to it. A legal notice issued by another party. He categorically states, I am in possession of the penthouse of his apartment. Can you take that notice which is produced along with my statement of objections? 736.
Page
18.
18. Legal notice.
Legal notice. The legal notice issued by him. My lord sees on page 17, our client TTS. Issued by him to Lokesh, TP Lokesh Gowda. My lord come to page 19. Para 7. Our client states that one of the penthouse is an occupation of the said N. Shiva Prasad, which is taken on leave. This is what it is. Now our client is not paying rent, not vacating the same. If you say my client that you can show to the vacate that penthouse, will want to take it. No notice will be issued to me. And his argument today is that this is not pleading and therefore cannot be admission. So stated 24/3/2023. My client the date of the suit. I have always been in occupation of this property.
What is the date of suit?
6/4/23. This contention is by virtue of the modified order on 24/23. I have then taken possession. In fact, this one was argued before the trial. The learned trial judge asked my learned friend to point out in pleadings several applications or objections to file. Point out in pleadings where he has taken this contention. My learned friend was unable to show where he has stated in his objection to any of the application that I have taken possession pursuant to the interim order. Apart from this, my lord, kindly see. Where is other document? There is a document by the best.
According to you, this is in respect of the penthouse. This admission.
In fact,
Admission. You are in possession only in one flat. One plant.
Only of the penthouse, which is why the honorable court, the trial court told my learned friend, you have not disclosed the full facts. I either reject your application or I allow it and I protect their possession in respect of this. That is what was the argument. Now, my lord, can you next document? Up to page 27. This is in respect of ESCOM deposits. I have paid this electricity bill. This is the date of the document 16. Malan Puji on page 29 also. 16/11/22. Months prior, I have been living there for almost 2.5 years now. I have put up this construction, in fact. This building, I have put up this construction. My one friend is a minister who lives in Tamil Nadu, has no experience in this field whatsoever. Can you see at page 31 is a document where he writes, in order to post me out, to say I am surrendering this temporary connection to trouble me. Thereafter, I write to them.
This is dated? No date.
There is no date.
Surrender of temporary connection.
Unless you see the next document, anyways. Yes. I write to the restaurant saying I am in possession on 19/4. And they do a spot inspection at R7, 20th April. And they confirm I am in possession of the land, like already admitted, I have put up my house here. My daughter-in-law, 7 months pregnant, and is hearing on this application as well. Now come to see document, the gas bill at 76. When reads the first document, that is my consumer detail of 13/3/2007. And I come to page 77. Gas bill again 24/2023.
24/2023.
Right.
Cash memo.
Cash 24/23.
Address in respect of which premises?
Left side, Shiva Prasad, 29 FRT Square, Talakere, Bangalore. Next document. Now we see the next document of pictures that I have shown of my house. I've been residing there for several months.
On what date you have occupied that house?
I have put up this construction myself. I've been residing there for at least 2 years.
2 years.
At least 2 years. So this document, the release deed was only a normal document. The law has already seen the agreement of sale. That document was executed in my favor in order to protect me in case the banks come after this property because he is taking loans. That is the reason why my learned friends executed that document. My lord will see, my lord has briefly seen that compromise which has been signed by him. But on the contention that is taking today, that schedule doesn't pertain to the, I'm hearing this for the first time, it's not taken before the lower court. It's not taken in his pleadings in the written statement to my suit as well.
But in that is premises number is 188. Compromise petition.
There is a new DBNT number here. The actual property we are dealing with is DBNT number 9. I have seen instructions on that one aspect. That is not an argument that will be taken by hearing for the first time. I am trying to ensure that taken written statement. I will concede. He has not taken his argument before. The strength of the order is that on 10/10/2017, 2 years after the alleged release deed, my lord friend's client confirmed that I am a joint owner along with him. My lord sees that document, compromise petition. It is produced along with the appeal. See again at page 177. Paragraph 6 and 178.
178.
First plaintiff further affirms. The TRS and concedes that the defendant 5 and 6 are the absolute exclusive beneficial owners of the claim settlement property. The right is unconditional, valid and substantive. 5 and 6 are the plaintiff and defendant. He signs this himself. This is 2 years after the release deed was executed. It is on this basis that argument is once to try that I have always been in possession, but always in the thoughts of the parties that both of us were joint owners of this property. The release deed was never meant to be acted upon. Also, the confirmation deed is also executed. In 125.
125.
Here confirmation again made by that party in favor of the respondent and the appellate. Can you see the schedule in this document? Take 131. Next schedule, BPMP number 9.
Hmm?
Delay issue.
You are not the signatory.
Can you come back? These are submissions below that have no basis. Can you come back to 177? This document is referred to in the document by learning credit science. This contention, each time a new contention is taken. Can you see 177? Paragraph 3.
177.
Which is the compromise petition. It refers to this confirmation deed. Paragraph 3, second plaintiff,
Confirmation deed.
dated 29/5/2015, exact same property.
Hmm.
Now, this party has approached the court without clean hands, suppressed material facts, and continues to mislead the honorable court. Which is on the strength of this, that the order in suit filed by my learned friend is passed because despite the interim order passed on 20th April, I have not placed that before the honorable court. That order was violated on several occasions. The lift connection was disconnected, electricity was disconnected, the generator room was taken out and thrown on the road. I produced those photographs in the trial court. Because of that, I was constrained to seek protection of even my access, and I am living on the 6th floor, moving the lift. Along with that pregnant daughter law, I am unable to access the property. So therefore, my lord, insofar as the first appeal is concerned, the order is passed on the strength of several documents that are shown in the honorable court. Recognizing my possession, electricity bill, gas bill, confirmation deed, compromise petition, and on the legal notice issued by him. When he all confirms that I am in possession of slab, along with the photographs that are shown in the court.
What do you say with regard to your notice, legal notice?
Legal notice is concerned.
Ah.
The entire improved order, except in the added time they referred. In this cannot so far as the admission, so-called admission is concerned. In the improved order page 37, it starts, there is not even consideration of the legal notice. Because I admitted in the legal notice, they are in possession. In the entire, if that legal notice has been considered and it has been construed as by an admission at some point of time, I can understand. That legal notice.
Do you admit this document of issuance of legal notice or not?
Yes, as regards my legal notice is concerned, it is a legal notice. It is not an exchange between the plaintiff and the defendant.
This is 24/3/2023.
Right. This is a legal.
This legal notice issued by your client only.
It was addressed to the defendant and the plaintiff. Kindly see, it is by.
Issued on behalf of your client CV Lokesh Code. Avner.
That schedule ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
Schedule nalindra?
On 21/4/2014, he created an agreement of sale agreement in his favor. As back on 2014.
Then while issuing notice, why you included him also?
Now in that legal notice, it is not a legal notice exchange between the plaintiff and the defendant. He has addressed the Lokesh Gowda, advocate had addressed to both of them. This person had created, he colluded with them, colluded with Lokesh Gowda. For that I have replied. So in that also, kindly see that
Whether you have issued this notice or not?
I hope but
And then you have recognized the possession of the defendant. Hmm.
This legal notice, if this trial court has considered that legal notice, the entire review order, definitely it is not on that basis.
Whatever it may be, counsel, regarding possession is concerned, your client only issued the legal notice on 24/3/2023.
Itself, this particular case. I have taken by surprise as far as this is concerned. The entire review order, it is not there. It is not because I admitted his possession. The legal notice.
Whether this document is produced before the trial court or not, this legal notice.
This legal notice, as per the accused order, no, my lord. But in
Whether this notice is
It
issued,
is produced.
produced before the trial
It
court.
is produced before the trial court.
But it has not been considered, no. That is not.
Whether it is considered is not relevant now. Whether you have issued this notice recognizing the possession of the respondent or not, that is the only question by this court. Ah.
This notice came to issued
Ah.
at the instance of one local order with whom he colluded. That specific performance suit is also fine. Multiple suits is one of the suit is that only.
Against whom?
Against suit against me only. And he himself as a party. which is
By this
against
civil location. First, you clarify with regard to whether you have issued this notice or not against the defendant. Ah.
As far as.
Once you admit that he is in possession prior to filing of the suit, how you can seek for the relief and argue that he under the garb of the interim order? Ah.
Here notice, admission can explain, it is not my admission in favor of the defendant. Now, your lordship is section 18 of the evidence act also. Admission is made in favor of that person to defend myself.
ಆಯ್ತ್ರಿ ಈ ನೋಟಿಸ್ ಯಾರಿಗೆ ಕೊಟ್ಟಿರೋದ್ರಿ?
The notice is admission addressed to both of us, I will clarify. It's not an admission in favor of.
All the governments made allegations made against our client in the notice are utterly false. Oh, this is reply notice.
Yes, sir. And this is the original notice here.
Where is the original notice?
And this is this notice dated 31/1/2023. Manjunath and
No, dated.
I defend myself. And this is the original notice for which I have replied. This notice, you want seize this notice, then.
Oh, that is in reply only they have stated that.
I some different note. It is
That's
not.
what I am asking you, whether this notice,
Notice.
this is your notice. Huh?
That one is I want it,
Ah.
but he polluted with them. Actually, I have stated something. No doubt. My advocate is, that's why it is not, and you see the addresses of this notice. Why is the
Oh.
later?
This is the notice issued by civil location.
Look at Goda, making the defendant of plaintiff as parties because he colluded with them. In that he is trying to take advantage. It is not a part of pleading. Kindly see, he doesn't seek possession. It's what the trial court has made out. He just produces. There is not even a pleading on the basis of this admission. Your lordship is well aware the admission can be explained. I am explaining this. The notice can be addressed to both of them. In that he did not reply, I replied. And in the confirmation deed also, he every time he takes my name and he gets executed and he gets filed the suit filed by them. So your lordship, this suit is in Mayon. 3 suits came to mind, including damages. He himself meddled with the property. He harasses me. Order 39(2)(a). Now, if your lordship see this order.
But in your reply notice only, you have admitted that he is in possession.
The admission is between. He can use against the person who.
Whatever it may be, when the admission is there that once Shiva Prasad is in occupation of the premises from, you read paragraph number 7. Yeah. That our client states that one of the penthouse is in occupation of the said N. Shiva Prasad, which he has taken on lease from our client, is not paying rents, nor is vacating the same. When this admission is given on 34 to 24/3/23,
The impute order does not refer to that. Now it is.
whether it is counsel, it is immaterial, whether it is referred or not. When you have given the reply to the said Lokesh Koda, in your notice, it's maybe he is colluding. It is an admission from you. Yes, because this reply notice is given by your client only. Your client only. Now you are arguing that under the garb of an interim order, now he is claiming that. Your counsel, ನೀವು ಸೂಟ್ ಫೈಲ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆನೆ ನೀವೇ ಕೊಟ್ಟಿದ್ದೀರಿ ರಿಪ್ಲೈ ನೋಟಿಸ್ ಟು ಒನ್ ಎಂತದ್ದು ಲೋಕೇಶ್ ಗೌಡ, ಹೌದಾ? ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದಿರಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 7 ಅಲ್ಲಿ? He is in possession in a penthouse and he is not paying any rent and anything and he is under lease ಅಂತೆಲ್ಲ ನೀವು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ. Now how you can seek a relief before the trial court saying that he was not in possession, I am in possession? This very notice takes out your case. What you have argued for hours.
It is not on the basis of that, can you see? Not on the basis of that. Now, even in the written statement, it doesn't produce that.
That's all your argument. That's all your argument. Reply.
Reply.
The trial court relied on other documents to show that I am in possession, and also relies on an objection filed by him against this person on me. Even I filed by me.
That is order 39 rule 2A.
Where he
That has been considered. It's not it's not an admission. After taking 2 crores, he is not even in possession. None of the documents show that he is in possession. Here recital, which is not a foundation.
Whatever it may be, counsel, you may be paid the amount of rupees 2 crores to him. But your own notice.
What is not?
What is the relief you have sought in the suit before the trial court? What is the relief you have sought before the trial? Only permanent injunction suit.
All of the.
Now then how, once you have issued the notice against him that he is in occupation of the penthouse property,
The title of my.
not the title, is a suit for bare injunction. You can evict him only due process of law. That's what the trial court observed in the order. That's why my one direct question is, do you admit that notice or not? You have issued that notice?
I'm the slave of the contents of the notice. I cannot do anything.
That's all.
That I
That's
cannot
all.
wriggle out of that. That's different, my lord. But the documents show otherwise.
When you have admitted that he is in possession of the property prior to filing of the suit, how you can seek for a relief of permanent injunction? You have not approached the court with clean hand.
It is not between me and the plaintiff.
Not the question of explanation, counsel. It is a clear admission on the part of you while giving reply that Shiva Prasad is in occupation of the premises of penthouse. How you can file a suit against him for permanent injunction? Maybe notices are exchanged between your client and that Lokesh Gowda. But
1943, before the modification, he doesn't claim, my lord. It is not his case.
whether he claims or not, that is secondary, counsel. When there is an admission on the part of you.
I respect.
The very one document takes out your case. So you should approach the court with clean hand, not by playing fraud with the court.
It is not that.
I thought that while you are referring the order passed by the trial court that something is fishy in the matter. But now I comes to know about this. The counsel. I thought that trial court has committed a mistake in giving in all directions. Once you admit that he has been in possession, how you can cut the electricity and all everything? That's all. Hard result. ಇಂಥ ಕೇಸ್ಗಳಲ್ಲ ಗಂಟೆ ನಾಲ್ಕು ಗಂಟೆ ಆರ್ಗ್ಯುಮೆಂಟ್. Whatever it may be, you take the relief by ejectment. That's all. Due process of law. That's all. Other suit also. I have reserved. I will go through the matters and I will pass orders. That's all. ಹೇಳ್ರಿ ಏನು?
Objection which referred to by the trial judge. Trial judge at paragraph 50 reviewed order. refers to a decision made by an element in his objections to IA that I am in possession of this property. That is there in paragraph 15, I am producing
That
that.
is, your worship, can you see, he enters upon the property during the pendency.
That is his contention is under the garb of. I objection statement paragraph number which.
Like, otherwise, your worship, I mean,
Hmm.
in that, he ordered that denied root new application came back. At that point of time, he already entered upon the property. I said he is in possession. That's all. During the pendency of the he came into possession. Not even on 19th word, he was not in possession.
Paragraph page 5, paragraph 2.
Ah.
Is somewhere in the middle, this plaintiff with great respect, also law abiding citizen, had applied to the order of the
Applied
court and provided basic amenities and never interfered with possession and enjoyment of penthouse, but defendant is using the property, started interfering with the day-to-day affairs and also started threatening the work with direct consequences, become impossible to case, etc.
That is the obliging the order of this honorable court antiде. That cannot be taken as an admission.
If indeed it was this contention, that I came into possession pursuant to this, not stated in this affidavit at all.
So in 19th,
Conduct of this party.
the very complaint filed by him on 19th for 2000, I have asked on the certificate copy of that. 19th for 2023, he was not in possession. Now, how can my, his admission can be overridden by the recycled content in the notice? How I can, be.
Yes, that's a told.
19th for 2023 on the last occasion.
Heard reserved. Enough I heard. Other day 1.5 hour. Today is also 1.5 hour. One miscellaneous appeal.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೇವಿಯೇಟ್ ಹಾಕಿದ್ದಾರೆ ಸರ್, ರಿಟರ್ನ್ ಆಗಿದೆ, ವಕಾಲತ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ.
ಯಾರು
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿರೋದು ಕೇವಿಯೇಟ್.
ಯಾವ ಇದ್ರಲ್ಲ ಏನಿದೆ ಮನ್ ಯುವರ್ ಕೇವಿಯೇಟ್ ವಾಸ್ ರಿಟರ್ನ್ಡ್. ಹ್ಯಾವ್ ಯು ಫೈಲ್ಡ್ ವಕಾಲತ್? ಎಲ್ಲಿದ್ದಾರೆ ಯುವರ್ 36.1 both
MFA ಹಾಕಿದ ಮೇಲೆ ಕೇವಿಯೇಟ್ ಹಾಕಿದ್ದಾರೆ ಸರ್. MFA ಹಾಕಿದ್ಮೇಲೆ
MFA ಹಾಕಿದ್ಮೇಲೆ ಕೇವಿಯೇಟ್ ಹಾಕಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ರಿಟರ್ನ್
Have you filed ವಕಾಲತ್ or not? You file it wakalat. Earlier caveat was returned with office objection on the ground that after filing of MFA you have filed the caveat.
I have filed.
Huh?
I have filed.
ಯಾವಾಗ ಹಾಕಿದಾರೆ ನೋಡ್ರಿ. What's your good name?
Jacob Alexander.
Jacob Alexander. No such name is shown in the cause list also. ತೋರಿಸಿಲ್ವಾ? ಆಯ್ತು. ವೆದರ್ ವಕಾಲತ್ ಇದೆಯಾ ಇಲ್ಲ ನೋಡಿ ಅಷ್ಟೇ. ವಕಾಲತ್ ಇದೆಯಾ? ಆಯ್ತು, ಸ್ವಲ್ಪ ನೀವು ಇದ್ರಲ್ಲಿ ನೋಟ್ ಹಾಕುವಾಗ ಬರ್ದಿರಿ ಹೆಸರು ಯಾರ್ದು ವಕಾಲತ್ ಇದೆ ಅಂತ. ಆಯ್ತು, ದೊಡ್ಡ ಸ್ವಲ್ಪ. ನೆಕ್ಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರೈಸ್ ಆಗಲ್ರಿ. ನೋಡಿ, ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. ನೋಡ್ ಇದು ಹಾಕ್ಬಿಡಿ. 4th week ಹಾಕಿ, ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ನೋಡ್. 4th week of ಫೆಬ್ರವರಿ. ಫೆಬ್ರವರಿ 4th week of ಫೆಬ್ರವರಿ. 4th week of ಫೆಬ್ರವರಿ. ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆದ್ರೆ ನಾನು ಬೇರೆ ಜಡ್ಜ್ಗಳಿಗೆ ಕೊಡೋದಿಲ್ಲ ಜಾಸ್ತಿ. ಇದ್ರ ಆಮೇಲೆ ಅವ್ರು ಬಂದು ಏನ್ ಇಷ್ಟೊಂದು ಪೋಸ್ಟ್ ಮಾಡೋಗವ್ರೆ, ನಾನು ಯಾಕೆ ಬೈಸ್ಕೋಬೇಕು? ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ನೀವು ಆ ವೀಕ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಆ ವೀಕಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಕೋಬಹುದು. ಯಾರ್ಯಾರಿಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆಯೋ ಆ ವಾರದಲ್ಲಿ ಯಾವತ್ತಾರು 5 ದಿವಸದಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೋಬಹುದು. If I continued, I will take up the matter. That's all. 41 ಯಾವುದು? Oh, it is parted. You require 20 minutes. He also require 20 minutes. ನೋಡ್ರಿ ಮೇಡಮ್, ಯಾವಾಗ ಹಾಕ್ತೀರ ನೋಡಿ. ನಾಳೆಗೆ ಹಾಕ್ತೀರಾ? ಜಾಸ್ತಿ ಇದೆ, ಲಿಸ್ಟ್ ಆಗೋಗ್ಬಿಟ್ಟಿದ್ಯಾ? ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಗುರುವಾರ ತಗೊಳ್ಳಿ. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಅಲ್ಲಿ ಮಾಡ್ಬಿಡಿ. ನಿಮ್ಮವರಲ್ಲಿ ಏನೋ ಪೋಸ್ಟೇ ಮಾಡಕ್ಕಿಲ್ಲ. heard the arguments of appellant counsel and also in part the respondent counsel for further arguments of respondents counsel. Correct. ಅಲ್ಲಿ ನಿಂತಿರ್ ನಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಎಲ್ಲಿಗೆ. I can recollect my memory. 22nd. ಏನ್ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆದ್ರೂ ಬರೀ ಪಾಠ ಆಡನೆ ಕೇಳ್ತಾ ಇರ್ಬೇಕಾಗುತ್ತೆ ಏನ್ ಹಂಗಾಗಿದೆ ಅನ್ಸುತ್ತೆ. ಹಾ 42. ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜೆಕ್ಷನ್ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್. ಯಾವಾಗ ಬೇಕು ನಿಮ್ದೇನು ಏನಾಗ್ಬೇಕು ಅದ್ರಲ್ಲಿ 22 ಗಿಂತ 22 20 ಇಲ್ಲ 19 ನೋ ಸಿಟ್ಟಿಂಗ್, ಅದಕ್ಕೋಸ್ಕರ ಕೊಟ್ಟೆ. 20th ಇಸ್ RSA ಡೇ. ನಾವು ನಾಳೆ ಯಾವ್ದು ನನ್ನ ಕೋರ್ಟಲ್ಲಿ ನಾಳೆ ಬಿಸ್ನೆಸ್ ಇಲ್ಲ. ಯಾಕೆ ನನ್ನ ಫೈಲ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ ಮೀ, ಐ ವಿಲ್ ಲೀವ್ ದಿ ಹೈಕೋರ್ಟ್ ಬೈ 5 o'clock. File should be come along with me. I am the first judge coming to High Court in the early morning by 9:15, 9:20. I will not sit after 5 o'clock in the High Court. Every day I dictate one judgment in the early morning by 9:30 to 10:30. ರಿಸರ್ವ್ ಆದವೆಲ್ಲ ಇವೆಲ್ಲ ರಿಸರ್ವ್ ಆದವೆಲ್ಲ ಅದು ಆಗ್ಲೇ ಮಾಡ್ಬೇಕು, ಇದು ಟೈಮ್ ಸಿಗಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ ಮೊದ್ಲು ಇಲ್ಲ. ಪಾಠ ಆದ್ಮೇಲೆ ಆಯ್ತು. ಪಾಠ ಆದ್ಮೇಲೆ ಇಲ್ಲ ಹಿಯರ್ ಆನ್ 22nd you can expect the order within 3 days of my hearing arguments. ಕೌನ್ಸಿಲ್ ಯಾವಾಗ ಬೇಕು ಹೇಳ್ರಿ, ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಕೊಡ್ರಿ. 4th week of February. 43 GS Venkata Subbarao, one IA is rejected. Legal cell. ಯಾರಿಗೆ ಮಾಡಿದೀರಾ ಲೀಗಲ್ ಸೆಲ್ಗೆ? ಲೀಗಲ್ ಸೆಲ್ಗೆ ಯಾರು ಅಡ್ವೊಕೇಟ್ ಯಾರಿದ್ದಾರೆ? BBMP ಯಾರೋ ಇದ್ರು, ಒಬ್ರು ಹೆಸರು ಹೇಳ್ಬಿಡಿ. BBMP ಯಾರೋ ಅಪಿಯರ್ ಆಗಂತ ಅಡ್ವೊಕೇಟ್ ಹೆಸರಿದೆ. ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು ಟೇಕ್ ನೋಟಿಸ್. ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ BBMPಗೆ? ಯಾರು? BL ಸಂಜೀವ್ ಅಂತ ತಗೊಳ್ಳಿ. ದ ಕೌನ್ಸಿಲ್ಸ್ ಊಟ ಕೊಡ್ರಾಗ ಏನೋ ಅವ್ರಿಗೇನೋ ಹೆಲ್ ಸರಿ ಇಲ್ಲಲ್ಲ, ಬರ್ತಾ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. ಯಾರು? BL ಸಂಜೀವ್ ಅಲ್ಲ. ದ ಕೌನ್ಸಿಲ್ BL ಸಂಜೀವ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್. both respondents 1 and 2. List this matter on urgency ಇದೆಯಾ? ಯಾವಾಗ? 22nd ನೋಡೋಣ, ಟ್ರೈ ಮಾಡೋಣ. 22nd of February. 3 ಜನ ಇದಾರ, ಬೇರೆ ಯಾರು ಇದಾರ? BBMP ಅಂತಲೇ ಆಲ್ BBMP ನಾ? ಆಯ್ತು 1 to 3 ಬಿಡಿ. 1 to 3. ನೆಕ್ಸ್ಟ್ ಪ್ರೇಮ್ ಕುಮಾರ್ AL.
My lords, I appear for the appellant, my lords.
ಯಾವಾಗ? when do you want counsel?
Next week, my lord, some urgency is there.
ಏನ್ ನಾಟ್ ಏಲಿನೇಟ್ ಇದೆ ಕೌನ್ಸಿಲ್? ಏನಾಗಲ್ಲ. 4th week.
ಅಲ್ಲ, not to alienate.
ಹಾ
Not to alienate ಅಂದ್ರೆ the record shows, my lord, it is a financial transaction.
ಆಯ್ತು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ, ನೋಡೋಣ 4th week. ನೆಕ್ಸ್ಟ್ ಅವಿನ್ ತಿಪ್ಪಣ್ಣ ಹನುಮಪ್ಪ. ಏನ್ರಿ ಇದು? ಡಿಸ್ಮಿಸ್ಡ್. ಏನು ಎಕ್ಸ್ಪಾರ್ಟೆ ಇಂಜಂಕ್ಷನ್ ರಿಕಾಲ್ಡ್. ಅರ್ಲಿಯರ್ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ನ ರಿಕಾಲ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರ ಅಯ್ಯೇ. ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಬೇಕಾ? ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ನಾನು ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ಸೆಕೆಂಡ್ ವಾಕ್ ಅಂತ ಕೊಡ್ತೀನಿ. ದ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್. 47 ಎಲ್ಲ ಫರ್ದರ್ ಇದು ಹೊರಡಿನ ಪಾಠ ಯಾವ್ದಾರು ಕೊಡಿ ನೋಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಟಿರಿ, ಇಲ್ಲ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಮುಂದಿನ ವಾರಕ್ಕೆ ಹಾಕೊಳ್ಳೋಣ. 22nd ನೆಕ್ಸ್ಟ್ ಒನ್ ಹೊರಡಿನ ಪಾಠ ಆಯ್ತು. 22nd 49 ಗೀತಾದೇವಿ ಪಪ್ಪಣ್ಣ ಇವೆಲ್ಲ ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲದೆ ಇರೋದ? ಹೇಳಿ. ಇದೆಲ್ಲ ಮಾಡಿದಲ್ಲ ಮೇಡಮ್, ಹರ್ಡಿನ್ ಪಾರ್ಟ್ ಅನ್ನೆಲ್ಲ ಮೇಲ್ಗಡೆ ಹಾಕಿಂತ. ಅದಕ್ಕಿಂತ ಈಗ ಅಡ್ಮಿಷನ್ ಇವೆಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಪಾರ್ಟ್ ಔಟ್ ಆಗಿರೋದು. ಅದ್ ಇಲ್ಲ ನೋಡ್ರಿ, ಹಂಗಿದ್ರೆ ಅಲ್ಲಿ ಮೇಲೆ ಹಾಕಿ. ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ಎಲ್ಲ ಆದ್ರೆ ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಹಾಕಿ ಅಷ್ಟೇ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆದ್ರೆ ಇಲ್ಲ. ಏನಾಗ್ತದೆ ಗೊತ್ತಾ, ಕ್ರಕ್ಸ್ ಆಫ್ ದಿ ಇಶ್ಯೂ ಅಂತಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ಆಕ್ಚುಲಿ MFA ನಲ್ಲಿ ಏನಿರುತ್ತೆ, ಓನ್ಲಿ ಹ್ಯಾವ್ ಟು ಸಿ ದಿ ಪ್ರೈಮಾ ಫೇಸಿ ಕೇಸ್, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಹೇಳ್ಬೇಕು. ಇದೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಎಲ್ಲ ಗಂಟೆ ಗಟ್ಟಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾವು ಹೇಳಕ್ ಅವ್ರು ಕಟ್ ಶಾರ್ಟ್ ಮಾಡಿದ್ರು ಅಂತಾರೆ. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಕಟ್ ಶಾರ್ಟ್ ಮಾಡಕ್ ಇಲ್ಲ ಕಟ್ ಶಾರ್ಟ್ ಮಾಡಿರು ಅಂತಾರೆ, ಅದಕ್ಕೆ ಅವಕಾಶ ಕೊಡೋದು. ಆಯ್ತು 20 ಸೆಕೆಂಡ್ ಹಾಕಿದ್ವಿ. ಇನ್ಯಾವ್ದು ಏನ್ ಮೇಡಮ್ ಎಲ್ಲ ಫೈನಲ್ ಇಯರ್ಗೆ ಯಾವ್ದು ಸ್ಟಾರ್ಟ್ ಆಗ್ತಿಲ್ದ, ಇವೆಲ್ಲ ಓಲ್ಡ್ ಇರೋದೆಲ್ಲ 2011-12 ಎಲ್ಲ ಫಸ್ಟ್ ವೀಕ್ ಮಾರ್ಚ್ ಹಾಕಿ, ಫಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಫಸ್ಟ್ ವೀಕ್, ಎಲ್ಲ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್. ಏನ್ರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದು ಕಮೆಂಟ್ಸ್ ಆಗಿದೆಯಾ ಇಲ್ಲ, ಕಮೆಂಟ್ಸ್ ಆಗಿದೆಯಾ ಯಾವ್ದ್ರಲ್ಲಿ ನೋಡ್ರಿ ಮೇಡಮ್. ನೋಡ್ಬಿಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ನಂಬರ್ 60 MF 5193. ಮಾತಾಡಾದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. ಅಪಲೆಂಟ್ ಅಂತ ಮಾಡಿದ್ವಿ ಅಷ್ಟೇ, ಮಾತಾಡ ಯಾವ್ದು ಆಗಿಲ್ಲ. ನೀವೇ ನೋಡ್ತಾ ಇದ್ರಲ್ಲ ಇವಾಗ, ಎಲ್ಲ ಆಗ್ತದೆ, ಟೈಮ್ ಇರೋದೆಲ್ಲ ಹೇಳಿ. ಅಲ್ಲ ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡಕ್ MFL ಆಗಲ್ಲ, ಓನ್ಲಿ ಪ್ರೈಮಾ ಫೇಸಿ ಕೇಸ್ ಇದೆಯಾ ಇಲ್ವಾ ನೋಡ್ಬೇಕಷ್ಟೇನೆ. ರೀಚ್ ಆಗಲ್ಲ. ಅವ್ರ ಖುಷಿಗೆ ಲಿಸ್ಟ್ ಮಾಡ್ರಿ, ಏನಾರು ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಬಂದ್ ಬೆಳಗಿನ ಸಂಜೆ ಅವ್ರಿಗೆ ಕಾಯ್ದ್ಬಿಟ್ಟು ಹೋಗ್ಲಿ, ನಾನೇನ್ ಮಾಡಕ್ಕಲ್ಲ. ಏನ್ ಹೇಳಿ, ಏನಾಯ್ತು? ಯಾವ ವರ್ಷದ ಅಪೀಲ್ ಹೇಳಿ? 2014. ಆಯ್ತು 23rd ಹಾಕಿರಿ, ಏನಾರು ಇದ್ರೆ ಟೈಮ್ ಇದ್ರೆ ನೋಡೋಣ, ಇಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ನಿಮ್ಗೆ ಆಫ್ಟರ್ 14th ಕೊಡೋದು ಮಾರ್ಚ್. ಅವ್ರು ಕೊಟ್ಟು ಹೇಳಿದ್ನಲ್ಲ 23ಕ್ಕೆ ಹಾಕಿ, ಅವ್ರಿಗೆ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಫಸ್ಟ್ ವೀಕ್ ಮಾರ್ಚ್ ಫಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬಿಡೋಣ. ಹಾಕಿರಿ 23rd, ಆಮೇಲೆ ನೋಡಿ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಬಂದು ನೋಡ್ಕೊಂಡು ಹೋಗ್ಲಿ. ಮಧ್ಯಾಹ್ನ ಹೋಗಿ ಒಂದು ಕ್ಯಾಂಟೀನ್ಗೆ ಹೋಗಿ ಮಸಾಲೆ ದೋಸೆ ತಿಂದು ಈ ಕಡೆ ಬಂದು ಆಮೇಲೆ ಟೈಮ್ ಇದೆಯಾ ಅಂತ ನೋಡ್ಕೊಂಡು ಹೋಗಿ.